since 2012, and I will ascend to, I've been elected, I'll ascend to president next September. I am also, I do a lot of volunteer work. I also am an associate member of the American Academy of Forensic Sciences, AAFS, and I just recently finished my term as an associate editor for Forensic Science International Digital Investigations, which is a peer-reviewed journal in the academic space of digital forensics. And I'm still a reviewer, but I stepped down from my duties as an associate editor.
Bringing me to my next question, what, if any, sort of articles or publications have you published in relation to?
Great question. I've published a paper on the standardization of data recovery. I worked on that with Dr. Owen Casey and Dr. Nelson. That was published in Forensic Science International Digital Investigations Journal. I also was the second author on a paper related to the use of AI in digital forensics, artificial intelligence, and I've published numerous articles, blogs, white papers. I probably have published about 20 of those, but just speaking to the peer review work, there's 2.
When you say peer review, can you explain to the jury a little bit about what that means or what that process entails?
Absolutely. So a peer-reviewed work is when you have a novel piece of research that you then submit that novel, never been presented work to a journal. It then gets reviewed by numerous academic peers. It goes through cycles of revision where they ask more questions. On the standardization of file recovery paper, that process took about 14 months for it to be peer-reviewed by experts in the field, and then it is published in a journal.
And so you've had both articles that you've authored that have been peer-reviewed and published, as well as you've performed the role of reviewer of other people's work?
Correct. I performed in addition to the publications I've done, I reviewed at least 20 to 30 articles, both in a combination of support for Forensic Science International Digital Investigations Journal and DFIR review.
Now, Ms. Hyde, if you could explain to the jury, when you say the term as far as digital forensics, what do you understand that term to mean with relation to what you do?
I would describe digital forensics as the analysis of data from any storage medium that can control data, be that a mobile phone, computer, or cloud, for the intention of that data intentionally being used for court.
And with reference to your firm, Hexordia, where is that located? What state?
We are headquartered in New York State, in Bridgeport, New York, which is outside of Syracuse, location in the DC metro area in Tyson's Corner, but we have employees in 6 states.
And with respect to your duties and responsibilities in regard to your firm, what is it that you do?
Great question. So I do perform digital forensic analysis on cases. I currently work on 2 U.S. government contracts supporting 1 digital forensic analysis and 2 novel research and exploitation of mobile devices. So I'm named personnel on 2 contracts, and then I manage another 3. I also develop training for mobile forensics. My courses have been taken by people all over the country, and Hexordia also delivers that training. I also do research and presentations for journals, conferences, etc. So a combination of casework, education, and research.
Now, Ms. Hyde, if I could turn your attention to May of 2023. At some point during that month, were you contacted by the Norfolk District Attorney's Office in relation to this case?
Yes, on May 4th, I was contacted by Detective Tully via our website about this case.
And eventually, was there a contract that was executed and you agreed to do some work in relation to one specific area of this case?
Yes, contract was executed on May 9th and work began on May 10th. Of 2023.
And as far as the specific information in relation to this case, what was it that you looked at? I'm sorry. Let me start by saying, what was it that you were asked to look at?
I was asked to look at 2 specific Google search terms that took place on January 29th.
And with regard to the information that was provided, and we'll get to that in a moment, but with respect to the question that was asked, was it a question that was posed, or were you asked to find some sort of specific response?
I was asked to look at the timelines and timestamps related to those Google searches.
Now, with regard to what, if anything, was then provided to you, or what, if anything, did you review in the course of your analysis?
I received 2 reports. I received the affidavit from Richard Green, and I received the report from Trooper, I don't want to butcher his name, but something along the lines of Nicholas Garino.
Perfect.
Oh, good.
And is it your understanding that Mr. Green was a person that was retained by the defense in this case?
Yes, I was aware of that.
So you essentially received reports from the state police and a witness for the defense, correct?
That is correct.
In addition to those 2 reports, what, if anything else, did you receive in relation to your analysis?
On May 10th, I received via U.S. Postal Mail a copy of the drive with data from a phone that was identified to me as belonging to Jennifer McCabe. It was a full file system extraction from a gray key.
And so when you received that information, what, if anything, did you do with it?
The first thing I did with that data set after having been retained was I made a forensic copy. I used an ArcPoint Atrio to copy the data from that original disk, which was then placed in our safe, to our working copy drive.
And that ArcPoint Atrio, what is that?
It's a forensics tool that does extraction and duplication.
And then once that process was completed, what did you do from there?
I immediately verified the hash values of my new image to make sure that it matched the hash value of the original image.
And what is the hash value?
A hash value is an algorithmic numerical representation of the data. So when you have a hash value, that value is unique to a certain set of data. So when you have that same hash value matching, you're ensuring that your copy that you made was correct and not in any way damaged or corrupt.
And as far as matching those hash values, were you able to do so?
Yes, the hash values of both the copy I made to work from and the original matched. They also matched the document that came along with the drive stating the original hash value.
And then what did you do from there?
From there, I processed the image in several forensics tools. I used Celebrite Physical Analyzer. I used Magnet Axiom. I used a tool called ARTX, A-R-T-E-X. I utilized a tool called iLeap, and I later used a tool called Sanderson Forensics SQLite, but I did not use that tool at this point.
Now, with reference to the tools that you used, that you just went through, are those fairly common tools, or are those tools that are commonly used within your industry? Yes,
they are commonly used digital forensics tools that are very standard for other forensics examiners to use on mobile exploitation.
And as far as those different types of tools, so I guess my question is, there were a variety of different tools that you used.
Correct.
And why were you using the different tools?
So different forensics tools have different capabilities and look at data a little bit differently. Phones have thousands of applications. If you look at the Apple Store or the Google Play Store, you can download a total of 6 million apps between the two. Commercial forensics tools, they can only support so many applications, so they each work and support different bits of data, so it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis.
And with respect to using those sort of different variety of tools from Celebrite to Axiom to ARTX, et cetera, is that something that you typically do as far as your normal process of conducting a forensic analysis? Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensics tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to do that. I would run some of those tools before others because of speed, and so I can begin analysis while other tools are running. If I could ask you just about the last one that you mentioned, just briefly, as far as the Sanderson tool.
Yes.
Can you explain to the jury sort of what that is and how that interplays with the other tools and analysis?
The Sanderson tool is meant to look at a specific type of data structure called a SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensics tools allow.
And just for the record, when you use that term as far as the SQLite database, how is that spelled?
It is capital SQL, lowercase ite, and SQLite is also commonly pronounced as SQLite, so both pronunciations are acceptable.
Now, once you received the extraction, made the copy, and then ran it through of those variety of tools, what is it that you specifically were looking at, and what is it that you were trying to ascertain, or the question that you were trying to answer?
So in looking at that analysis, I was focused specifically on the data that took place on January 29th. So the first thing I did was I limited my search within those tools to that period, and I looked at the artifacts that they were parsing pertaining to Safari history, as Safari was the browser that had been in use at that time.
Now, in addition to looking at those search, what, if any, information were you looking at in relation to deletion?
I'm sorry, I could not hear you.
In addition to looking at those materials as far as those searches were concerned, what, if anything else, were you looking at regarding that data with respect to deletion?
I didn't hear the last word. With respect to?
Deletion.
Deletion. I apologize. Thank you. Yeah, so one of the things that was asked, one of the things that was actually in the affidavit from Richard Green was that it was stated that there was belief that one of the search terms had been deleted. So I was specifically looking at that search term to see if what the reason was for the suspicion of deletion. There is... the tools denote things based on how they are running as an automatic process. The tools are designed to parse through large amounts of data to make it easier. So the tools will often flag certain data as recovered, and sometimes there is confusion between what recovery and deletion means. That actually was the subject of the paper I referenced earlier that I co-authored. And the tools are sometimes misinterpreted that that statement of recovery means deletion. So I was exploring that.
Oh, so just joining us, this is a
now,
expert
you mentioned specifically there were two searches of interest that you were exploring. Is that correct?
That is correct.
And what were those two searches, and what, if any, information do you have in relation to those?
I had the information from the two reports that had been written in terms of what they found. And the two search terms, one was HOS, H-O-S, long to die in cold, and the other one was how long T-I, die in C-L-K-D.
And what, if any, information from your, starting, if you could, sort of walk the jury through as far as your analysis, what you first observed, and what your analysis consisted of as it evolved.
Absolutely. So when I first looked at it, some of the tools surfaced the data from a specific storage called the, I'll just make sure I get the entire path for you, com.apple.mobile Safari plist. It is very common in mobile devices for it to look like a reverse domain name. Like you normally would go to a site like CNN.com. Typically, those names are like the opposite. So com.apple is going to be representative of a native Apple application. So this particular plist was related to that. A plist is, or called a property list, is a data structure that's unique to Apple devices. And there is data pertaining to Google search, not just Google searches, search history that's stored there. There's also, I found evidence of the search terms in Knowledge CDB. The Knowledge C database is an Apple database that is meant to store information about users so it can determine future functionality, what you're looking for, etc. So that's the Knowledge CDB. It's more of a system level artifact. And then there was also, and these were the observed search terms, and most of the tools picked up both of those search terms in there. Not all tools did pick up the one that was from the wall, which was the instance of Haslong to die in cold. That's how I'm pronouncing the HOS. If you would like me to clarify it a different way, that's fine. That particular search term was recovered from a SQLite database, the one I later explored, and Celebrite specifically demonstrated and showed that particular search term as a suspended state tab, and that's a really intricate artifact whenever we're ready to explore that. That is the one that was marked as recovered. So those were my initial findings, just looking at what the automated tools parsed. However, Celebrite was the tool that found that particular search term.
Cool.
We've got
Now,
Kingdom
you
List.
used a term in there as far as a wall or a write-ahead log file. Is that correct?
That is correct.
Can you please explain to the jury what your understanding of that term is based on your training experience?
Absolutely. This is a really interesting data structure, the way it works. So the way SQLite databases work is the data before being committed to the database, which is almost like an Excel spreadsheet if you think about that. Each table is like a page on an Excel spreadsheet. The data before going there goes kind of to almost like a text file, like if you were to have a doc of writing all the changes that need to happen to that Excel spreadsheet. And they're not made to that spreadsheet until it closes. So what happens is as you're doing things, either adding a website by searching for it, or closing a tab or deleting a text message in a SQLite database in general, both things you add are written to that text document or things you delete. So they all hang out there together. So it's any changes that are going to be made since you started using that application until it's closed. Then they change there and then it reopens. So to make an analogy, if you're in a restaurant and you order some food, the food being the data and you at the table being the table that the data is going to, when you request that data and you say, I'm adding it, it goes to the area where the waiter or waitress or server is going to grab it from, right? That warming station. That is almost like our write-ahead log. And so different tables are ordering food and food is constantly being put there. If somebody, maybe their steak came out rare and it needs to be cooked more, when they send it back, it'll also go to that warming area. So you can see there that you've got things waiting to go out to the tables and things being sent back to the kitchen. So simultaneously, that storage area contains both the newest stuff waiting to go out and the stuff coming back. And that's really what a wall file winds up containing: your newest Google searches, your newest text messages, etc., as well as anything that you've been deleted, that you've said was deleted, because the reference in there is going to be delete this entry. And so then all of those don't happen until the application is closed and reopened. If the application's been closed, when we do the extraction, we actually don't get the wall file. We only get the wall file if at the time of extraction that database had not been closed. So that just means that Safari in this instance was still running when the extraction was done. Most of you, when you use your phones, you leave the applications up. So because of that, we have a wall file, and so that wall file is going to contain both a data that's been requested to be deleted and new data. Now, when I say deleted in this instance, I don't mean like you as a user saying delete this old text message. What I mean when I say deleted in this instance is removed from the database. So when we're talking about something like a Safari tab, deletion from the database can occur because you closed the tab. We all open tabs when we use our browsers on our phone, and we all close them. And so closing in that instance would be a deletion in the database, but what that's doing is not a user requesting deletion. So I just want to be clear on that term.
And to that point, as far as, so when you say something has been deleted, specifically with reference to the write-ahead log or the wall file, that's not something that's necessarily initiated by the user themselves, correct?
Sounds like a bunch of bullshit to me, Joe.
Conception, yes.
Your Honor, just in regard to a side issue, may we approach just briefly?
Sure.
Is this a different angle that we're seeing now?
Yeah, it looks like they've gone to the type of angle you'd have when we had COVID. People were testifying remotely to prevent the jurors from being recorded. It's not a flattering angle, I'll say. And the watching this morning, I didn't realize it, but I saw the juror come in. I didn't realize the jurors come in that same door where you see the officer in the white shirt. That must be the only way in the courtroom. They don't have a separate doorway for jurors. Because I saw the juror walk in a pink or a red blouse on, walk past, and then all of a sudden the feed died and all hell broke loose.
Yeah, normally you would think that a courtroom would have a separate jury entrance into the pew section there to avoid that.
They typically do. They usually have a route to bring them in and out. They have their own area that they go to, so that they're isolated from everyone else as they should be sequestered, so to speak. But evidently, this has some issues.
Morning, Kingdom.
Now, Ms. Hyde, you had used the term earlier in your testimony regarding something within your field called an artifact. Is that correct?
That's correct.
And can you explain to the jury what you understand that term to mean?
An artifact is any trace that's left behind by any action on a digital piece of data.
And can you give the jury an example of sort of what an artifact might be or what an artifact might look like?
Absolutely. So an artifact of you sending a text message would be that we would find the database where text messages are stored, and inside that database we would see the time and date that you sent it, who received and who it was sent to. It might not be their name, it might be a numerical representation that we have to tie to another database. Then we would have the message itself. It may be in plain text or it may be encrypted or encoded. And then we may have something called a blob, and that would be a reference to data that's too large to store in the database, so it would be elsewhere. So that would be if your text message included, let's say, a picture or a video.
Now, in regard to your analysis and your ultimate conclusions, in this case, you wrote a report, is that correct?
That is correct.
And within that report, there are a couple of tables and a specific figure, is that correct?
That is correct.
Your Honor, with the court's permission, if I could,
She
I'd like
seems
to
confident,
publish to
Kingdom.
the jury table 1 from Ms. Hyde's report.
Okay.
Yeah, I'm not sure what Kingdom's going to do if the state's able to put to bed that.
Ms. Hyde, do you have a copy of your report with you as well?
I do.
Testimony.
Your Honor, with the court's permission, just because I fear it may be a little difficult to see from where she's seated, if she could refer to the table in her
Sure.
report.
Thank you.
Ms. Hyde, what's up on the screen, and I'm sorry, there should be a laser pointer on the desk before you. Do you see that?
I do. Oh, yes.
So using that laser pointer, if you could draw the jury's attention, or direct the jury's attention, I should say, with respect to what are we looking at in this specific case?
Absolutely. So this table here has a couple of different elements that I'm showing in terms of what searches were searched where, and when, and what source of data they came from. So if we look at this first search, I have them in the timestamp order that is associated with the artifact. I want to clarify that we need to discuss the meanings of these timestamps as we go. So this first one that you're going to see is, and I'm just going to reference my paper because of the size, is 0227 and 40 a.m. So that's 2 o'clock in the morning, 27 minutes and 40 seconds. And it is a search for the term
I ain't believing none of this,
long
Joe.
to die in cold. And that is timestamp in this instance is from the browser state DB, which is right here. The browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that that tab moved. It could be lots of things. It could be you switch tabs. It could be you close the tab. It could be you minimize the application. Depending on the version of iOS, what can be that browser state of the tab that changes this timestamp differs. But what's very special to know about this timestamp is that that is not the time necessarily of the search. If a browser is opened and a single search is made, those will match. However, as long as that browser hasn't been closed, moved to the background, etc. If that browser has had any activity that happens to that tab in terms of application closing, minimizing, this can update. That is what that timestamp is for. This search term is always going to be the most recent search term in that tab. That means the last item that was opened in that tab was HOS long TI die and cold. We cannot tell by this particular artifact what time that search occurred. It is a high likelihood that that tab was opened at this time because there was another search that occurred at 2:27 in the morning. It was a sports site. I cannot pronounce it. It began with an H. Hockomock Sports. Hockomock. Okay, thank you very much for the pronunciation. Hockomock Sports. There were a couple of searches pertaining to that done immediately after, but it appears that that's when this tab was opened and the first search done there. So this search, we know was done by this, and we know that it was the last search in the tab because it comes from this source, the browser state DB. And that means that particular timestamp and search pertains to what has happened with the tab. And that's what allows you to open your Safari browser on your iPhone and then open it on your iPad or your Mac and have the same tab. That's the function there. This search here, this is really interesting. So at 6:22:49 a.m., we have an entry in CacheDB that is specifically, if we dig into this URL, this is an Apple suggested term. So when you use a browser and you start to type a search you've never typed before, the browser tries to help you and say, are you searching for this? So as the user began to type the phrase in the immediate search after, which is how long TI to die in CKLD, this particular suggestion came up, indicating in all likeliness that the search term being typed had not previously been searched, because Apple suggested, instead of a previous search, it suggested how long does it take to digest food. After how long to digest food had been suggested, the user then has a search at that time, 6:23:51, for how long TI die and cold, and that is coming from the mobile Safari plist, the com.apple.mobile Safari plist I mentioned earlier, and the search is also shown in the knowledge CDB. That's commonly what we would expect. We would expect that search to be in both of those, both that plist and that database. Then the... Can I stop you? Yeah, absolutely.
As far as the expectation...
Please, somebody stop
that
her.
being in both of those,
because
the
unless you
plist and the other
click on that
database,
search,
why is
it's
that?
not going to save a cookie.
That is because the search is not being tracked not only by the plist for Safari, but also by the system itself to be able to do that predictive coding. So in the future, when you start to type how long, it gives you what you searched last time.
And with respect to that, how long it takes to digest food? Based on your analysis, was that a search term that was ever entered into this phone?
Correct. The source of that, if you look at this first line where it says cdn2smooth.apple.com, that's what indicates that this is an Apple suggested term, not a user input term.
I'm sorry, I interrupted you. If you could please continue with the next.
Absolutely. The next search that was done immediately after the search at 6:23, the next search was how long TI die in CLKD. Again, we see that search both in the Knowledge CDB and the mobile Safari plist. And then we have, so we see it in both databases. Then, so that's how long to die in cold. Sorry, I was on the next line. Then at 6:24, we get the next search, which is HOS long to die in cold. And we have that search again, both in the Knowledge CDB and the plist. If I were timelining this based on activity as opposed to timestamps associated, what I see here is the beginning of a user typing a search, Apple making a suggestion of how long to digest food. The user does not take that suggestion and rather inputs how long TI die in CKLD. They then make a second search of HOS long to die in cold. That search winds up being the last search in the tab, and that is why we see it in the this particular browser state DB. It should be noted that this is in one of those WAL files and not the raw file.
And so as far as sort of towards the top there.
Joe, is anyone believing this bullshit? This is desperate, dude.
But as far as that reading of 227
I'm not believing it at all.
In the morning, as far as the timestamp associated with the search.
Like I said,
I'm trying to process exactly what she's saying.
Later on in the morning.
Because that table isn't showing the time of that search, it's showing the state of the database. So it's saying that the last time that tab was touched, moved to the background or foreground, was 2:27 a.m. The website, as you search more websites in the tab, that gets updated. So the current state that this is showing is that the tab was moved to the background or opened or some action for the tab at 2:27 a.m. when the Hawkmock Sports, I got it right, Hawkmock Sports website was visited. And then once the Hawkmock Sports website was visited, that tab was in continual use. There are other searches and activity that happens. We don't see that happens eventually. This search gets made at 6:23 a.m., this search at 6:24 a.m. That winds up being the last search in the tab. And because it's the last search in the tab, that's what the final update is and the final status.
So when you say last search in the tab in reference to time,
what she's saying is that open the tab and one
sorry, I don't understand the question.
and the next search comes.
So as far
they didn't
as
open up another tab, that same tab, and retype the search into it,
closed, and then another search done at 6:23. Is that correct?
Was the last
2:27 isn't necessarily when the tab was closed. That's in my report. I say that it's undetermined because there's a lot of things that can cause that time stamp to be there,
under the impression that
including tab being moved, tab being minimized. I don't know exactly what caused the tab to get that particular entry, but it is not, that timestamp is not indicative of the time of the search or any URL that's visited there. That time is indicative of movement of the tab, and the search is the most recent search. So they update at different times.
So I guess my question is, as far as from what your analysis is here, is there any use of that tab between, or is there any evidence or artifact of use of that tab between the 227 timestamp and the 623 timestamp?
So the fact that that timestamp exists at 227, combined with the fact that the only existence of this search is at 624, means that yes, that particular tab was used after 227 when the Hawkmock Sports was searched. I apologize for not being familiar with that name.
Oh, that's absolutely fine, man. Now, if I could ask you at this point, you had talked about one in particular
Dante is
database
running the kingdom flag
having
all
sort
over
of an
the
intricate
world,
artifact.
apples
If you could remind the jury what that is, and if you could explain that.
Connections to approved census.
So the artifact that needed a little bit more explanation and digging was this browser state tab. And that's because if you look at the end of this file name, you'll see it's a db-wall. That means it wasn't in the regular database. It was in the write-ahead log. And to Celebrate's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. If you remember before, we talked about write-ahead logs, and we talked about the fact that they can contain data that is both removed from a database and data that's not yet to be committed. And this database, we do not know which that is, but what I did was I manually went through, and that's in the figure, I manually went through and reconstructed the WAL files using the Sanderson SQLite tool. And in reconstructing the WAL files, I found many. I'll tell you exactly how many if I can refer to my notes.
Sure.
Refer to my notes. 1, 2, 3, 4, 5.
Hey, Big Ron, just
approximately
while you're
16 instances of that existing in the wall file. Now, what's
What's that, Joe?
interesting in that figure is
The
that
volumes are a little low.
each entry of something in a write-ahead log gets a unique identifier. So it gets a number, right, that makes it unique. Just like each one of us has a phone number that's unique to us, each entry in the database that starts in the write-ahead log gets its own unique identifier. And that unique identifier in this instance in all 16 entries in the wall file is the same, which shows that it's truly only one search, not multiple searches for that search term in terms of what exists in the wall file. So that's the first piece of nuance there, that it only truly was searched one. And you would have to really dig into that wall file to expose that, but I think it was pertinent to know how many times this was searched.
I'm sorry.
Yes, please.
Stop you there for one moment. And Your Honor, with the court's permission, if I could ask Ms. Gilman to publish table 2 now.
Okay. Oh, wonderful.
Dante says the trial is doing its best.
May I look at table 2? Sure. Thank you, Your Honor.
To driving at what is
Ms. Hyde, do you recognize what's up on the screen?
I do. That is table 2 of my report on page 4.
And if you could, again, using the latest form that you have before you, direct the jury's attention to what, if anything, is significant to
she's making a case that how
So
strong
table 2 here is designed to share with us
not
what each of the locations that can potentially have Safari data, what kind of data they hold. And one of the things that many of us are interested in sometimes is, do these things hold our private searches, like if we're in incognito mode in Google or private searching here. So this table denotes if we're seeing private or non-private searches, if it includes tabs that are open or closed, so that we know which artifacts are giving us what kind of information, as well as what some of the associated timestamps mean. So this was designed as a guide to really understand table 1 more in depth. So this first one here, this refers to the history DB wall file. And that file has non-private searches. It includes closed tabs. And the visit time there is the time that a user reopened the tab. We don't always have the artifacts we want. And in this instance, we did not have that particular one. Then we have the Safari Tabs DB. This has private tabs and non-private tabs. And it shows only tabs that have not been closed. So this is an active tabs database. The next one we have is the Browser State DB and its wall file. And this is the one we were referencing where that we keep talking about, where that 2:27 a.m. number is coming from. So this one is going to be non-private searches. It includes closed tabs, which is important, and the last view time. So when an item went to the background. So it's about the tab, not about the search. That's probably the most important demarcation. And one of the issues here is when the tools parse the data, they call the columns what the columns are called raw in the data. Those don't necessarily tell us what they mean. We have to verify and validate what they actually mean. So when I'm saying last underscore view time, that's what the database name is, not necessarily the actual function, or not what we would presume it to mean. The next one, the last one here, is the mobile Safari plist, and this one actually tells us, the date here gives us the time that something was queried reliably.
Now, if I could ask you, if you could just explain to the jury as far as these SQ or SQLite databases, how exactly do they work, and what, if any, relation do they have with regard to data and information with the write-ahead log of the wall file?
Wow.
So SQLite databases work and function as a storage for anything that the phone may need to reference later or that you're doing. They're stored for a variety of things. Most of your third-party apps use SQLite databases, and multiple applications do. So SQLite gets information in, and it allows for that information to be updated, added to, or removed from. So data that's in that situation, that it's sitting in the database, that is what we refer to as live data. Then data that is waiting to be put into the database, that is sitting in the wall, or has been requested to be removed, that is what's in the write-ahead log, and we call that non-live data because it's not in the active database. So when you're using an application, and it's putting that data to that temporary storage area, that wall, that write-ahead log, what happens is then when you request data by going into your contacts, let's say, and looking at the people who are stored in your contacts, right? Your mom, your dad, your brother, your sister, all those people. When you're looking, your best friend, you're looking up their numbers, that data is all stored in that database. So when you add someone, it does that entry to the wall. Now, so if I just added Sally, how do I know that Sally's in there, right? Well, what happens is the interpretation of the SQLite database goes to the wall, checks and sees if it's in the wall, and uses the wall to incorporate it together to present you everything as if it's in there. Then when you close the application, you close contacts. You don't just put it away like go switch apps. You actually close it. When it closes, all of those changes get committed. So now the items that you've requested to be deleted, that contact you don't like anymore, that X, whatever, their data is no longer in there. The data that you've added is now in there, and now that's all live. Sometimes we can get more complex and recover some of those items that are left over because they are marked for deletion but still sit in the database, or they're sitting on a page that is no longer active in the database. So there's a lot of places that we can recover data from in addition to the wall that exists in the database after something has happened, but that isn't pertinent to this particular use case.
All right. What she's saying is,
Now,
if it's not on the
as
wall,
far as,
it didn't happen
that sort
at
of
all.
interplay, between
what we
the
learned.
SQLite database and the wall, what if any sort of, as a
If it doesn't
forensic,
fit, we must acquit.
examiner, what if any sort of complexities arise out of it?
Oh, one of the biggest complexities is the assumption that because data exists in the write-ahead log, that a user took an action to delete it. When I teach at the university, when I peer review my colleagues' reports, this is one of the most common mistakes I see. And it's really because some of the forensics tools to indicate that the file has been recovered, they put a big X on it. And that was actually a big subject of that standardization of file recovery paper I referenced earlier. And it speaks about all kinds of files, but actually has a special section on SQLite, specifically because that nuance is often missed by examiners.
Now, in reference to that being
We're going to see what happens in
marked as deleted or misinterpreted as deleted by user, is there a specific tool of the tools that you mentioned before, as far as Celebrite versus Axiom versus that has that information that others may not?
So Celebrite and Magnet Axiom, both Celebrite Physical Analyzer and Magnet Axiom, both have file system viewers that then have SQLite database viewers. I would say that those SQLite database viewers have more of a basic function in terms of looking at data in the live database. They don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite.
And so when you see something like that in a Celebrite extraction, is there, what if any further analysis do you do to sort of look behind it?
Absolutely. Anytime I see an entry marked as recovered, and I'll use the term recovered instead of deleted, by Celebrite, and the source is a write-ahead log, I would go and begin reconstruction of the write-ahead logs using Sanderson's forensics tool to get to the meat of, is this something that it has been deleted, or is this something that has yet to be written to the database? You can often see remnants of that based on how many unique entries there are of it. What the other thing we do is, so I mentioned that when we have the wall file, it hasn't been applied. So if I take the SQLite database and the wall file out, and I make another copy of them. So I've got one copy I'm looking at Sanderson, and I take another copy and I actually open it. What's cool is it does the commits. So then I have a copy of the database that actually has all those changes. So I now know if the entry was deleted by just comparing the two. So I can do that analysis by basically making the database think it was reopened, by reopening it with a non-forensics tool in that instance, just to see what it would look like in real life. And then I can look at the difference between the two and determine if something was marked for deletion or addition.
Now, are there different reasons from your training, your experience, and your knowledge of these systems? Is there different reasons for why it's your conclusion that that particular search or those search terms were not deleted by the user specifically?
Yeah, well, there's a couple of reasons. First, the way tabs work from a functional perspective, you can close a tab, but there's not really a user deletion function for the tab. And there was no evidence of other deletion, if that makes sense. I also, it doesn't make sense that the term was, I don't see evidence that the term was searched prior to that 624 time. So since the term wasn't searched prior to that 0624 time, the existence of the tab being closed would not mean that that search was deleted, because then it would be evident in the other databases pertaining to the actual search, not the databases pertaining to the state of the tab. Is there a possibility that the tab was closed? Absolutely, but that is not a deletion. Secondly, an existence in the WAL file, as we mentioned, could be that it's something new, not something that was deleted. So just its mere existence in the WAL file doesn't mean it's deleted. I should say that that same X in the tools, you have to check the file because it could be from a free list or a free page, in which case, I know we didn't go into those details, nuance of SQLite databases that actually doesn't pertain to this. However, those would be truly deleted items. So there's other places where we would expect potential recovery, not necessary in this instance. And you can have something that's in a WAL file and deleted without being in those other locations. Just stating that its existence in the WAL file itself doesn't mean deletion, but there are other SQLite things that would clearly indicate deletion that aren't applicable to this particular search.
Now, Your Honor, with the court's permission, if I could ask Ms. Gilman to publish figure 1 from Ms. Hyde's report.
I expect to see some pushback on cross-examination on this, although we could go back to defense pulling off
this is
their own
figure 1. This
expert.
is a direct screen capture from Sanderson's tool from the browser state DB, limited to the Haas long to die in cold search.
If you could, using that laser pointer, again, direct your attention to what, if anything, significant or of note that you observed in using the Sanderson tool that's particularly.
Well, you guys are
Absolutely.
tough.
So all
Tough
of
on
these
this lady.
searches are the exact same term. And here we have the order index.
Kingdom says if you're caught
And
cheating,
here
this
we
chick can
have
talk to
that
your
last
wife for
view
a small
time. And
fee.
by
About
looking
yourself
at
and data.
the last view time, which is the raw title of that artifact for the timestamp we were looking at, these and these are identical. This, and more importantly, are even the actual UUID for these are identical, which is right here. Now the offsets are different, and what that means is that this is just appearing several times in the write-ahead log. It has moved as the database has moved data through the write-ahead log to different positions, but has in every instance the same unique identifier, meaning that all of these entries are the same entry, just shown multiple times in the same database.
And to that point, as far as the multiple times that it's listed within there, what, if any, relationship does that have to how many times it was actually searched by a user?
Well, that UID shows that in this particular instance that it existed once in the last time in the tab, because this artifact, it does not tell us how many times something was searched by the user. This artifact is limited just to the tab. We would look at the mobile Safari plist, which has one entry for this timestamp, or knowledge CDB, which also only has one entry for this search. Those two locations are where we would determine how many times it had been searched, as opposed to this location, which could tell us that if there were multiple entries, but there is only one. But since this is limited to just the last search that's showing in a tab, it isn't a good source to say how many times was it searched, just not this particular artifact.
But from other artifacts, you were able to determine that?
Absolutely. You can determine that from both Mobile Safari plist and Knowledge CDB.
And I'm sorry, I jumped in there just as far as turn your attention back to figure one. What, if anything, else?
There you have it, folks. How long to
That's
die in
really
cold
what's of
search one
significance,
time,
is that
according to
it
the
is
expert.
the same entry there multiple times, and we can tell by the unique identifier that it is the exact same entry also. And it's, although it's the same search term and the same timestamp, it's only one instance of it, just it's stored in the database multiple times at multiple offsets.
Now, from the timestamp associated with that depicted in this figure, what, if anything, can you say as to or what, if anything, were you able to conclude from your analysis as to the time that the website was viewed?
Well, I guess I should really clearly, for people who may not be familiar, that doesn't look like a normal time, right? That's because this is an Apple WebKit timestamp, so we actually convert it to a regular time. But when you look at this number raw, you can actually see that it's consistent throughout, even though you don't know what it is. But if we put it into
weak
a
argument there,
decoder,
Kingdom.
this particular
Handling the
timestamp
fact
is
of
where
how
we're getting
strong to die in
January
the cold is
29th,
the key point of evidence. They
2022 at
refuted it.
02
It has nothing to do with it.
47
We-
a.m.
Someone call it out as
To be
weak
clear,
pain.
just for real clarity, when we actually translate this timestamp, it's in universal time constant,
He's
not
just listening,
in local
Kingdom
time, but
Radio
for the sake
host.
of
This is
conversationalists,
a desperate,
I'm
this
using
beat-up
the
expert
local
in
time
quotes
here
to the stand.
as
It has
opposed to
nothing
the
in tap
time
to
in
do
the
with
universal
Aaron
time
Reed being
constant,
innocent or
which is how
guilty.
this
Now
artifact
it has
is
nothing to do with it.
particularly stored.
Prior, it was a
Now,
hinge
with
point of evidence.
your analysis,
And of course,
is there some kind of
Kingdom Radio
testing that
response
you
with
conduct, or
issuing
can you explain to the jury sort of what that is and how it relates to your analysis here?
Absolutely. So with this artifact and being able to determine what this timestamp really means, I actually did quite a bit of testing, which is fun, but that's okay. So we went ahead and took a jailbroken iPhone, and the purpose of a phone being jailbroken is we're bypassing the security protocol so we can monitor the data and its storage in real time and bring the data through. We did this manually in terms of pulling the data out, and we also did multiple forensic images at different stages. We manipulated tabs, we did some Google searches, and then we would close tabs, move tabs, and perform several different searches that we scripted out first, what we were testing, and then check to see how that timestamp was moving. We even did some really interesting things where we tried.
Sorry, objection.
Yes. Okay.
Dante's showing some frustration. Fine. Okay, lock Reed up. Just stop talking, please. I will go back to say I don't know that this improves the case considerably, but I don't know that how long to die in cold Google search. I'm not sure how much weight that was actually bearing in the case. You still have some issues to get over with law enforcement, namely the Proctor testimony. That's going to be a very difficult spot for the state to overcome. They can't bring in an expert for that to explain how that wasn't said or those text messages weren't sent. And yet, folks, we still have yet to see the defense. We know the defense is keyed on this. We know that they've had another expert use the same Celebrite data to analyze it, and they've come up with something different where they think they can prove that House Long to Die in Cold actually was done at 2:27 a.m. So it's going to be curious to see if the defense takes that on cross or if they will bring that up and open it up in the defense's case when they put that case on. By the way, is that lady sitting down right now? Is she wearing a tiara? Is it her birthday?
I'm sorry. So you had, I think when you were talking about some of the testing that you had conducted, you used the term we.
It's the first time I've seen an attorney wear a
individuals
suit.
that worked on this particular assignment.
I had somebody peer review and test my testing, so they didn't work on the case. But as I was testing,
tell you what, if you know this lady, I would leave my phone laying around
that
her.
I was
Sounds like she
following my
could
test
pick that up
plan.
in
That's just normal
Big
practice
D.
that we use peer review.
So the testing that you were testifying about is testing that you...
I conducted, correct. But I had peer review by my team member on the script I had made to do my testing. So, and I use when I do testing, I'm following the NIST guidelines for
It says she
data
looks
set
like a
generation and
terrorist to me.
testing that's outlined by OSAC, which ironically, I should disclose I'm a
I'm sure the
co-author
jury
on.
will weigh that in their deliberations.
And then, if you could, I'm sorry, Ms. Hyde, just continue as far as your testing.
Absolutely.
Turning your test.
Yeah, so then populated the device and looked at all of the different data that came back from the different states while it was jailbroken. And the changes that happened, what I was saying was interesting is then tied it to a Mac and saw how the browser state changed if we change the browser and the tab on a Mac and how that would affect it. And because we could see the differences, and by we, I mean that I had my testing peer reviewed, because I could see the differences of what the data looked like when I was altering it both in the Mac and on the phone, I was getting differences in those timestamps and those different conditions. So in other words, I could get a timestamp that showed in the browser state DB that was earlier than the current search by a variety of means, including manipulating the tabs, closing them, opening them, switching which one was in proper view forward, as well as looking at that tab on an external device, including a Mac and an iPad on the same account.
Now, throughout the course of your work, I think you alluded to it earlier in your testimony as far as your experience is concerned. You've had occasion to work both as a forensic, forensic extractions.
I'll tell you, it's definitely not a flattering
Yes.
camera angle.
As well as working also in research and development, is that correct?
Correct.
And so from the R&D side, what, if any, role does that play as far as your analysis?
No, this is a
in
horrible,
general
horrible
terms
camera
in your
angle.
analysis here when it came to some of the devices?
Hey, well, this
some of the things
young
that
lady's
the tools
Texas
that you
hate better than
I believe that
LC3.
my experience in research,
guarantee she
development, and reverse engineering
protests
throughout my
pro-Palestine
career pertaining
wears a mask
to
just to make-
artifacts, of course,
just because it makes
influences
her
and
feel safe.
my
The
analysis
headgear she's wearing
processes
is a giveaway.
in terms of wanting to ensure
Correct.
I understand how things work. I think it actually gives me a better understanding in many ways of how data moves through devices, as well as how understanding
Of course,
why
Kingdom is
the
seconding
tools
those motions. She looks
parse
like
and
a
represent
terrorist to
data the
me.
way they do, in terms of the fact that they are presenting the data as they parse it using the proper algorithms to
That is a loaded question,
dissect that
Dante. I'm
data
not
and
going to answer
determine what
that.
it is based on testing and knowledge. So I think it actually influences in a positive way the depth that I go through in my analysis.
You had mentioned earlier in your testimony that you had reviewed both Trooper Garino's report as well as an affidavit from Mr. Green. Is that correct?
Correct.
And with regard to the affidavit from Mr. Green, what, if any, issues of significance did you observe in his analysis?
In Mr. Green's analysis, there is a conclusion that is drawn that a search occurred at 02:47 a.m. on January 29th. Based on the artifact recovered from browser state DB that Celebrite parses. And there are two errors with that. The assumption that that is the time of the search is a misunderstanding of the browser state DB artifact, because that artifact is not the time of search, it's the time of movement of the tab, as well as the statement that, that it was deleted due to the demarcation of Celebrite as recovered.
And based on the totality of your analysis, your testing, and everything that you looked at in this case, what, if any, conclusions did you come to?
My conclusion is that there was a search at 02:47 a.m. for Hawk Mock Sports, and that browser was in use, and there were continual searches due through the night. The phone was, I do agree with Mr. Green's findings that the phone was in use at that time at 0227. Later, the phone a web search is done at 6:23 a.m. For how long, at that moment, Apple produces a suggestion for how long to digest food. The search is instead completed with how long TI, die, and CKLD at 6:23. A new search is conducted at 6:24 of HOS, long to die in cold, Haas long to die in cold. That search is then the last search that is made in that particular tab. And that's my conclusion.
What, if any, conclusion did you come to in regard to items being deleted pertaining to those artifacts you were looking for?
In regards to those artifacts pertaining to those search terms, I had no evidence of deletion.
I have a moment, Your Honor.
Yes.
There you have it, folks. The state's expert is saying that House Long to Die in the Cold was conducted one time, not deleted at 6:24 in the morning, but definitely not at 02:27 a.m. as the defense is asserting, and as our friend Kingdom has asserted.
Your Honor, may we approach?
The other stance and word out of his mouth has been House Long to Die in the Cold. I think they're doing a sidebar, but I'm curious to find out what the defense is going to go, because once again, the defense had their own expert witness, take the same data and make the same analyzation that this expert has made. I believe she addressed that there by saying that they're going off of one menu, so to speak, in the Celebrite that shows that when the tab was opened or maybe when the tab was closed. But she is saying that, yes, if you look there, it can be misleading, but you have to look in these other places, the wall being one of those, which is another location of data storage inside the phone, that you have to look there to see the very details of the tab. And I think we've all experienced that. I do that with my phone. I may only have 3 tabs open, but I'll just keep going back into the search bar on the Google search and search for the next thing. So I don't necessarily open a new tab for every search. It sounds reasonable to me, Big Ron. What's your opinion?
I was always under the impression that it didn't save a search into cookies unless you clicked on that. That was my opinion, and I may be 100% wrong on that. I know on my cell phone, I close all my tabs all the time because it eats up background memory, especially on an iPhone. It just tears up the background memory on an iPhone bad. So I always close all my tabs. It keeps it from slowing down and gives me a little bit of a quick response on it. But I was always under the impression that if I search something, when it gives you those algorithm searches, you put in the first 3 words and it gives you something crazy like how does a squirrel eat chocolate or something like that. Unless you physically clicked on that option, I didn't think it saved it to cookies. But from what she's saying, I'm 100% dead wrong.
That's what it sounds like. It sounds like once you that it records a tab being opened, the initial search in that tab, but any subsequent searches after that, it sounds like it changes the title of that tab to essentially the last search done on that tab is what that tab will be labeled. Which really, if you think about it, that's the way it is in your phone. If I search for chocolate chip cookies on open a tab and search for chocolate chip cookies, and then later I search for House Long to Die in the Cold, when I go back to there, it's going to have my latest search, which would be House Long to Die in the Cold. So I think her testimony was pretty good, to be quite honest with you. I don't have, of course, I don't have the knowledge to refute what she says. I kind of have to take her on her word, but she explained it very well. She explained how she got to her analysis findings, and I thought she summed it up pretty good. She may not have been the best looking witness. She may have been dressed funny. She may have had a funny camera angle. But the information that she provided on the stand, I thought she was a strong witness for the state. Of course, Dante would like to know, can we get this woman to look at the Sallyport hard drive? I don't. Maybe. She may have the expertise to do that. I'm not sure. I would expect that we've had the defense have some experts look at that as well. Guys, on this break, I'm going to step away for a quick bathroom break myself. I'll be right back, but we'll be silent for a moment. I'll tell you what, let's play while we're on the break. instead of listening to the news. Let's go to Kingdom's recap of it, Michael Proctor on day one testimony.
Welcome to Michael Proctor on King. Welcome to Michael Proctor on Kingdom Radio.
Appears to be a picture of a toy Santa Claus.
All right, folks, I'm back. You know what? I don't really know much more to say than that, other than I think she was a credible witness, and I think she's going to leave. She's going to leave a mark.
I think
My
she was a
apologies,
credible
I had
witness and she had some
dual
good
P's going there.
information, but I don't understand what that's got to do with what we're dealing with now, because everything's leading completely down a different path.
Well, it goes back to the cross-examination to Jennifer McCabe on this Google search. Jennifer McCabe is saying that I didn't ask how long it took to die in the cold. That wasn't a question I had. It was a question that Karen Reed had once they'd found his body. They were waiting for the ambulance to get there. She's saying that Karen was hysterical, upset, and rightfully so. She just found her boyfriend literally dead, laying in the front yard with snow on him, and has obviously been in the cold for a while. She's saying that that Karen Reed asked her, said, "Please do a Google search and find out how long it takes for someone to die in the cold." And that's where the house long, which is a misspelling of how long to die in the cold, was the Google search. On cross-examination, they bring up the same Celebrite data analyzed by another expert that says that you made this search at 2:27 a.m. pacing in your home. You weren't asleep after the party like most people would have gone to sleep. You were awake, kind of leading to believe that Jennifer McCabe had a guilty mind. She was concerned. She was nervous. Instead of being asleep, she knew something was wrong and that it just hadn't been discovered yet, and that she was doing some research to make sure that by the time O'Keefe would be found, that he would be deceased, therefore not being able to say whatever nefarious means that he met his death. This is going on the defense's assertion that whatever happened to O'Keefe happened to inside the house by the Albert family and the partygoers that night, which McCabe was one of those people. So this is refuting the defense's assertion that this how long or how long to die in the cold Google search was made at 2:27. If the Google search was made at 2:27, it reinforces the defense's case that this Google search was made prior to anyone knowing that O'Keefe had been injured and that he was laying in the front yard. It would give her inside knowledge that she must have known this. Otherwise, why would you make that search? But this testimony has refuted that, saying that she made a search at 2:27, but it was about some hockey league, I think, some sports request. And then later at 6:23 a.m., after the body had been discovered, she opens up her phone, goes to the same tab that was opened, and just does another search inside that same tab. This expert, I think, laid it out pretty good, saying that, well, you can't go by just whether the tab was opened or closed, because the one log, so to speak, or one database stores it one way. You have to look at, she said, two others. And these two others show that since it's not there as a deleted search, it wasn't the search was never deleted. And since it's not there multiple times, it was only searched one time, is what she's saying out of this. And she's referring back to separate databases contained within the Apple phone in her expert testimony, saying just that.
So she's
I don't know
not
if that
saying she
cleared it up
didn't.
for you, Ron, or made it more muddy for you, but that's
She's not saying that she didn't search it. She's saying she did, but only searched it once.
She's saying she did search it. She searched it once, and that it was at 6:20 some odd time in the morning, a.m., after the discovery of John O'Keefe, which is consistent with Jennifer McCabe's testimony. This, in fact, that's exactly what this does. This backs up Jennifer McCabe's testimony that she only made the search one time, and it was under the behest of Karen Reed, that she didn't look for it herself. And it also explained the other search that was logged in there, how long to digest food, which would also be kind of incriminating under the circumstances. But this expert is testifying that that was a search suggestion by Google, not exactly. And we've all experienced that. You start typing in something, uh, we've seen it as conservatives. You type in something about uh, Donald Trump, and you'd get a Hillary Clinton suggestion or something like that. But that's what she's saying, is that this was a suggestion search, not a typed in search by Jennifer McCabe or the user of the phone. Can't really say it's Jennifer McCabe, but whoever used the phone at that time at 6:20 some odd time in the morning. So essentially, it backs up Jennifer McCabe's testimony identically, perfectly. Go back over some of these comments. Dante has said, peer review, authorized censorship tells us this woman's job is dependent on not rocking the boat. You could say that. I just don't know that there's any evidence to. I think it's an assertion. I don't know that there's any evidence to support that, Dante. They put all this effort into Jen's search, but it's okay. Brian's agreed to destroy their phones. Something stinks. I don't disagree with that. I think Higgins destroying his phone and Albert getting rid of their phone, I think that's highly suspect. But I don't disagree with you on that one, actually, Dante. I just don't know that you can present any evidence that there was any foul play connected to this offense, since there's no evidence to go back on. This guy is way Higgins, the way he throws out trying to pick up on other cops' wives or girlfriends. He could have had some other type of relationship in that phone that he didn't want discovered, that maybe wasn't connected to this case, but could have jeopardized his position as an ATF agent, is the reason he got rid of that phone. Of course, that's pulling on assumptions, just like we're assuming that there was something connected to this case incriminating the phone that they got rid of. I guess the absence of evidence doesn't mean evidence. Does that make sense? And here we go. We have some clear thoughts from veteran LT3. All jokes aside, she laid out the facts in her expertise. I agree with you, LT. It sounded reasonable to me. It sounded like she knew what she was talking about. And I didn't catch it that you didn't hear the audio because they were muted from the sidebar when they went to break, but I think they're just doing their morning break. So we should be back here in a few minutes instead of watching Batman and Strawberry Shortcake on this news feed. But Big Ron and Dante, Vet, all you folks listening out there. By the way, if you're watching our live stream, if you'll text in whatever platform you're on, we can see that live here in the studio. We'll put your questions up or your comments up, and we can either respond to your comments or we can try to answer your questions if you have them. But we encourage everyone to participate. Participate in the feed and ask you questions. Give us your opinions. We'd like to hear them. But I would say that this testimony reinforces the state's case. I don't know that it damages the defense case. The defense got several prongs attacking the state on this. And I will say, once again, the hardest one they've got to get over is getting the repugnant things that Proctor said on his text to his friends out of the jury's mind, in trying to put reframe this back up, that it was a solid investigation, that it wasn't biased. You can't bring in an expert to reduce Proctor's testimony. That's going to stick where it's at, and it could be a bone that sticks in the jury's throat all the way through this. You may not be able to overcome it. Vet brings up a good point. Wonder how you can cross-examine that witness. Data is data. I would think that the defense would move on. Defense they could pass on this witness and then bring their own witness to put on the stand during the defense and give their expert opinions, view on that. Sometimes that's the way experts work in court. Here's the states, here's the defense. You make a decision on which one you believe. Or they could come at it if they've got the Celebrite data and feel comfortable enough to dive in with it and find if they know or have seen a chink in the armor there, they may attack it. It's really hard to say on that one. But I agree with you. Data is data, unless they've got some expert testimony or some data to refute it. You might just let that lie and try to fall back to the back of the jury's mind instead of keep it to the forefront. Well, we'll see. And Dante, the possibility of corruption and an ATF agent and Boston cop destroy the phones as they might have non-related incriminating evidence sounds bad. 100% it sounds bad, Dante. Getting rid of the phones, there is no good angle on that. And once again, despite what some of our pundits on this feed might say, I am not making apologies for these folks, not whatsoever. Getting rid of the phones is super suspicious. But I will say, because of their positions in law enforcement and the other things that could be located on that phone, there may be other reasons why they destroyed it, not the fact that they're covering up for this actual offense. But it also is evidence that it's not evidence that they're not involved either. It just doesn't look good. But once again, in court, the absence of evidence is not evidence. It's not something that the jury's heard it. The jury can weigh it in, but it won't be something that they can put a sticker on an exhibit number on that the jury's going to actually use in their deliberation. But no, I agree. I think Higgins is dirty in more ways than one. I haven't heard enough about Brian Albert to actually say that, but I would say that getting rid of the phone is pretty dirty. We've got our friend from Oregon, Robert White, in. Welcome, Robert. And I appreciate you. Thank you, sir. I'm myself and Big Ron are holding down the fort today without Kingdom. So I apologize if we don't give the conspiracy side of this as strong as it's usually pushed. But I'll go back again that I try to make these analysis on what the jury is going to hear, not what's rolling around on the outside as far as news media and other people's opinions. And the reason I do that, folks, is that at the end of the day, when the jury comes back on a decision, they're going to use the evidence that we're hearing that comes from that testimony stand. We're using, they're going to use the evidence gets an exhibit sticker, as we've seen that process go through. That's the only stuff by law, and honestly, as we the people, that's the only thing we really want our juries to consider. We don't want our defendants tried in media. Media is not subject to cross-examination. They can say what they want under the freedom of speech. What they say is not necessarily evidence, but what we hear in court is supposed to be evidence. That's what our judges are supposed to do for us. But that's when I give my analyzation, that's where I'm coming from on that. I don't take outside pundits' views in. I listen to what the testimony is and try to weigh in as if I was their juror. So I hope that clears something up. And I've got Veteran says, I'm a damn apologist. Okay. I'm glad you fixed that up with the joking for everyone watching. I'm not worried about that, folks, to be honest with you. If you listen to what I say, I'm not apologizing for anyone. I think I've called a spade when it comes to this investigation as being at the very least incompetent, at the worst there's corruption. I just don't know that I've heard evidence that convinced me 100% that there's corruption. We'll go back to the black sole shoe versus a white sole shoe. You show me that in trial, then I have no other conclusion other than to draw that that there's police corruption and tampering with evidence. But once again, when it comes to that black sole shoe and the white sole shoe that was entered into evidence yesterday, defense passed. The defense did cross-examination to that witness, but they didn't bring up the shoes. So it leads me to believe that there's some sort of anomaly in that photograph that we're seeing that explains why it's a black sole shoe. And if they were to bring it up in front of the jury, it would have been explained very simply. And so there was no reason to bring that up. That's my assessment on that. But as far as an apologist, yeah, that's my friend Kingdom giving me a hard time. but it doesn't bother me. And our friend Robert White in Oregon is telling all you guys you're doing a great job. So he's enjoying listening and your comments and everyone's point of view on that. So that's good as well. Hopefully, we'll get back to this trial here pretty quick. And I think we're about done with the state on this one. I don't think the state's gone as far as they've want to go. They kind of let the witness give an in summation with all the technical data that was presented. So it kind of leads me to believe that the state is pretty close to turning this witness into cross examination, and we'll see honestly what the defense is going to do. If they're going to take on a cross examination of this witness, or they're going to pass the witness. I would say cross examination is going to have to be refuting her findings. I don't see any other thing that this witness testified that they could even bring up in cross examination to challenge, unless they're going to challenge her findings outright, which would be, in my opinion, a pretty lengthy cross examination, at least as long as the defense was up. You watch there. There's your weather from Boston. If you're in Boston, looks like you got some stormy weather coming. Hope it's not a snowstorm, which is not. Looks like you got some rain coming in over the next couple of days. While we wait, let me run a little promo for our friend Sig Soda. For those of you that don't know, let me tell you about Sig Soda. Sig Soda designs Pro 2A gear like hats and gloves. He's got some great little stickers. Also, pro Trump stuff. He's a pro Trump guy. He's got a nice hat called Biden, spelled Byeden, like Biden. But he also has produced a hat for our friend Dexter Taylor, who is a gentleman that we know out of New York, a 52-year-old black man who, computer programmer, the type of neighbor that you all like to have. We've gotten to know Dexter very well. He was convicted in the state of New York for not purchasing permits for building traditional firearms at home, which is completely legal, completely within your 2A rights to do on the federal level. But evidently in the state of New York, you need to purchase a $300 permit per weapon that you may possess in your home. If you never take it out, you never load it, you never brandish it, you never let anybody know that you've got it. The state of New York still wants that permit. But because he bought parts, and the manufacturer gave over the customer list to the ATF, and I saw that all these parts, because he built 12 firearms, 80% lowers. For those of you that are in the know of that, that means that he essentially gets the lower receiver and is essentially a block of steel, and then mills it out himself. It takes a real craftsman to put these things together. But he produced some very nice firearms. If you're a firearm collector, you would want these in your collection. These aren't zip guns made out of rubber bands and duct tape. These are extremely well-built, finely crafted weapons. Another little side note to that, they'd never been fired prior to law enforcement raiding his home and taking them into custody. They test fired them so they could show them in court that they were operational weapons. But I say all that to say this, that Sig Soda's designed a hat. I stand with Dexter Taylor. You can get it on the Sig Soda site, or you can DM me on X at Joe_Lanou, and I can set you up, and also add $10 of your purchase goes to the Dexter Taylor Legal Defense Fund. Going back to Dexter was convicted of this charge for not purchasing permits. They treated it like it was a violent crime, although Dexter Taylor has no criminal history. Literally, like I say, he's the neighbor that you'd want to have. If you're walking down the street, a 20 fell out of your pocket, he chased you down to give it back to you. He's that kind of guy. But he's sitting in the state penitentiary at a 10-year sentence, was just convicted in May. But this is a hat to show his support. Number one, getting his story out there is another thing that we're trying to do. I think when more average Americans see this in its real picture, not sensationalized by the media, I don't think most people are okay with a guy like Dexter Taylor being put in prison for the length of sentence that he's put in prison for not purchasing a firearm permit. But his legal defense fund is important. whether you DM through me to donate, when you go to Sig's site, he's got a flash page that comes up. Drop $5, whatever you can afford. Drop it into Dexter's legal defense fund because he's got appeals coming up. It's going to go through the federal court. In his case, will actually challenge the state's law against the Bruin test. So all of us 2A folks are very interested in that and want to support that, and we wish our friend Dexter the best of luck. But here's a little promo on where you can get that hat, and he can talk to you about getting it.
Hi, folks. Joe Lanu here. SigSoda.com has come up with an exclusive hat design to show your support for our friend Dexter Taylor, a.k.a. Carbon Mike. Message me on X to order, and $10 of every purchase goes to the Dexter Taylor Legal Defense Fund. Sig Soda is your source for Pro 2A Amendment gear, official sponsor of the Night Court Show. Let's show Sig Soda some love and some support.
And while we're talking about 2A Pro 2A vendors out there, let's talk about FoundryHolsters.com. Foundry Holsters, actually, let me change that. It's FoundryHolstersCompany.com. But they make custom holsters. This is a veteran-owned company out of North Carolina, very strong 2A supporters. They, folks, they have a lifetime guarantee or satisfaction guarantee on every holster they make. They will make them custom for you. You can, if you don't see anything on the website that you like, you can email them. They make inside, outside holsters, any type of holster that you want. Each one are custom made. You give them your make and your model, and they will form one for you. Our co-host John Cox had one made to accompany or to accommodate his light on his pistol, and he is extremely happy with that. Said it's the best holster that he's ever had, and that the owner of this company was. Because it was a special made holster, was very in tune with him and guaranteed his satisfaction, which he achieved that, but also laid it out there. If you didn't like it, send it back. He would make it happen. So I can't stress Foundry Holsters. It's Founders Holstery Company, co.com. If you're looking for a holster, support these small businesses, support these folks that are 2A supporters as well. I feel like that's a better, as us other freedom-loving Americans, that's a better spending of our money is some of these smaller companies that are keeping the fight up, and they hold the same values as we do. So if you're looking for a holster, interested in a holster, that's FoundryHolstersCompany.com, FoundersHolstersCo.com. Custom holsters for you. Vet says really curious on which direction the defense is going to go, and also where the state will go next. Folks, I'm saying at some point we're going to have to see a medical examiner. We've had a medical examiner testify in grand jury, but we haven't had a medical examiner testify in this case. I think that the state cannot close without putting up a medical examiner to talk about the exact cause of death or the determined cause of death. As the state sees it. I think that is a key point in the element of the offense. I don't know that they could rest with satisfying the burden of proof of the state without putting that up. So I'm hoping we'll see the medical examiner today, to be honest with you. But we'll see. I don't know which way they're going to go either. And I am curious to see if the defense just passes the witness or they actually dig in. Because they dig in, they're going to have to come in with some technical data from their experts that have pulled off this same Celebrite report and come up with a different conclusion. And that is something to note. The defense has a different conclusion of this same data that they received the same data that she received, the Celebrite dump in the files from the phone. So the defense has made the assertion in media and through Turtle Boy that they can prove that this search did happen at 227, and that goes back again, kind of like the black sole shoe versus the white sole shoe. If that did happen, it's going to have to make you reconsider how genuine anything Jennifer McCabe has said, because she denies that the search happened at 227. And the fact that this particular search did happen at 227 is very suspicious, because this is the time frame where no one knew where John O'Keefe was. Keep in mind, party goers, he didn't come in the house, or in their mind, he's at home sleeping. Karen Reed, according to her story, she dropped him off. So she's at home sleeping. Everything seems to be fine until about 4 or 5 in the morning when John O'Keefe doesn't come home and when she raises the alarm that there might be something up. So all that said, if Jennifer McCabe did make a search about how long it takes to die in the cold at 2:27 a.m., it definitely paints her in a different light, and I think it adds to the conspiracy assertion or theory that the defense is pushing as well. So it is some key testimony. Let's hear what the news has got to say about this. I think they're recapping it.
An hour and a half past the time that we were supposed to. And we started with digital forensics examiner Jessica Hyde. She was contacted, she says, by both the prosecution and the defense to review Google searches made by Jen McCabe after John O'Keefe died. Now, remember, Jen testified earlier to searching how long to die in cold around 6:24 a.m. after she says Karen Reed asked her to. But data suggested that Jen made that same search much earlier, around 2:22 a.m., which is hours before John O'Keefe's body was even found. The digital forensics examiner testified that the 2:22 a.m. timestamp is actually not necessarily when the search was made. Rather, she says it could be the time the search tab was originally opened or moved or closed, and that she found no evidence that Jen searched how long to die in cold before 6:24 a.m.
But saying that the last time that tab was touched, moved to the background or foreground, was 2:27 a.m. The website, as you search more websites in the tab, that gets updated. So the current state that this is showing is that the tab was moved to the background or opened or some action for the tab at 2:27 a.m. when the Hawkmock Sports, I got it right, Hawkmock Sports website was visited. And then once the Hawkmock Sports website was visited, that tab was in continual use. There are other searches and activity that happens. We don't see that happens eventually. This search gets made at 6:23 a.m., this search at 6:24 a.m. That winds up being the last search in the tab. And because it's the last search in the tab, that's what the final update is and the final status.
But of course, the defense is going to get their opportunity to cross-examine that witness. And that juror that I talked about from earlier, she was eventually dismissed. The judge just cited personal reasons, didn't give us any more of an explanation. In Dedham, I'm Penny Commit, WBZ News.
All right, Penny, thanks so much. Turning to next weather. This is that.
Well, now that's interesting. The juror that was seen on the feed has been dismissed. That means you're going to have alternate juror that's going to jump in and take that seat. Shouldn't affect it too much. Alternates do sit and listen to testimony in case they have to fill in. Another interesting thing that I did not know was that the defense reached out to this expert as well to do an analysis. So she did an analysis for the defense as well, but I don't think the defense decided to use her. They may have gone a different route. I do know they reportedly they have an expert that reevaluated this data, looked at it a little closer, and says that absolutely this house long to die in the cold was a deleted search from 2:27 a.m. and that the exact same spelling, misspelling, house long to die in the cold was a duplicate search, another search again at 6 in the morning. The theory behind that that Kingdom is proposed, and I think he's gotten this from other outlets as well, is that she intentionally misspelled it on the second time to try to cover up the fact that she deleted the search before because she was worried that that could be discovered, and that her effort to get around that was delete the search and then repeat that same search in the same tab at 6 some odd time in the morning, and that that would cover up and make the 2:27 a.m. search not be discoverable. So I guess kind of the question is that, what do you, if you're the juror, what do you think? Do you see it? Which way do you see it? Do you see it on the defense side? Or do you see it on the prosecution side? If you're an unbiased juror, and the only thing that you're taking into consideration is what you've heard on the witness stand, not other pundits reporting or podcasters reporting or my opinion, anything else that all of us on the outside are saying. What conclusion could you come to just by listening to the evidence in its totality of the whole trial? And I know Dante's pretty familiar with this case. I think Veteran and Ron, you guys are somewhat familiar with the case. I'm pretty familiar with the case. I know Kingdom is as well, but I would be curious, like Dante or some of the other folks that have been following this, even if you're not commenting, if you would drop a comment, is if you had to go into deliberations today, which way would you go? Would you side with the defense or would you side with the state? Dante, if you can give us an answer on that, or Big Ron, you as well.
Now, everything I've seen, especially the yesterday's testimony, we were looking at that tail light, those different views of the light still red without white light showing through. I'm convinced that she didn't do it, or at minimum wasn't the cause of the death. I still think there was an altercation inside the whole text messaging stream that we have between her and the one guy pushing the whole sex scene pretty hard. And I don't know, this just has a whole feeling of one of those lifetime stories of the jealous guy that wants the girl, but the girl doesn't want to be with the guy because there's a boyfriend. And I'm definitely on the defense on this one. And it looks like Dante said he'd have to go with the defense too, Dante.
You know, I'm torn. I don't know if I had to do it right now. I don't know where I'd go. I do have issues with the taillight lens. I think there is, once again, very poor investigative work on memorializing what really is happening there. We have days that have gone by before we really get pictures of what that taillight looked like on the vehicle. When there was plenty of opportunity for law enforcement to do that. Once again, is that a conspiracy? Because if you're going to try to cover it up, then you would try to what am I trying to say? Choreograph how things are seen. So I see that. Oh, Dante says there's a rumor going about that a juror was talking to a witness in the waterfall last night doing their own investigation. That's not good. Boy, wouldn't it be something if there's a mistrial for a juror's misbehavior? That would be incredible. Because a mistrial, by the way, folks, and something like that would pretty reassure the state to recharge the case and go back at it again, start from the scratch, first witness and all the way back through again. But back to what I was saying, if I was a juror and I had to deliberate today, I think I would have reasonable doubt. I would have to go with the defense, although I'm not 100% sure that she is a complete innocent in this. Now, whether it was intentional, whether it was an accident, whether she even knows that she actually struck him, I just don't know on all that. I haven't seen evidence other than anecdotal evidence, nothing empirical, that says that he went into the house. I've heard that there's some data off of a cell phone. Initially, it was an Apple Watch, but I think that's been disputed now. I've heard a lot of things in the media. But when it comes down to what I've heard in court, which is what a jury would have to go off of, I haven't heard anything that for sure puts him inside that house. What's Veterans say about this? Veteran says the light beginning intact on the flatbed tow truck, and now the incompetence of the investigation, how Proctor laser focused on Reed. I agree with every bit of that. I still say there is no conclusive evidence of exactly what that tail light looked like, with exception of I'll give the Dayton police officer, the sergeant that testified. I think he was professional, and I think he told us what he really saw and what his real recollection was that it was a cracked tail light, but it was mostly intact. He thought maybe one piece was missing, which I will say that is in my mind, that's a far cry from what I'm seeing with the tail light assembly as presented in court, which more than 90% of the lens is gone. So that's a hang up for me in a tie. It goes to the defense, and I would say that wouldn't say that Jennifer or Karen Reed had nothing to do with this, but I will say that I'm not sure the state's proven the case up to this point. Long-winded, but I agree. I would go with the same way you guys are going. Same long-winded way of saying it.
I agree with Dante on that one. It's a failed investigation. There's so many holes from the Solo Cup to the snow blowers out there and the leaf blowers trying to trying to pick up evidence. So I'm with you on that one, Dante. On that basis alone, it should be dismissed.
No, and I don't disagree with you, Dante. I agree with you as well. I don't know that it's a clear-cut case of police corruption or cover-up, but I will say that, and go back to the O.J. Simpson trial. I think most people would believe that O.J. Simpson absolutely had something to do with the death of his estranged wife and her boyfriend or her friend. But the police in that case, carrying the blood vial around, they did things that they should not have done, either out of laziness or incompetence. I don't think they tried to frame OJ, but I think out of laziness and incompetence, and I think the jury got that right. It's really sometimes not a statement for the jury to absolutely find in this single incident a person needs to go to prison or a crime has to be punished. If the state doesn't come right, I think the jury needs to kick that back, and that sends a message back to the state: is that don't bring us bullshit. If you're going to come and put take an American's sacred right of being free away, no matter who that American is, no matter what station that American comes from, American is all you need. That's the only card you need in your pocket, is that you're an American and you have the right to be free. If the state's going to take that away, they need to come right, and they better have their I's dotted and their T's crossed. And if they don't, I think juries need to let people go. I do believe that it's better for a guilty man or guilty person to go free than it is for an innocent person to be subjected to prison. Imagine that. Let's imagine you got 30 years or 40 years in the state penitentiary, how every day would be for you to be incarcerated, not free. You can't hug your children. You can't walk outside when you want to. You can't choose what you want to eat. You don't even choose when you want to go to bed or what TV show that you want to watch. Imagine that and being innocent. That to me would be living hell right here on earth. I have seen that a few jurors said that it was payback for Rodney King. I have a problem with that. Jurors shouldn't be paying back for other cases. They need to look at, did the state bring a case or not? There's no burden of proof putting on our justice system. There's no burden of proof put on the defendant. The defendant can sit there and be quiet. The state needs to be able to prove beyond a reasonable doubt that a person committed an offense by the elements and by evidence that's weighed in court justly, and a jury makes their decision off of that. I think if you're doing it for another case, that's bullshit. I have heard that jurors have said that after the fact, but I think at the end of the day, if the state had brought a better case against OJ would have been convicted, in my opinion. If they hadn't taken one of the biggest issues, if maybe some of you are not old enough. Oh, hold up. I think we're back live. This could be an accident reconstruction person. Good.
You get certified for 5 years, and within those 5 years, you still have to maintain a certain amount of education to reapply for ACTAR again.
And with respect to that ACTAR examination, are you familiar with sort of the success rate or the passing rate when it comes to that examination?
Correct.
And what is it?
It's fairly low. I can tell you within my unit at the time I took it, there were probably 20-something of us that took it, and only 3 of us passed at the time. Yeah, it's not a very high pass rate.
Now, over the course let me ask you this. When you first sort of enter into the cars units, are you just sort of, you go through the training and then you are on call and get sent out on the road by yourself, or how does that work?
No, you first get initially assigned to a field training officer, and then at that point you shadow the field training officer to various crashes.
And is there any sort of set time period for how long that shadowing process goes on for?
It's not really a set time. It's more based on experience, on how many crashes you go to and how much experience you have in the field. And then they basically, well, if they feel like if you're deemed qualified, then they'll send you on the road on your own.
Credentials. Dante,
And over the
I think
course
he's either
of
short
your
or
years within
further back from the
cars
mic.
of the reconstruction unit, approximately how many crashes have you responded to and investigated?
As of now, I've been to approximately 196 crashes, and I've probably assisted another 100, 150 crashes.
And of those, of all those crashes that you've responded to, investigated, if you know percentage-wise or number-wise, approximately how many of those have been crashes involving pedestrians?
I know I've been to approximately 55 pedestrian crashes, and I've assisted others on pedestrian crashes also. So, I mean, 55 out of 196.
Now, with respect, if I could turn your attention to January 29th, 2022. Do you recall that date?
I do.
And
Here we go.
at some point over the course of that date, were you contacted by somebody in regard to a pedestrian collision that occurred, in the town of Canton?
I was.
And do you recall who was it that first reached out, or how did you first become aware of it?
My sergeant, Sergeant Brian Mahoney, was the one who called me at the time.
And initially, as far as your involvement was concerned, what was your understanding as the initial request for your involvement?
My initial request was to image the airbag control module, do a little inspection, test the vehicle, and map the scene out.
Now, you've used that term a couple of times, and if I could just ask you to explain it a bit for the jury. When you say an airbag control module or an ACM, what is that, and what do you understand that term to mean in the context of crash reconstruction?
The ACM is the module in a car that controls the airbags and the seatbelt pretensioners.
And what you were referencing before, as far as being a CDR, having taken CDR trainings and being a CDR instructor, what, if any, relationship does the CDR have to ACM?
CDR is just a crash data retrieval software. It's the software that we use to image or download an airbag control module.
And can you explain to the jury sort of the process of physically sort of how that's done, as far as what are you doing to the vehicle in order to download that information?
Yes. There are two ways really to download a vehicle. It's either one is direct to module, or just direct to the vehicle through the DLC port or the diagnostic link connector. Direct to module, we don't use the direct to module if a vehicle had no power. Then we would have to go directly find the module inside the vehicle and go right to that specific module. But if the car has power, we would go direct to the DLC port, which is the same port that you see when you're like a technician would do the diagnostics on a car. They would plug underneath the steering wheel, and then we'll get there, extract the information from there.
Now, once that information is extracted, what, if any, training have you received in regard to reading or interpreting the data that's extracted from?
Yes, I've been certified as a CDR analyst, and I've taken 2 classes on it now.
Now, sir, turning your attention to February 1st, 2022. On that date, where, if anywhere, did you go in relation to your investigation in this case?
I went to the Canton Police Department.
Now, at some point prior to that, were you made aware, or did you do any research into sort of what the weather was like around the time? What was reported to you initially as around the time of that the crash occurred?
Before that, I know it was snowing and turned to a blizzard at the time.
Now, initially on February 1st, 2022, where did you go?
To Canton Police Department.
Now, sir, at some point in time on that date, did you also have occasion to go to a residence or a street called Fairview Road in the town of Canton?
I did.
And Specifically, there was a address that you were directed to. Is that correct?
That's correct.
And who, if anyone, did you go there with?
I believe it was one of the Canton police officers, Lieutenant Paul Gallagher, I think his name was. I met him there.
And without anything specific as to what was told to you by Lieutenant Gallagher, what was sort of the purpose of having Lieutenant Gallagher there with you at that time?
Of course, he wants to get to the
He
point.
was going to show me where
Another
basically the evidence that they have at that point was.
Now, in addition to that, were you also able to, you familiar with another specialized unit within the state police called 13?
I am.
And at some point, did you have access to certain diagrams created by
Dante, I was about to say that. If this data from the Lexus comes back and says that vehicle traveled 61 feet at 24 miles an hour at that same time, that's going to be a pivoting point in this case that it's going to be difficult for jurors to get over. I'm not sure how detailed the data coming off these recorders are on this particular model, so I'm curious to see this myself.
I'm going to show you what's been marked as Exhibit 135 and 136. Actually, just review that until we finish.
I'm not sure what you're talking about, Quianis, but I'm just going to say that I'm good. That's good.
I do.
I'm good.
And Your Honor, with the court's permission, if I could just publish that briefly to the jury.
Okay.
Ms. Gilman, if I could actually have Exhibit 136. If you recall, do you recognize what's up on the screen as Exhibit 136?
I do.
This is the diagram that you were able to view from the created by Lieutenant O'Hara from 13.
Yes, it was.
And what's contained, at least when it's overhead shot, is that fair and accurate trail of the roadway or the conditions of the roadway, absent obviously the weather at the time that you went out there on February 1st.
Correct.
Tell me you can take that down. Thank you. Forgive me, Your Honor, if I could just have 1 second.
Sure.
Monty says, I think the reverse speed could be argued as a wheel spin, depends on the sensors on the car regarding crash assessment. I agree. You could try to lock it up. It's just going to be interesting that if it's at the same time and it indicates a distance.
And do you recognize those, sir?
I do.
Yeah,
what do you recognize those?
Hard to get around.
They are pictures that were in my report. They're
Hang on, folks. I'm trying to figure out find out exactly what happened here. I think they lost feed from the courthouse.
Contains, at least when this overhead shot, is that fair and accurate trail of the roadway or the conditions of the roadway, absent obviously the weather at the time that you went out there on February 1st.
correct.
Tell me you can take that. Thank you.
Try another feed.
That's a better camera angle.
Forgive me, Your Honor, if I could just have 1 second.
It looks like they switched back to the regular camera angle, I guess. Maybe that's why the feed died with the news.
May I approach the witness, Your Honor?
Yes.
I think it's Qualnius on the YouTube feed. It's giving me a hard time about how I do it because I was up till almost 2 o'clock
And do
Central
you
Time
recognize
on
those,
a
sir?
space,
do.
and he's saying, "How do I do it? Be back up this early in
They
the morning."
are
But folks,
pictures
that's
that are
what we do to
that
try
were in
to
my
put good
report.
content.
They're Google images of the roadway.
And one facing from the northbound direction, one facing from the southbound, is that correct?
That's correct.
Your Honor, may I approach?
Yes.
I'm also seeking to introduce the minutes of the next exhibit.
No objection.
Like I say, we Kowal Nias is how his name is pronounced there on his YouTube feed. But no, we do this to try to bring good content. We're trying to expand our reach and honestly just spread our message of pro freedom Americans getting together and having conversations and some sharing. Sharing of mind and thought is what we're trying to do. And yes, James, I know that you, Paul Us is our friend James on X. But, I made the comment of I'm doing this so folks will buy me a cup of coffee. We do have a donation league link for folks that can support the show. I'll throw the link up in a minute, but it's simply a site that buy me a coffee where you can make a donation to the show.
Yes, it is.
By the way, folks, we do appreciate that. That helps us with some expenses to putting this show together and some equipment that we're saving up to buy. And we're also working on getting to a trip to
All right.
Iowa in July. We'll talk about it a little bit later.
So this is Ferry Road. It's facing northbound. 34 Fairview Road would be on to the left in this area.
Now, with regard to the roadway, when you went there, what if any observations or what if anything did you note about sort of the roadway surface or markings on the roadway or general overall condition of the roadway?
The roadway was, there's no significant difference. Anything significant with the roadway.
As far as the roadway material, were you able to observe whether or not it was sort of asphalt, concrete, or anything?
Right.
else?
Yes, it was an asphalt roadway.
And as far as the markings within the roadway, what if any observations did you make of those?
There was double yellow stone line, white fog lines on both sides of the edge of the road. Is that what we're going after? The roadways?
And then as far as adjacent to the roadway or adjacent to the fog line, what if anything did you observe there?
So as you look at the picture, the left side has asphalt curbings. These are about 5 inches tall, same on both sides. And there's a sidewalk along the right side of the roadway here.
And the side with the asphalt curbings, that's the same side that 34 Fairview is located on, is that correct?
Correct.
Ms. Gilman, if I could have the next slide. And Trooper Paul, if I could direct your attention to the next exhibit before you, I believe it's 583. And again, sir, what's up on the screen, is that what you have before you as 583?
Yes, it is.
And if you could, again, using the laser pointer, just briefly direct the jury's attention to what, if anything, you know as far as from this perspective.
Yeah, so this is the southbound. 34 Fairview would be on the right side here.
Ms. Gilman, you can take that. Can I approach just to retrieve your honor?
Yes.
Now, Trooper, with regard to the roadway as far as Fairview Road, what, if anything, did you note in regard to postings regarding the speed limit on that particular roadway?
Yes, the posting for a speed limit is 30 miles per hour. At this area, it's only posted 30 miles per hour for northbound operators, and I believe it was like 19 Fairview Road is posted in front of. For the southbound operators, it was not posted.
And so for a northbound operator, that would again be someone where the residents of 34 Fairview Road will be on the left-hand side of the road, is that correct?
That's correct.
And with regard to the width of the lanes, or what, if any, measurements did you take in regard to the lanes or the roadway itself?
Yeah, each travel lane was approximately 12 feet, and the overall width was approximately 27 feet.
Now, as far as measurements being conducted with regard to the scene, what, if anything, did you use or employ to make those measurements, or what, if any, devices?
Yes, I mapped the scene with it's called a Leica GNSS GPS total station, and also used a drone.
That's a UAS, is that correct?
Correct.
The drone, I mean?
Yes.
And with regard to each of those, as far as the GPS mapping and the drone, have you received any sort of specialized training in regard to employment of each of those tools?
Yes, I have been certified to use the Leica, and I've also have a Part 107 license for the drone.
Now, as far as starting with the Leica or the GPS, if you could explain to the jury sort of what that is and how you use that device in order to, as you termed it, map the scene.
Yes, it's essentially what surveyors would use to make roadways. It uses satellites and GPS data plus cell phone data to make marks on the roadway, or actually not marks, but just mark points in the roadway that are within millimeters of the device.
And with regard to the drone device, sir, how does that, can you explain to the jury sort of how that works and how that's used?
Yeah, so the drone, and we fly the drone around the area. We set it to set up a grid pattern to fly around the scene. And while it's flying this grid pattern, it takes a series of photographs. And these photographs are also GPS marked. So once we get all the photographs in, we throw it into a program, and the program will essentially stitch us all together. And then once we get that picture, we throw it into a diagramming system.
In that diagramming system, have you also received training in regard to utilization of that diagramming system?
Yes, I have.
And the one that you're currently using within the CARS unit, what is that diagramming system or software called?
It's IMS 360.
And Your Honor, may I approach the witness?
Yes.
Sir, I'm showing you 4 documents. Ask you to just review those.
Okay.
Finish. And do you recognize those, sir?
I do.
And what do you recognize those to be?
These are the diagrams that we print out through the program.
And the last one is the drone image, is that correct?
Yes, they're all drone images. The last one is just one that was put into my diagram, and I labeled it as a drone image.
Your Honor, may I approach?
Yes.
I'm also seeking to introduce the witness to the next 4 exhibits.
No objection.
Yes. That's my fault. Thank you very much. Sure. Now, Cooper Paul, are you familiar with the term, well, let me ask you this, in regard to the roadway itself, what, if anything else, beyond sort of lane width and overall width, what, if any, other measurements did you take there?
So we took measurements for the evidence.
And let me ask it this way, as far as with elevation or incline of the roadway, what, if any, measurements did you take in regard to that?
Yeah, so we took the elevation and roadway measurements, or the elevation for the roadway.
And where in relation to the residents at 34 Fairview did you take that? Sort of the entire street or just in the general area of that specific address?
In the general area of that specific address.
And from your measurements as far as, well, let me ask you this, how is a measurement regarded to elevation or incline? What kind of tool do you use for that?
We have a level, it's a digital level that we'll place on the roadway, and we'll get a measurement from that.
Now, with regard to the measurements that you took of the elevation or the incline in the roadway, anything, or what, if anything, of significance did you find from that?
So this roadway had approximately plus or minus 1 to 2 degrees.
So nothing significant, is that fair to say?
Nothing significant, yes.
Now, sir, through your training experience as a crash reconstructionist, are you familiar with the term related to crash reconstruction called roadway evidence.
Yes.
And can you explain to the jury sort of what your understanding of that term is and what types of things could be termed as roadway evidence?
That's roadway evidence is anything that's related to the collision you're investigating at the time. It could be anything from vehicle debris, gouge marks, tire marks, anything that's related to a vehicle or whatever type of crash you are investigating. It could be vehicle or pedestrians.
So any sort of anything from either the vehicle, pedestrian as well, is that correct?
Correct.
So pieces from a vehicle, holding items from a pedestrian, correct?
Yes.
Now, with respect to both your review of the CERT team diagrams as well as speaking with members of the Canton Police Department, were you able to then plot certain pieces of roadway evidence onto those diagrams that you that I just showed you a few moments ago?
Yes, I was.
Now, with reference to, you're familiar also through your training and experience when it comes to pedestrian crashes, as far as sort of the physics or kinematics of how pedestrians interact with vehicles in the course of a collision?
Yes, I am.
Now, I'm going to ask you just a couple of terminology questions when it comes to items that are involved in a collision, sort of simple Newtonian physics, Newton's first law. Can you explain what that is to the jury and sort of how that pertains to any collision between two objects?
The first law?
Yes.
Yeah, that's the when an object stays in motion or stays at rest, will stay at motion or rest until acted upon by an outside force.
Now, with respect to, are you familiar also with a crash reconstruction term called final rest?
Yes, I am.
And are there different derivations of final rest as far as controlled final rest versus uncontrolled final rest?
Correct.
And can you explain just first to the jury what final rest means in relation to crash reconstruction, and then what, if any, differences there are between a controlled final rest and an uncontrolled final rest?
Yes, the final rest is what we use for describe the area where a pedestrian came to stop after the collision. It's immediately after the collision. This is where they first stopped, or a vehicle. Usually after collision, it's where this vehicle first stopped. And a controlled final rest is when an operator actually controls the vehicle to the stop, and as opposed to the uncontrolled final rest is when there is no control, usually acted upon by outside forces that will control the vehicle or pedestrian to its final rest.
And Your Honor, with court's permission, if I could publish what's now been marked as exhibits 584 through 587 to the jury.
Yes.
Ms. Gilman, if I could first have diagram 1. And Your Honor, may I approach this to return the exhibits to the witness? Ms. Gilman, if I could ask you to zoom in just a little bit on that. And now, Trooper, what you have up on the screen, is that what you have before you as first in that set of exhibits?
Yes, it is.
Now, using the exhibit before you could, I would ask you to draw the jury's attention or direction to what, if anything, of significance you have noted within this diagram.
Okay. Who is the pointer?
Yes.
Okay. So in this time, I labeled each part of evidence. So right here would be the pedestrian's final rest, and they're all, since there's so many put together, everything was labeled with a red arrow that would be pointing to where the final rest is. And this is where a glass cup was found, and these are the red and clear plastic pieces. That's where they were found, and the pedestrian shoe was found here. The smaller versions here in the light blue is one's a fire hydrant, the flagpole. This is a label for the street 34, and obviously the street name Fairview Road here.
Now,
we've got Kingdom weighing in from his remote viewing today. It says after the BS testimony trying to cover up the house long to die in cold pool search, can't believe an effing word
roadway
from the
evidence, or
crooked
specifically
ass
from
cops or the
the
Commonwealth going forward.
pedestrian or Mr.
I'd like to
O'Keefe's
see some
final
foundation
arrest in
behind that.
reference to other items that you have depicted on the diagram.
So we're talking about Mike. So on these diagrams, like it's hard to see here, but it is a scale diagram. The diagram itself is scale. Once you put a roll up to the actual paper, it's scale. I've also have on here, sorry to see, but I think it's right here. They're called ground control points. They're little X's on the roadway. They're used for the drones imaging, and using the drone imagings will use those in order to help put all the pictures back together. At the time of this, I measured between each point from ground control point 1 to 2 and put it as approximately 50 feet.
They didn't spend much
2 to
money
3
in
is 50 feet, and
graphics.
3 to 4 is
I
50
hope the
feet.
jury can see this better
So
than
it kind of is a second way to measure off the diagram, and also using the program to measure to different points while using the diagram.
And as far as starting with the shoe that you have depicted in this diagram, what was the measurement of the shoe away from Mr. O'Keefe's body?
I believe the shoe was approximately, I have in my thing, it's approximately 10 feet away.
Your Honor, with the court's permission, may the trooper refer to his report just for the specific measurements?
Yes.
I agree with you. Veteran Kingdom is emotionally invested in this.
Sorry, Trooper, with regard to the shoe, how far away approximately was that from Mr. O'Keefe's body?
9 feet.
And did you also have a measurement for how far away the glass cup pieces were from Mr. O'Keefe's body?
Yeah, 1 foot.
And for the red plastic you have labeled on this diagram as A, how far away from Mr. O'Keefe's body was that?
7 feet.
Now, with regard to the directionality, you also measured sort of directionality as far as the 9 feet that the shoe was away. Which direction was it?
Each evidence was measured from the pedestrian's final rest. So the shoe was 9 feet southeast from the pedestrian's final rest.
And if you could, using the laser pointer on the screen, as far as the directionality of this, or if you could first direct the jury's attention to where Mr. O'Keefe's final rest is, and then as far as the directionality of southeast from that, where is it?
Okay, so right here, pedestrian's final rest. It's more right there. The shoe is right here, so it would be kind of southeast. I have an arrow pointing north to kind of give it an extra.
And the glass cup that was 1 foot away, in which direction was that?
It was about 1 foot north. I think it was found like within, right next to him. So.
And the red plastic that you have labeled as A, again, that was 7 feet. In which direction was that, sir?
That one was east, so it's right here.
And as far as the clear plastic, what was the measurement and what was the directionality for that item, sir?
10 feet southeast. So about over here.
And the red plastic that you have labeled on the diagram as B, how far was that and what directionality was that?
That was 12 feet southeast, and that was found right here.
Thank you. Sir, if I could direct your attention to the next exhibit before your diagram number 2, and if I could have that, please. Sir, do you recognize what's depicted up on the screen?
Yes, I do.
And if you could, again, using the laser pointer, what, if anything, of significance do you observe in this particular diagram in reference to the roadway evidence?
It's just essentially the same diagram. It's just a closer up version of it. So you had, yeah. So you saw the pedestrian's final rest, glass cup, plastic pieces, the shoe. It's all still depicted in the diagram.
And the red arrows that you had indicated, delineated, depicted sort of from where the words are to where the items were. Is that present in this diagram as well?
Correct.
If I could direct your attention to the next exhibit before you, and if I could have diagram 3, Ms. Gilbert. And again, Trooper, do you recognize what's up on the screen?
I do.
And if you could just describe to the jury, what are we looking at in this diagram?
Yeah, so this is just a closer up to the the evidence. It's a little smaller scale.
And these diagrams are created from photographs that you took with the drone overhead on that day of February 1st. Is that correct?
That's correct.
And if I could direct your attention to the last exhibit within those. And again, sir, if you could, you recognize what's up on the screen?
I do.
And could you describe to the jury again using the laser pointer to delineate what, if anything, is significant to observe in this drone photograph and diagram you have on?
Yeah, so this is from my report. It's the same diagram. Has the same amount of evidence on here. There's a house, there's a light pole here. These lines here, which I mentioned earlier, were the edge of the road.
I think that if he's
and the edge of
just
the
going to
sidewalk.
come back and give us the mapping of the scene, something we should have seen from the investigators, quite
Mr.
honestly.
Riley, why don't we pause here for the luncheon recess? Trooper Paul will have you back with us this afternoon. Okay, and if you
Okay,
follow the
we're
jurors.
going to
okay?
lunch. If this guy doesn't
Jurors,
come
why don't
up
we
with
take
actual
40,
Lexus
45 minutes?
smart box data
I'll see counsel
that
at
shows
sidebar.
actual movement and timing of the vehicle, I don't think this gives the state, this doesn't really help the state overcome. It reinforces what the state's saying already, but I don't think it helps them overcome the issues with Proctor and some of the either incompetence or some of the corruption, however you want to look at it, that's been alleged by the defense. I don't think this is going to weigh much in the jury's mind, other than being kind of boring, quite honestly. So we'll see. We'll see on that. I say we have the infamous Johnny Coxerin, as King Bill calls him, with us. Welcome, John. Have you been watching any of this? Do we need to catch you up?
You need to catch me up. I'm in the drive-thru at the Chick-fil-A.
All right. Well, you get yourself a free sweet tea for me, and just know that I think you're a bastard for getting free sweet teas at Chick-fil-A.
Well, I'm not there yet. I'm not there yet, Joe. I don't know that I'm gonna get a free sweet tea.
All right. Well, you enjoy your chicken cuisine there, because it is some of the finest. I'm not Chick-fil-A is not a sponsor of the show, but I do support them as well.
Yeah.
We've had an interesting morning. Let me give you a rundown. Initially, the camera feed was cut from the courtroom for about 2 hours, a little less than 2 hours. There is a rumor floating around that a juror was dismissed. Originally, they said the feed was cut down because a juror was caught on camera. And initially, I thought that the camera was at a wide angle and the jurors were coming in the same door. I've since changed my opinion. I believe this juror was called in to speak to the judge because there was an allegation that she was at the Waterfall Bar, the bar that Reed and O'Keefe were at the night he died, drinking, and that's been testified in this trial, that she was at the Waterfall Bar asking questions. And somebody reported that back to the court, and this juror was dismissed. So we've had one juror dismissed this morning. We're down to an alternate juror that has taken in a real seat on one of the 12. After that, we had some more things happening. The state puts up a data analyst that went through the Celebrite data on Jennifer McCabe's phone. So the state has answered back on the how long to die in the cold. The search at the defense alleged happened at 2:27 a.m. This person got on the stand and explained that, yes, that tab was opened at 2:27 a.m., but the original search on that was a sports reference to something local sports, I believe. And that tab remained open, and that Jennifer McCabe, or the user of the phone, again at 6:24, I believe, 6:20 something in the morning, on the behest of Karen Reed, according to Jennifer McCabe, asked her to Google how long it takes to die in the cold, where she misspells how long. She spells HOS, H-O-S, long to die in the cold. She was emphatically adamant that this search, according to the expert, this search only occurred once and was not deleted.
Oh.
So in the defense did no cross-examination. They did put it out that the defense also requested this expert's testimony or analysis prior to trial, and that this expert provided the defense with the exact same analysis that she gave in court. And we don't know if they'll actually call her. I think they've gone to a different expert that we may see on the defense side. But absolutely,
Very interesting.
puts a dent in that. Of course, Kingdom, he's following this remotely. He's traveling today, and his response was, after that BS testimony trying to cover up the house long to dying cold Google search, you can't believe an effing word from the crooked ass cops or the Commonwealth going forward. So Kingdom weighed that with a open mind, it seems, and come up with a different conclusion.
Yeah. Well, and like I think we've said before, it just goes to show, if you've got the money to defend yourself, it can pay off. Because if she had not had the means and the funds to have these people brought in, I think she'd have been hung out to dry.
Well, I agree. I do think the state has, as we stand right now, of course, the game's still playing, but I would say the state is in the lead on the house long to dying cold. The witness they brought testified well, seemed to be very knowledgeable, explained things that I've never heard on a phone. And I've got some experience with the Celebrite data, but she used a couple of other tools as well. And she explained what the difference was between them, how one could look at the Celebrite data and say that, yes, house long to dying cold was a deleted search at 227. But she explained that that's not true, that the log that they're looking at is about when tabs are opened. And if that tab was not closed and another search was put into that, but she said there are two other databases logs that you can look at that would tell you more detail about each individual search, and that on those logs, this search was conducted at 6:24, I believe, in the morning, and it was only conducted once and was not deleted. Also explained how long for food to digest in the stomach. Says that was a search suggestion by Google. When she put in the first how long, it said how long for food to digest. So that was not actually a user search, but that was a suggested search.
Makes sense. Wow.
You know what the problem is? It did make sense. The only way you could just outright refute her testimony, in my opinion, is going to be a motion. And of course, Kingdom's got us covered on that side of it.
Yeah.
We've got Range Minded back. Welcome back, Range Minded. So that's where we're at right now. We have an accident reconstruction expert. We're at lunch now. An accident reconstruction expert on the stand. Initially started talking about taking data out of the Lexus, but has since kind of digressed from that and gone into a drone overhead mapping of the crime scene from where the body was, where the glass was, how far the shoe was at, with the road conditions. That's kind of where we're at. I was just saying before you got in, and we got Big Ron with us back. Welcome back, Big Ron. But I would say that if this guy doesn't come up with the actual onboard data from the Lexus itself, talking about a reverse speed of 24 miles an hour and a travel distance, which I'm not sure if the Lexus can gather that information or it's obtainable. I've heard rumor that it was. I've heard rumor that the state had that. If they don't bring that to bear, then I think this guy's testimony is not going to sway you. If you're in the reasonable doubt camp, I don't think this is going to pull you out. If you're in the she damn well did it camp, I don't think this is going to sway you anymore. I don't think this testimony is going to make a hill of beans compared to this. You guys got to remember, the state's got to overcome Proctor. Proctor's testimony was damning to the state. One, it showed unprofessionalism, no matter whether you think corruption or not. It shows unprofessionalism 100%. It shows the lead investigator, whether they want to call him the lead investigator or not, but at least the investigator that's pushing this case did seem to have some sort of a bias against Karen Reed early on. It's significant to listen to his testimony about the time frame. I know we all like to look at everything in the package and give it an overall assessment, but go back and look at it chronologically. At 10:30 at night on the 29th. Now, Proctor's been out in the snow. He's been out all day. He's been seizing vehicles, conducting some interviews, initial interviews, but he didn't have all the information to really say 100% sure that Karen Reed did it at that point, in my opinion. But yet he's texting his friends, talking about her balloon knot. He's talking very negatively about her, but also basically says she's effed. She's done for, and that he uh, disparaged her quite a bit in that. And this is just hours after the investigation started. So I think that honestly is the hardest thing out of his testimony, besides all the harsh names that he called her and the disrespectful way he referred to her. I think you look at the timeline on that and say, early on, not even 24 hours into the investigation, you've got your mind made up, which would lead one to believe that any other course of investigation would not be traveled by investigators. They would just go for the one that reinforces what they believe already, which, in my opinion, goes to the defense. I think most people want our law enforcement investigators to chase down every lead when, in some cases, that's not possible. Or the way law enforcement sometimes looks at it is like, well, the evidence is leading me here, so I'm just going to keep taking the breadcrumbs where I'm going, and that'll get me the story that I can prove in court, whether that story's true or not. I think most people don't want that from our law enforcement. They want to bring a truthful story into court, where sometimes it looks like law enforcement brings in the one, I can prove this one, so this is the one it is, even though there may be some other ways to explain some of the evidence. But I think that the most difficult part that the state's got to come over with Proctor is that at 10:30 at night, sitting in his easy chair, sucking down a beer after this investigation, literally talking smack about Karen Reed. I think that's going to be the most difficult thing for the state to get over at this point, from what I've heard.
So I was wondering, when you have technology in a big case like this, where it plays a crucial part, do you foresee in cases in the future where the state just goes ahead and says, yeah, we're going to have to call in experts, and it be on the state's dime versus the defendant's dime?
Ask me that one more time.
So where you see technology playing a crucial part in a case like this, do you see the courts and the judicial system saying in cases from, let's just say from this point on or in the future, coming up and saying, well, this, technology is going to play a crucial part in this, and to make sure that a defendant gets a fair trial, that the state picks up the dime on paying for these expert witnesses, or is that going to fall on the defendant and the defendant's attorney to see that that's done?
No, I don't see a scenario where the state is going to pick up the cost of the defense unless it's a court-appointed attorney, and then they will put a budget in there for that if the defense attorney makes a request. But it's a special request when you have a court-appointed or the state's paying for the defense. They will pay for certain experts, but each expert's got to be justified by the defense attorney's got to justify the expenditure with the court. It's kind of like some separate motions that go on. But no, I don't see an all outright. If you need an expert, we'll provide that expert for you.
Yeah, I was just wondering, because it looks like, and I may be wrong, like you said, the game's still in play, but just looks like the technology aspect of it is going to put the reasonable doubt in the jurors' minds. And the way I see it now, it is playing a big part in this case, saying she did do this, she didn't do that, and this tab was closed, and this is she didn't Google this. This was a suggestion. Because if I was on a jury and somebody said, well, you searched this, then that was like, yeah, why did you search that? But if it's a suggested search, then that's out of play in my mind.
Well, no, absolutely. I just don't see a scenario where the state or the government is going to pay for your expert testimony to defend yourself in court. I just don't see that as a scenario that comes into play. Now, things are different if you're indigent, you can't afford an attorney, you can't afford representation. The state does have to provide you with funds and expense for representation. But then once you look at it in levels, once you receive that representation, then in that representation, the attorney says, "Hey, we need experts in this. We need this much money for this," and then the court will essentially give them a budget to operate within to find their experts. Which I don't know if that's. I just don't know that you get the exact same representation when you have the state's paying for your defense.
Oh
They,
yeah,
they,
I
they
mean,
limit you. They'll throttle you back with the dollars.
oh yeah, I think we both have seen that when you pay for an attorney versus a court appointed attorney, how much effort goes into defending a defendant. It's
Right,
just
and it depends on the stakes of the penalty. Like in Texas, a death penalty case. Let's say Joe Lanu's charged with a death penalty case. The state's going to provide me with two attorneys, and at least one of those attorneys have to have set first seat on at least one capital murder case. They've had to try one at least. It can't be their first one. The second one has to be bona fide up. Doesn't have to be a first seat attorney on a previous capital murder case, but has to have some experience. Has to be qualified. And they do provide the state and provides all this at the state on the state's dime, and the state will provide a budget for expert witnesses as needed. So it depends on the state, and I think it depends on the exposure which crime has been in capital murder cases. That's why you'll hear, and I don't know if you hear it in your state, but my state, they'll talk about DAs will talk about a capital murder case. I've been involved in a couple of them actually, and one of the things is the expense of actually just trying one. It's well over $2 million to just try a case between the state's expenses and the defendant's expenses that the state's going to pick up on. But that's in a capital murder case. That's not in a case where your exposure is 5 to 99 or life. They're not going to kill you on it. The state doesn't afford you the same type of representation on that case as they do as a capital murder case. Good example is if I'm just looking at life in prison on a murder case and I'm indigent, and the state appoints me a counsel, they're just going to give me one counsel, and that counsel can ask for expert witnesses, but he's got to go in and basically justify it to the judge that I need this to be able to prove this. And if the judge approves that, then he'll approve a budget for that, and then you'll be able to do it. But it's not like Karen Reed. She's paying the dime, so she can bring in, she can consult 20 experts to find one that is going to testify that's beneficial to her case. Or she could look at 20 experts and all of them come back like this data one. Remember this lady that did the data, she was also hired by the defense to do the same analyzation of the cell phone data. And she gave them the same report that she gave the state. And a lot of times that the state you'll see that happening where the state will get one, and then the defense or the state will request. Let me back up. The defense will ask witnesses analysis of say cell phone data first, and then once that report comes back, the state will then pay them to testify for them as well. And the notion behind that is like this is the defense's own expert. The defense's own expert saying this, but of course the defense is not using this person because her analysis doesn't come back to support the defense's theory. So I hope all that word salad answered your question there, John.
oh
I'm not
yeah,
sure
yeah.
or not.
No, and if nothing else, I think it's information for the general public who might be listening who don't understand that process either. Because you always hear, especially on capital murder cases, well, why didn't this, the state do this, or why didn't the defendant's attorney do that? And, so yeah, I understand what you're saying. I also think it was informative too for those who don't know.
Yeah, I won't say that our judicial system is set up for the defense. I think it attempts to be fair, but I don't know that it is truly fair to someone who's indigent not paying their own dime for their defense. If you're relying on the state to pay for it, the state does get frugal with their money, and I think in a lot of ways it probably limits your defense. Um, Having money and being charged with a crime is better than uh, being charged with a crime and not having money. 100%.
Yeah.
Uh,
That,
I want to say something about Veterans Post here. He's talking to Range, so he says, "Hello, Range. My daughter took the Perry sticker and placed it on my safe. I'll deem you a pick." She's like, "I'll do it myself." 7 years old is a time. I think that she's independent, putting the sticker on the safe. But the sticker is what I want to talk about. Range, why don't you DM me a pictures of the stickers you just got in? I saw some posts about it, but I don't think I have any actual pictures. Let me post them up. Range Minded, he's a sticker and patch guy, by the way. He's got a line of those for his podcast and some other Pro 2A things that go along with it. But these stickers are interesting, and I think he's still got some of those left. If you'll send me some photographs of those, Range, I will throw them up for others to see. If anybody's interested, you can contact Range Minded, and I believe it's rangeminded podcast.com, but I will pull that address up for you here in just a second. If you're interested, he's got some nice little inexpensive swag that you can get from the Range Minded podcast show. Sorry, John, I didn't mean to step on you, but I wanted to let that
oh no,
get that
you're
out
fine.
first by my mind.
No, you're fine. I'm sure the viewers will be pleased to know I'm eating my chicken sandwich, and I only got one sweet tea today.
The people do not care about your chicken sandwich or whatever
Well,
else you're talking about. Your free sweet tea that you didn't get it.
Olivia wasn't working. I didn't see her.
Oh, I got you. So you don't have you have a plug there. It's not everybody's your plug.
Yeah.
And folks, those of you that you are interested is rangemindedpodcast.com. His address is there on a banner. Reach out to him, and if you're not watching, quite honest with you, if you don't watch Range Minded, you should. You can catch him on anywhere a podcast is, Spotify, any place that has an RSS feed that has a podcast. Just put in Range Minded, he'll pop up. Very informative stuff. He goes over some of the recent court cases that have to do with 2A legislation. He digs into those in any ongoing legal cases. He digs into those as well. But the guy's actually pretty entertaining. I hope he's not listening. I don't want his head to swell up. But definitely a podcast if you're freedom loving, and definitely lean towards the 2A. Range Minded is your go-to podcast for that. And also Untactical Texan. You'll see him on YouTube and other places. You'll find podcast. He's another one that he's a favorite of the Night Court show, and we try to support him as much as we can. So you guys jump out and support him as well. And I think Veteran DM'd me some pictures of the stickers, so stand by. Let me look for that.
I'm glad Vet found them, because all I kept finding was pictures of kiwi on pizza, which is an abomination.
Yeah, I don't know how that even happened. That's ridiculous.
Yeah, I
Kiwi
actually
on
watch
pizza.
Range's podcast so I can grow up to be like him.
Some big shoes to fill. Range is
Oh, yeah.
he's got a natural knack to that, quite honestly.
So are we taking a 30-minute lunch today, or 45, or what are they doing?
You know, they cut the feed off or the audio off before they got to that. I probably doing a 30-minute lunch. I think she said that yesterday they were going to try to get through a lot of this full day today. So when she says that, usually she does the 30-minute lunch to try to get folks back. And I'm hoping we'll find out, probably in news reports, may not find out in court. I'm hoping we'll find out more about this juror that was dismissed and whether, in fact, she was, or he or she. I'm assuming it's a she because I saw a female on the camera this morning. On what they were doing when it came to doing their own investigation at the Waterfall Bar. That's a problem. You know, if you have jury misbehavior that it reaches a high level, then you could actually have a mistrial. And think about it on a mistrial for this one, folks. A mistrial would mean that the state has to dismiss the case, or the case is dismissed. The state will have to go back, refile the paperwork. In some states, you even have to go back to a grand jury to go through the whole grand jury process again. It will set this case back 2 years. Then they'll have to get their dates in court, come back to court. You'll hear the same series of witnesses, and the state may have learned something here and there, but you'll see the same series of witnesses hit the stand again and tell this whole story over again to a brand new seated jury. So that would be shaking if that happened. Of course, it sounds like that's not what happened in this case. They dismissed the juror. They've got the alternates there. Another way that can happen is that they don't have enough alternates, and you have enough misbehavior by the jury that gets so many people dismissed that you don't have 12 people to sit on it. That would also be a mistrial. So interesting, very interesting.
Yeah, I caught the tail end on Fox News this morning, and they were talking about Trooper Proctor and some of his text messages, and got quite the commentary from the Fox News early morning cast. They were shocked.
Well, yeah, what'd they say? Give us what was their opinion?
Well, they were. I mean, they were basically saying, you know, this is, and like we've said, you know, since he started opening his mouth, this puts law enforcement as a whole in a bad light, because people are already looking for a reason to blame law enforcement for anything, and then you've got, you know, a supervisor type law enforcement officer with a state agency talking about a defendant like he was talking about, you know, disparaging comments, and you know how they can even, or how the jury can even take his testimony as truth. You know, if he's you know drawing her in the light that he's drawn her. So I think they're, you know, I don't know how much they're following the trial, but I kind of got the impression they're kind of they're talking about the same things we are. It's like, you know, this is not professionalism by no means. The way they've handled the case, you know, is it handling the evidence incorrectly? Just the whole 9 yards that we've talked about. They're basically echoing that same concern.
Now, I think it's a problem for anybody to hear that out of a lead investigator, especially on a murder trial. But I think any investigation is that that they have a bias towards the defendant, because we want to believe that our judicial system has some integrity, and that the officers that are involved in, I'm just not law enforcement, but the court officers, which are any attorney that practices in that courtroom, are officers of the court. We want them to act in fairness, and we want them to pursue the truth. When it comes across where the truth doesn't matter, I just need this person in jail, or whatever means I can get them there is the way I get them there. I think that leaves a bad impression in your average person's mouth. Folks, I've got on the screen now, if you're watching, I've got the Range Minded Podcast latest patch. And I believe this is Perry, the beaver there, is looking pretty suspicious. That dangerous and unusual. Stickers and magnets, I believe. But hit Range Minded Podcast up on his website, and he can get you hooked up on those. They're not real expensive, but they're very unique, and he keeps a fresh batch of these things coming in. So follow him, keep up with that stuff. If you like patches, you like stickers, Range Minded's got you covered. But that's the sticker, I believe, Perry sticker that Vet's talking about. They got stuck on his gun safe this morning. Dangerous and unusual, probably fitting. And it sounds like Kingdom's telling us that it was juror number 3 that was dismissed. I think just juror number 3. So I guess that's juror number 3 was dismissed. And I'm corrected by James that it's Perry the Platypus. Excuse me. Perry the Platypus, dangerous and unusual.
Well, I'm glad to see that Kingdom's keeping up with Turtle Boy today.
Well, no, he is our first go-to for anything Turtle Boy. All Turtle Boy, all the time. So, if Turtle Boy says it, you can take it to the bank.
Yeah,
If that agrees with me, my assessment was right. I'm batting 1,000 today. Very fitting for me. He is dangerous and definitely unusual. Yeah, Bet, we know. You're a co-host on Night Court. We know you're definitely dangerous and you're pretty unusual. We love you, brother.
So who do we know who's going to be on the stand the rest of the day, or who's up there now?
Well, yeah, you've got a Michigan, not a Michigan. You've got a Massachusetts state trooper that's testifying, who's a crash reconstruction certified specialist, and he is going over drone footage that he's done that essentially maps the scene, shows you where the body was, where the shoe was, where the glass was, all the stuff that, by God, we should have seen from this crack search team that came out there that night. They should have mapped that out, laid it out, and it should have been memorialized from the very first day, not some days later when there's no snow on the ground, as you see from the photographs. Those are the original drone flies on this. So I don't know when this was done, but it absolutely wasn't done near the time of the accident. And quite frankly, with the way that the first investigators went out there and memorialized that crime scene, I'm not sure that I can trust when he says the shoe was 10 feet away. Let's don't forget the lieutenant over that unit says, well, when he presented his data on his cell phone, essentially was a Google Maps. All evidence, body, everything included into this case was in one red dot. And his explanation was, it's plus or minus 16 feet. So taking all that into consideration is if he used that data to reconstruct this crime scene, I think it's all bullshit in the first place. So I don't know how much we're going to get out of this. He did talk about pulling some information off of the Lexus smart box, for lack of a better term. The actual name of it, I can't recall at this moment, but it's essentially a black box that's on modern vehicles. Different manufacturers can get different types of information, some more, some less. We're thinking a Lexus probably has some of the best in it as far as technology. But he did talk about hard brakes, whether the vehicle came to stop on its own or whether it hit another object that stopped it. He did talk about that, but didn't give any indication that any of those sensors or triggers were found in the Lexus. I believe there are some of these devices on vehicles that can tell you vehicle speed and vehicle direction. And braking, especially hard braking, would come up as an event that would be recorded on these recorders on vehicles. But I haven't heard him mention that yet. To me, that would be damning evidence for the defense if they could say at 12:31 a.m. on the 29th, this vehicle moved for 61 feet in reverse. The gear was in reverse. The vehicle would know that. 61 feet at 24 miles an hour, as the state alleges. If it said that, then this would be a very difficult case for the state. I mean, for the defense to overcome. But we haven't heard that out of him yet, so I don't know that he's going to bring it. He seemed to have jumped into his subsequent drone surveillance of the area, giving us an overhead with some little dots and some little lines, and still yet a very poor graphic for the jury to analyze to see exactly what he's showing. But either way, He's just showing where the state alleges the body was, where the state alleges the shoe was, where the state alleges the broken glass was. I haven't seen anything on the tail light pieces, but that may be coming up next, and maybe he's mapped those out. But I questioned that, to be quite honest with you. If the guys on the scene, that when they started picking up evidence, that picked up the shoe, that picked up the body, removed the items he's talking about from the crime scene, if they didn't document exactly where that's at with anything more accurate than a plus or minus 16 feet, then everything he's got is conjecture and guess in the first place. My opinion.
Yeah, I agree. So on the talking about the vehicle data, I call it an ECM, electronic control module. So I was reading, and I believe it was on all higher end Lexus models. So you've got the sensors in the bumpers that basically tells the computer that there's enough force to activate the airbags. And I don't remember what the speed was or how that was calculated. Say, yeah, you need to activate the airbags. Poof. But what I did read was that they would be able to tell, like a speed range that she would be going, like either say, let's just say 0 to 20 mile an hour or something like that. That the electronic control module would actually tell them how fast she was going in that period of time before the sensor detected some kind of a resistance, I guess you could say, if that makes sense. So I guess if it was there, that he would have testified to that.
To answer your question there, John, 8 to 14 miles an hour is the minimum that's required to activate an airbag if it hits a stationary object of similar size, 16 to 24 miles per hour or higher. So 8 to 14.
Oh, okay. Well, thank you there, Ron.
Well, I think it also depends on what it encounters. It depends on how formidable the object that it strikes, but also it depends on where it strikes it. If you're backing up at 10 miles an hour, or you're driving forward at 10 miles an hour, and you hit some low hanging bridge at the windshield, I don't know that your airbag sensors are going to detect that. I think it's a bumper contact or where these sensors are at. Am I wrong about that?
No, I don't think you are. The NTSB, I think it was the NTSB, specifically says, I'm sorry, it's the National Highway Traffic Safety Administration, specifically points out the front bumper that does have impact sensors in it that have to make contact at those speeds to get the airbags to deploy. With newer cars, which hers would have been, do have sensors that will act for side curtain airbags, along with rear impact airbags. I'm not sure how that would work with windshields, though.
Well, and I talk about the tail light. Once again, we don't really see any damage on the bumper area of her vehicle. The only damage seems to be around that tail light area. And if you go with the state's assertion that she did this, and you believe that, there's many ways of many positions that O'Keefe could have been in when he made contact with that vehicle, that he could have avoided the making contact with the bumper, and in only being struck in the upper part of his body, i.e., the head. It is possible. There are scenarios that would make that possible, is what I'm saying. And folks, on the screen again, Range Minded actually just sent me a DM of some better photographs of his little swag, his stickers and magnets of the Range Minded podcast, and Perry the Platypus, the unusual and dangerous. So once again, if you're interested in any of that stuff, hit him up at rangemindedpodcast.com, and he will get you taken care of. He would be excited to do so.
All right, I'm going to jump off of here and give me a few minutes, and I'll jump on the PC.
Yes, sir. And we are monitoring the feed. We are not back yet. Still just looking at a blank screen there for the court. We're not even seeing a ceiling fan yet. And James is saying basically detecting a change in the impedance in the metal when it deforms, that is how it deploys on side impacts. So a little information on how that side impact sensor works. But once again, I don't know that even moving at 24 miles an hour and striking a person, that you would have those sensors go off in the area that the state is alleging that this impact occurred, if that makes any sense. And you also, if the tail light was the only thing that connected the dude, then it would be possible. It would be possible to hit fairly hard without deploying airbags because it wouldn't deform the frame hitting a body. Um, it sounds like we agree, James. That's my assessment as well. That it's possible for this to have occurred. I guess is what I'm saying, without these sensors going off. So the fact that there's not a sensor signal or sensor record recorded doesn't mean it didn't happen. It just doesn't support that it did happen as well. Once again, I think if this guy doesn't come with some actual, the data says empirically that the vehicle moved in this direction at this speed at this time, I think this guy's testimony is just a bunch of blah 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 at this point. I don't think any juror sitting on the fence is going to be swayed by it, and any juror that's sitting on their proposed side of the fence, whether not guilty or guilty, I don't think this is going to sway them either. Folks, I'm going to put the live screen up. You just can see the court screen, blank screen, while we wait for this to come back. I'm going to step away, grab something to eat real quick. Big Ron, you can throw in some commentary with the questions if you like, but we may have just a little bit of silence here for a few minutes. Get some nourishment in us.
Gotcha, buddy.
There you go, folks. We should see that pop up with. Well, I don't know if we're going to see the ceiling fan or not. They played around with the cameras. It looks like we're back at the old view, but I'm not sure what they're going to come back with. But when they go live, we'll get it live here. By George, there's the ceiling fan. Okay, for real. I'm stepping away for a few minutes. I'll be back.
Are you arguing with yourself, Q? Actually, what you're saying is a possibility. It could indicate a higher velocity than what was done if it's taking the speed off the transmission itself. So if the transmission thinks that the car is going faster due to the transmission spinning, that would not accurately indicate that the car was moving at that speed, unless it's taking, if it's a rear-wheel drive car, the speed off the front tires, where there's no input from the transmission or the drive shaft. I completely agree with you on that, Q. Unless they specifically specify that wheel transducer is what's reading it off the front tires, where there's no input from any kind of a powered device from the car, then I'm with you. That the transmission could be saying that they were doing 30 miles an hour, and that very well could just be the tires spinning on the snow, and they may have only been moving 3 or 4 miles an hour. So that would be a question I would definitely dig into. That's a really good one there, and we'll see if old Alan Jackson gets that on down the Chattahoochee if he's going to dig into that.
Thank you. You can see it goes back.
Looks like we're coming back, Joe.
Afternoon, Trooper. All right, Mr. Lally, whenever you're ready.
Your Honor, with the court's permission, may we have exhibit 587 back up on the screen?
Yes.
And this gentleman, that's the drone image. Trooper Paul, directing your attention to what's up on the screen that's now been marked as exhibit 587. Again, this is the last in the set of 4 diagrams or drone images that I presented before you before, correct?
Correct.
Now,
Hey, Range, to answer your question, like we were talking about earlier, I don't know if you caught that. A lot of newer cars use a speed sensor inside the transmission casing to sense the direction of the car's movement, depending on which direction the transmission's spinning. A lot of it's not used by transducers in non-powered wheels.
That's correct.
Now, with respect to this particular area of Fairview Road, understanding that you were there in the daytime, correct?
Yes.
However, when you were there in the daytime, what, if any, note did you take as to sort of overhead lighting or available sort of ambient?
I think you're right, Q. I think my Charger uses a combination of wheel hub sensors
on the top
and transmission
corner, I'll try to,
but I'm not exactly sure off the top of my head.
There's a light pole right there, overhead light pole.
And with relation to where you've marked as far as the final rest position of Mr. O'Keefe and the other areas of items of evidence that were recovered from the scene, was there any lighting in that particular area?
There wasn't.
Ms. Gilman, you can take that down. Mr. Officer, we can have lights back. Thank you very much, sir. Now, turning your attention, sir, back to February 1st, 2022. At some point, you were at the Canton Police Department, correct?
Yes.
And where specifically within the Canton Police Department did you go?
To the back in the garage area.
And within the garage area, what if anything did you do in the garage area?
In the garage area is where we imaged the airbag control module.
And so, I'm sorry, it's fair to say the vehicle, the defendant's vehicle was located in that garage area?
That is correct.
And you imaged that vehicle, and what, if anything else, did you do with respect to that vehicle that day?
At that point, we just analyzed the damage to the vehicle.
Now, at some point, did you perform any sort of mechanical inspection of the vehicle?
Yes.
And was that day or at some later?
It was that day.
And was that within the garage area itself, or where did you perform the mechanical inspection of the vehicle?
We analyzed a little bit of the the steering and the brake pedals while it was sitting in the garage. Then we did testing with it on the in the driveway next to Canton PD.
Now, sir, starting with a visual inspection of the vehicle. Your Honor, may I approach?
Yes.
I'm showing you 2 photographs. I ask you to just review those, look up when you finish.
Yep.
Do you recognize those?
I do.
And what do you recognize those to be?
They are crime scene photos that I've attached to my report.
Your Honor, the Commonwealth is seeks to introduce and admit as the next 2 exhibits.
Objection, Your Honor. Thank you.
Yep. Sorry.
Thank you.
Your Honor, may I return those to the witness?
Yes.
And Your Honor, with the court's permission.
Yes.
Thank you. One moment, Your Honor. And Trooper Paul, do you recognize what's up on the screen right now?
Yes, I do.
And what do you recognize that?
That's one of the crime scene photos that I attached to my report.
And what's contained in this, is that a fair and accurate portrayal of sort of the front of this vehicle, looking at it from the passenger side?
Yes.
And Douglas Gilman, if I could have the,
Looking to see if there's any sensors in that front bumper. I know I've got a K-band radar in my front bumper that would sense, and I've got small K-band
yes, I do.
sensors in my back bumper. And I'm not
That's
seeing.
the crime scene
It looks
photo
like there may
that I
be the
attached to my
K-band
report
sensors there
with
on the round
notations that
portion
I
of the
made
bumper.
on it.
and what's contained in this photograph, is that a fair and accurate portrayal of what you observed in the rear passenger side area of the defendant's vehicle in the garage on February 1st?
Yes, it is.
Now, step back a little bit here. With regards to what you've noted within this, if you could, using the laser pointer before you, just direct the jury's attention to what, if anything, of significance you observed in your inspection of this area of the Lexus.
Okay. So on the left side here, I put down that scratches, and there's a dent there. The broken tail light here was here. There's some scratches on the bottom right rear bumper here. And there was glass from a cut back on the bumper.
As far as the glass on the bumper, what, if any, observations did you make of that in relation to the vehicle itself?
Yeah, it appeared to be from a cup as opposed to any glass that came from the vehicle.
Objection. So I'll strike the first part of the answer, but the second part will stand.
I have no objection to the second part. Thank you.
Now, with regard to the dent that you've delineated within this photograph, did you take any measurements from the ground as to where that was located?
Yes, I did.
And how far did you measure the dent to be approximately from the ground?
Approximately 48 to 50 inches from the ground.
And what, if any, measurements did you take as far as from one part of the vehicle to the other, as far as where the dents were located?
Yeah, so it was approximately 19 inches from the right side of the vehicle.
Now, the scratches that you were talking about before, where were they in relation to the dent?
Right above the dent. I can see right there. As my hand's shaky.
Now, as far as you obviously also made observations of the driver's side tail light as well.
Yes.
And so, from what you observed of the driver's side tail light versus the passenger side tail light, what, if any, observations did you make as far as the color of the pieces that you found missing from the passenger side tail light?
As compared to the left side of the tail light?
Yes.
So on the left side of the tail light, there was red and clear plastic pieces.
Now, the scratch marks along the bumper, did you take any measurements with relation to them?
Yes.
And specifically, did you take measurements from the ground to where they were located?
Yes.
What did you measure those?
They were approximately 27 to 28 inches from the ground.
Thank you, sir. Mr. Gilman, you can take that down. Now, Trooper Paul, we can talk about a mechanical inspection of a vehicle just first in general terms. What is it that you're doing with respect to the vehicle in order to conduct that mechanical inspection?
So when we do mechanical inspections, we're obviously checking the steering, make sure the steering moves properly, the brake pedals, make sure they are firm, make sure the accelerator pedal moves back and forth. Just generally looking at the tires, make sure there's no issues with the vehicle.
And what, if any, observations did you make of the vehicle itself as far as any defects or anything to do with the braking, the tires, or any of the other areas that you expect?
We didn't observe any mechanical defects with the vehicle.
Now, with relation to the weight of the vehicle, what, if any, analysis, or what, if anything, did you determine as to the weight of the Lexus?
The way the Lexus item was on an analysis was just based on I think I have the gross vehicle weighting for the vehicle.
And how much did the vehicle weigh according to the gross weight?
I think it was approximately 7,000 pounds.
Now, with respect to the lights of the vehicle and being the tail lights and the headlights, what, if anything, did you determine those to be as far as what type of lights were they?
They were LED. Both they were headlights and taillights were both LED.
And if you could just expound a little as far as LED lights, what if any significance does that have to you, or what kind of lights are LED? How bright are LED lights?
LED will most comparison to what most people think in car and tail lights, where I have the bulbs, where they have the filaments. LED is more electronically controlled. They sense, there's a sensor that will light up, as opposed to a bulb type headlight and tail lights.
Now, are you familiar with an organization called NHTSA?
Yes.
And what does NHTSA stand for?
It's the National Highway Traffic Safety Administration.
And what, if anything, did you do with regard to NHTSA in respect to this vehicle itself?
We run the vehicle through NHTSA to see if there's any recalls on the vehicle.
And what, if any, recalls did you discover when you ran this particular vehicle through NHTSA?
There were no recalls.
And to be specific, we're talking about this specific vehicle as opposed to just Lexuses in general, make and model, correct?
Correct. Yeah, we put the VIN into the system, and it will tell you if this vehicle has any recalls to it.
Now, you indicated on February 1st at some point you did some testing with the vehicle. Is that correct?
Correct.
And where was that testing done, and what did it consist of?
It was done in the parking lot of Canton PD on the same day. We did a forward braking test, a reverse braking test, and a reverse acceleration test.
Now, the parking lot of the Canton Police Station where you did this, what kind of roadway surface was that?
It's an asphalt surface.
So similar to the asphalt surface at 34 Fairview Road, is that correct?
Correct.
And what was the condition of the roadway as far as how dry or wet was the roadway when you conducted these acceleration and braking tests?
It was wet at the time.
And with respect to your understanding of January 29th, 2022, with the asphalt surface in front of 34 Fairview Road, what was the condition weather-wise as far as that roadway surface at the time of this collision?
At the time of the collision?
Yes.
Well, I understand it was snowy, so the asphalt road had been fairly wet from snow.
Now, when you conducted these acceleration and braking tests with the defendant's vehicle, what, if anything, what, if any, tool or what, if any, implement did you use in the course of that testing?
We use a device called it's called a V-Box. This one's a V-Box Sport. The device is attached to the windshield, and then it's also attached by an antenna that goes to the roof. And then basically V-Box, do you want to explain what V-Box is?
Please.
Okay. So a V-Box is just, it measures performance for the vehicle. It uses GPS data to measure the speeds and its location. And use that it'll give us how fast we were stopping, a drag factor for the roadway for that specific vehicle and type of road, and acceleration factors. So we attach that to the windshield, just kind of give me a way to check its acceleration and check its performance.
And sorry, you're on one moment.
Sure.
So the V-Box is attached to that vehicle. So it's what specifically is it measured?
So yeah, it's using the GPS data to apply its location, and so it's measuring its speeds and using the speed and the location, putting that together. And once you use the app through the V-Box, and you set certain parameters as like you can go, I want 30 miles per hour, 20 miles per hour, 10 miles per hour, and it'll set your vehicle. So when you go to 30 miles per hour, it'll tell you what you're doing at 30, what you're doing at 20, what you're doing at 10, and then it'll know if you're doing braking or acceleration tests. And it'll use those numbers that you have to give you, your acceleration factor or braking factor for the vehicle.
So from the V-Box Sports device that you use, and you've received training as it applies to using that device?
Yes, I have.
And certification as well?
It's usually just training on it.
Now, with respect to the V-Box Sport as it's attached to that vehicle, that's measuring specifically from that vehicle with those tires on that roadway surface that day, correct?
That's correct.
Now, with regard to that testing on that day, you did some acceleration or reverse acceleration tests, is that correct?
Correct.
And how many of those tests did you conduct?
2.
And you describe to the jury sort of how you conducted those tests or what speeds you were using or sort of that process of the 2 reverse acceleration tests that you conducted that day.
So the reverse acceleration test we conducted, we set the parameters up to 25 miles per hour. So what we did is we try to come from a stop at 0 and then press the accelerators all the way about as hard as I could press it and try to go back and see how fast I can get to 25 miles per hour and see what the performance it did at that time.
And what, if any, kind of data did you receive with the V-Box Sport using during those 2 reverse acceleration tests?
It gave me an acceleration factor. It gave me its speeds and times and distances that it was at each location.
And if you could explain to the jury, sort of when you say acceleration factor, what is an acceleration factor?
It's just a number of how fast a vehicle could travel from an acceleration. And it could be a light acceleration to a medium acceleration, a hard acceleration. They all have a different number that you can use to kind of relate it back to what the acceleration is for that vehicle.
And what was the acceleration factor that you were able to obtain with those 2 reverse acceleration tests?
I believe this was I had 0.317, I believe.
Now, during the course of those the reverse acceleration tests that you conducted on that day, what, if anything, did you know? Well, let me ask you this: as far as the operation of the vehicle, who is actually physically operating the vehicle?
I was actually operating the vehicle.
And what, if anything, did you know during your operation of that vehicle during the reverse acceleration test that you conducted?
We also noted the accelerator pedal moved freely. There was no binding. There were no interference from anything on the floor. Nothing interfered with the accelerator pedal. It worked as it's supposed to.
And when you're doing this reverse acceleration test, how are you, if at all, are you manipulating the steering wheel at all, or is it a straight line test, or how is the test? How is the vehicle directed during the test?
So I try to keep it fairly straight.
And when you accelerated in reverse in a fairly straight fashion with the steering wheel, what, if anything, did you note about that?
They kept the vehicle fairly straight. It was fairly easy to keep control of.
Now, in addition to the 2 reverse acceleration tests, what, if any, testing did you do with regard to reverse braking?
Yeah, so we conducted 2 reverse braking tests.
And again, similar, can you describe to the jury, this is also with the V-Box Sport attached, is that correct?
Correct.
So you're obtaining data from that as well?
Yes.
And during the course of the reverse braking test, what, if anything, first as far as data is concerned, how fast were these tests being conducted? What, if anything, was input, and what, if any, data did you receive from?
Yeah, so the reverse braking one, we try to get up to about 30 miles per hour. And then once we get up to that speed, that's when we apply the brakes, try to brake the brakes fairly hard to try to get the vehicle to stop.
And are you also familiar with the term known as a deceleration factor?
Correct.
And can you explain to the jury what that is?
It's just essentially the opposite of an acceleration factor. This is a number for how fast the vehicle would slow down.
And with regard to the deceleration factor from the 2 reverse braking tests that you conducted on that date,
Joe, you back yet?
What figure did you receive from the instrument from the V-Box Sport?
For the reverse braking?
Yes.
I believe this one was it gets you a drag factor number for this vehicle too, and it's our deceleration factor, which is both are used the same way. This one, it was I think it was 7.1.
Now, with regard, again, you're operating the vehicle during these 2 reverse braking tests, is that correct?
Yes, I was.
And what, if anything, did you note in regard to the operation of the vehicle when you were conducting these 2 reverse braking tests?
Yeah, the brake pedal was firm. There was no pulsation from the brake.
Now, in addition, sir, were you able to conduct some forward braking tests?
Yes, I was.
And similar again, could you describe to the jury as far as how you were operating the vehicle during the forward braking test?
Yeah, it's essentially the same thing as reverse. If I was going forward this time, I got up to 30 miles per hour, and I would just apply the brakes about as hard as I could apply them till it stops.
And again, are you receiving from the instrument some sort of deceleration factor?
Yes, I was.
And do you recall what that was?
Yeah, it was a 0.69.
And during the course of your operation of the vehicle during the forward braking test, again, what, if anything, did you note in regard to the operation of the defendant's vehicle?
Same as before, that brake pedal was firm. There was no pulsation, no issues.
Now, you talked a little bit about a ACM or an airbag control module, correct?
Correct.
You indicated earlier in your testimony that you had downloaded information from that. Is that correct?
Yes.
Now, when you download that information, what, if anything, do you get from the vehicle, or what, if any, how are you able to sort of read or interpret that data?
So in the airbag control model, it's equipped with it's called an event data recorder on EDR. And then that data from the EDR, we will use the Bosch CDR software and will attach to the vehicle. And then that software will basically extract the information or image the information that's in the module. And so that information could range from getting us speeds, if it was braking, if there was, steering wheel movements, basically like looking for change of velocity, that type of, so there's a lot of, information around the vehicle.
May I approach you?
Yes.
Showing you the document, sir, 7 pages in length. Just ask you to review that when you're finished.
Okay.
Do you recognize that document, sir?
I do.
What do you recognize that to be?
This is the document that gets printed out through from the airbag control model through the crash out retrieval software.
Thank you. May I approach again, Your Honor?
Yes.
I'm up to seek to introduce the minutes in that exhibit.
No objection.
Exhibit 590.
Now, sir, when it comes to the CDR printouts, or let me ask you this. When it comes to the airbag control module, who is that designed to protect or to apply to in respect to safety measures with vehicles?
Applies to the occupants inside the vehicle.
And this may sound a little terse when I say it, but essentially the airbag control module is typically not designed to protect people on the exterior or the outside of the vehicle, correct?
Correct.
Now, you've been involved in a number of crash investigations involving pedestrians, correct?
Yes.
And as far as this particular case, what, if any, sort of useful or significant information were you able to interpret or retrieve from the ACM?
And this through the software, there was no data recovered or no events recovered.
And when it comes to pedestrian crashes in general, and as far as there being no data in this case, is that something that's abnormal?
It is not.
Explain to the jury sort of why not.
So what an airbag control module is doing, as it's running, it's constantly monitoring the vehicle. It's looking for like a sudden change of velocity, and like a collision. So once it feels that sudden change of velocity, essentially will wake up and monitor the vehicle, see if there's people wearing seatbelts on, what's the speed of the vehicle, number of different things that it could look for. And all it wants to do is either do I deploy the airbags or do I tighten the seatbelts? So most motor vehicle crashes with a car-on-car crash, there will be a higher change of velocity. So that's usually kind of what it's looking for. Pedestrian crashes are there's not going to be much change of velocity to the vehicle. That means when they both interact with each other, the pedestrian is not going to change that vehicle's velocity in such a quick manner as, say, two cars would strike each other.
Now, with respect to crash reconstruction in general, are you familiar with a term called delta V?
Yes.
And can you explain to the jury sort of what that term means as far as what is a delta V and what is it measured?
So that's kind of what I was saying about the change of velocity. It was a change of velocity. And I mean like change of velocity, like it's also going to be within a certain amount of time. So change amount of speed within a certain amount of time. So,
And with respect to the vehicle as it applies to crashes or collisions involving pedestrians, and I think you've said a little bit about this, but what, if any, impact on the velocity of the vehicle would striking a pedestrian typically have?
very little.
Now, specifically when it applies to pedestrian collisions in general, are you familiar with the concept of linear momentum?
Yes.
And can you explain to the jury sort of what that is and how it applies with pedestrian crashes in general?
Linear momentum. Momentum is essentially when two objects interact with each other. They come in with momentum and they leave with momentum, with essentially the same momentum. And linear momentum just means something that's in line with each other.
Now, as far as we talked a little bit earlier in your testimony about roadway evidence, when it comes to your experience with pedestrian collisions, what, if any, relationship does that linear momentum have in relation to roadway evidence that you would expect to find at a scene of a pedestrian collision?
So when a pedestrian strikes a vehicle, they will go in the direction where the vehicle was traveling. So if the vehicle is traveling one way, the pedestrian strikes, it will go essentially that same way, depending on what part that vehicle strikes.
Now, as far as other items that the pedestrian may either have in their hand or other items of looser fitting clothing, what, if any, experience do you have as far as observations of those on collision scenes involving pedestrian collisions?
Yeah, so it's not uncommon for pedestrians to lose essentially any sort of loose clothing. So shoes, belts, hats, anything that's not very strapped on very well, could leave the body.
And as far as directionality is concerned, when it applies to that linear momentum that you were speaking of before, those sort of loosely held or handheld items, or would glasses be included within that as well?
Correct.
So those types of items, as far as directionality is concerned, what, if anything, can you tell the jury about that?
Yeah, so they will go in the same direction the pedestrian travels post-impact. We usually use that as kind of a post-impact path of travel for the pedestrian, showing that this is the direction that they would have traveled from where they got struck.
Now, are you also familiar with the reconstruction terms known as area of impact and point of impact?
Correct.
And can you explain what those terms mean excuse me, in a crash reconstruction context for the jury?
Yeah, so an area impact is essentially the area where the crash happened, where these two vehicles or vehicle pedestrians, where their initial impact happened. Point impact is the same thing. It's just more down to like that specific point at that specific area. Area can mean a little bit broader in that sense.
And what are some of is this something that is delineated somewhat, at least by roadway evidence?
Correct.
And if you could describe to the jury sort of what types of roadway evidence that would lead you or any crash reconstructionist to formulate an opinion as to the area of impact?
Yeah, so like I said earlier, with the path of travel, so a lot of collisions most of our collisions, we start where the final rest goes, and we follow the debris or the clothing. We're back to where, follow that path back to where it came from. And we know within that area, that's where an area impact would be.
Now, with relation to the evidence that was depicted on the diagrams that were up on the screen before as the exhibits, what, if any, relationship would the taillight pieces and the shoe that were recovered from the street in front of 34 Fairview Road have in relation to that area of impact?
Yeah, so they were found alongside the roadway. So I know that they were found, the area impact had been somewhere within the roadway and probably somewhere at the beginning, just prior to the beginning of the first point of evidence that we found.
So somewhere towards the first point of evidence contained within that debris field, is that correct?
Correct.
Now,
Yes.
Now, sir, are you also familiar with a safety system specifically applicable to Lexus vehicles?
Yes.
And have you seen training in regard to downloading information in regard to that as well?
Yes.
And what is that safety system? What is that called?
It's called the Toyota TechStream software.
And so the Toyota TechStream is a software similar to the crash data retrieval or CDR software that you're talking about, but just specific to a Lexus.
Yeah, but it's between Toyota and Lexus has software. The TechStream it's similar in the fact that they both record data to the vehicle. TechStream was created by Toyota for their technicians to diagnose vehicles and use that information to help, any kind of mechanical issues that they would have with the vehicle that they can do when you bring your car to them. They can look at the TechStream and just kind of find out what caused the mechanical issue.
Now, with respect to the Toyota TechStream data that's available, what kind of data are we talking?
So TechStream, yeah, they also the diagnostic stuff. So they're looking for any engine defaults or anything else. But they also have what's called a vehicle control history in it.
Sorry, I missed that. Called what?
A vehicle control history.
Thank you.
And the vehicle control history it's basically monitoring people's driving behavior. So it has certain, they call it triggers that they have listed. And when those triggers are met, they will record data related to that trigger.
And what type of data, in general terms, what type of data are you able to recover through the Toyota TechStream?
Dante, I don't think it had colored bulbs. I know my car's got
so
LEDs
each trigger
in place of incandescent.
It's the same as the
and my front lights are projection.
Brakes.
So I think that may be what he's going at. Is that the tail lights were LED bulbs, not colored bulbs.
Engine RPMs, all that type.
I looked that up the other day. The replacement bulbs for that model, and they're clear.
Now, in addition, is it possible?
But are they LED or are they incandescent?
Vehicles that have
they are from the
made,
factory. They are
accessible to
incandescent.
Toyota TechStream.
Gotcha. Well, there's your answer there. Then he may be.
So Lexus
might be misremembering.
That's
is
correct.
The proper way to put it.
But
I think my car's LED in the back, and I'm gonna have to check that now.
Lexus vehicles are made by that manufacturer, are equipped with.
I think that model was a 2021, if I'm right. Now I may be wrong, but I thought it was a 2021.
What, if anything, in relation to the camera system, is it possible to collect from the vehicle controllers?
The camera systems in certain vehicles can record photos, like little grainy black and white photos.
And were you able to recover any black and white photos or photos of any kind from the defendant's vehicle in this case?
I was not.
Now, with respect to the sort of physical process of the downloading using this Toyota TechStream tool, can you explain to the jury sort of how that's physically done or what you're doing to the vehicle in order to download that information?
The same process, just different software as we would for the airbag control module. As I said before, we plug into the DLC port and then up that software program, and we follow the steps and we extract the information from the vehicle.
Now, the extraction of the Toyota TechStream data in this particular case, when was that accomplished?
For this one, I believe it was February 2nd, 2023.
So a year and a day after you had conducted the braking and acceleration test and inspected the vehicle in the Canton Police Department garage?
That's correct.
And so as far as the timing of that being February 2nd of 2023, why was that?
I was at the time of my initial inspection, I didn't really know much about TechStream at that point. So over time, I kind of learned about TechStream. And so once I learned about it and I thought, is this relevant to our case? And I looked more into it and found that it is relevant. So.
And the Toyota TechStream, as far as that applicability or that tool, is that a relatively newer tool in the area of crash reconstruction?
It is getting fairly newer, as in it's getting spread out. It's getting bigger. It first got created on one vehicle in 2014. So it's been slowly trickling into the Toyotas and Lexus vehicles over time. But it's definitely gotten bigger within the past couple of years.
Now, with regard to this information, when you were then able to download that information, you received some data. Is that correct?
That's correct.
And you mentioned that it goes, or it's measured sort of by triggers. Is that correct?
That's correct.
And from the data that you were able to obtain from the defendant's vehicle, what type of data were you able to retrieve as it relates to the vehicle control history?
Yes. So, I mean, this had like a page and a half full of triggers that over the vehicle's time span that it captured.
And with respect to the triggers, how many triggers did it capture?
It's like a page and a half. I don't know exact numbers of how many triggers that was on each page, but there was, it's at least a good page and a half full of triggers.
Your Honor, may the trooper refer to his notes in regard to that?
I agree with Dante, unless he's about to get into some specifics of things that happened at 12:30 a.m. on the 29th. I think this guy's a nothing burger.
But he's said a lot of words.
A lot of people say a lot of words. It doesn't mean that those words have significant meaning.
Right.
And how many triggers was it, sir?
Can we count them?
Does he have to count them, Mr. Lally?
No, I don't think he has to count them. Sir, if I could direct you to paragraph 23.
Oh, yeah. So 22 separate triggers. So on my report, it says 22 separate triggers that occurred on odometer mileage 12665 to 12666.
And with regard to the mileage that you noted as far as being between miles 12665 and miles 12666, that's 12,665 to 12,666, correct?
Correct.
And what was the mileage that you observed on the vehicle at inspection?
12,665.
And at the time that you conducted this Toyota TechStream download from the vehicle, what was the mileage at that time?
12,666.
And there's also reference within the vehicle control history data in regard to something called a key cycle. Is that correct?
Correct.
And can you explain to the jury sort of what a key cycle is and what are the different things that could trigger a key cycle?
Key cycle is essentially, so it's from the ignition cycle. Let's take a step. Here. So a key cycle is essentially from when the vehicle's off, it's pressed on. It doesn't necessarily need to be running or turned on. It just needs to be turned on and then off again, and that would be one key cycle.
Now, with relation to your analysis in regard to the vehicle control history, what, if any, role did the key cycle numbers, or what kind of role did that play in your analysis?
It shows me where how far away they were from each other. The key cycles were.
And how far away in what terms?
So when I turned the vehicle on, when I did my testing, it showed me what key cycle was that I was on when I did those testings, and then the odometer mileage in relationship to that.
Your Honor, may I approach?
Yes.
If they've got vehicle data that shows reverse at 61 feet and 24 miles an hour, and they're taking this slow to get to it, that's
And do you recognize that, sir?
ingenious.
I do.
And what do you recognize that to be?
That is the table from the vehicle control history from my report.
And Your Honor, may I approach?
Yes.
I'm off to seek to introduce in the minutes of next exhibit.
No objection, Your Honor.
Okay. Exhibit 591.
Your Honor, may I have a moment and then return it to the witness?
Yes.
Your Honor, with the court's permission, if I could ask to publish this to the jury. Now, Trooper Paul, what's up on the screen? Is that the exhibit that you have before you?
Yes, it is.
Now, if you could, using the laser pointer before you, just direct the jury's attention to what we're looking at in this exhibit and what type of information and where it's located within this exhibit.
Okay, so this is the vehicle control history. Every single point here, this is where the triggers are. This is the labels for each trigger. Odometer mileage is on this label here. These are the elapsed time and key cycles. I have noted through arrows here, these were when the vehicle was with us, and a lot of this is related to my testing with the vehicle. And these right before that were the triggers that were prior to those testings.
Now, from the within this table, sir, there are two triggers recorded at odometer mile 12,629.
Yes.
And what's the key cycle associated with 12,629?
1,162.
Now, these triggers that are contained as far as the 12,629, that's prior to the.
You have to either come closer.
Everybody's having trouble hearing you, Lolly. Come on. This has got to be every day.
There's no microphone near you. That's the problem for the court reporter.
My issue is, Your Honor, there's no light over here.
All right, so let's turn the light on and then you can ask your question, then we'll turn the light right back off, please.
Thank you, Your Honor. My apologies.
I agree
So
with
that
Dante. I hope this gets spicier.
Odometer mile as far as two triggering events at 12,629, correct?
Yes.
And that occurs prior to the 12,665, 12,666 during the course of your braking and acceleration test, correct?
Correct.
And the mileage difference between those two, did you do that math?
Yes.
What was the mileage difference between the two?
36.
And how many key cycles were different between your testing and that odometer reading of 12,629?
2 key cycles.
Now, as far as the, what if any information did you have and where did you get it in relation to the defendant's vehicle's path of travel prior to those odometer readings that you noted when you did your
Yeah, so yeah, I was told that where she traveled afterwards or prior to that. I was noted their locations, and I used those locations through Google to get a mileage for them.
May I approach her?
Yes.
Showing you another document, sir, do you recognize that?
I do.
And what do you recognize that to be?
Those are the Google directions. I put them in a table and put in my report.
And may I approach her?
Yes.
I want to introduce you to the exhibit.
No objection.
Exhibit 592. Thank you.
All right, I have 1 minute, Your Honor.
Yes.
Okay, so it looks like he's trying to put together between the mileage
May I return to the witness, Your Honor?
Yes.
that where
If I could,
these shifted in reverse and a high angle of depression of the accelerator pedal are consistent with being in front of the Albert House.
Now, Trooper Paul, do you recognize what's up on the screen as the next exhibit before you?
Yes, I do.
And these are, again, if you could explain to the jury sort of what we're looking at here and how you came to these mileage tools.
Yes. So when I got the directions, it showed that we got from 34 Fairview Road to 1 Meadows Ave. And when I put that address onto Google, it gave me suggested routes. So I put each suggested route on there and the time it took. So I did that with every direction from 1 Meadows Ave to Waterfall to 12 Country Lane, and 12 Country Lane to 1 Meadows Ave, and then 1 Meadows Ave to 345 Country Hill Drive, North Dighton. So I did that for every single one and find suggested routes, so which is labeled in all these boxes here. And then at the bottom here, I did a total distance, and I did a min and the max distance of, the minimum was 36.1 and the max distance of 38.8.
All right, so I'm going to ask you to take that down for a minute, and I'll see counsel at sidebar, please.
Aunt Bev is going to say, look, this dude is too dry and it's too hard to follow whatever the hell it is that he's saying here. How come he couldn't just draw a picture and make this simpler to understand? But I believe where the state's going to go with this is that this guy is going to say that she put her vehicle in reverse and the accelerator pedal was recorded at a higher than normal angle of depression, basically. In other words, she stepped on the gas. She put it in reverse and stepped on the gas. And this would be because he's deducted the mileage that they can account for. So he has an idea where the mileage would have been, because that's the way it's recorded on the device, where the mileage would have been when she was in front of the Albert House at the time of the incident. This is going to be some difficult. If the defense doesn't cut holes in it, this is going to be a difficult point for the defense to overcome. But once again, I go back to Proctor being a wild card. Proctor was so far out of line, so repulsive, and demonstrated so much bias towards Karen Reed.
You are unmuted.
There may be some jurors that just can't get past that. I would say if Kingdom was on the jury, that there's nothing you could show him that would convince him otherwise at this point. And there may be jurors that I say that in jest. Seriously, there could be jurors that feel the same way Kingdom does.
Exhibit, sir. Have you also looked at a mileage or distance between? I'm sorry. The first up there was as far as 34 Fairview Road to 1 Meadows Avenue. Is that correct?
That's correct.
And that gave you sort of 3 different routes of travel. Is that correct?
Yes.
And the minute of the max was 2.2 to 2.6.
Correct.
Now, if you were to add that as an additional sort of distance travel to the 36.1 to 38.8 that you had calculated, how much of a difference does that make?
Between the two min maxes?
Yes.
Only 2.7.
And as far as your analysis that we're about to discuss, adding in that approximate 2 points, whatever miles, how much of a difference does that make to your analysis and ultimate conclusions in regard to the VCH or vehicle control history data?
As we're going later, but so the 36 is just within the realm that she could have traveled 36. The odometer mileage is odometer mileage. So 36 is 36. That's what's on the vehicle. So within the realm of possibilities that the vehicle could have traveled 36 miles after the 2 triggers that are in this vehicle.
Now, with respect to that minimum and max, as far as the 36.1, 38.8, what, if any, relationship does that have to the difference in the odometer readings that you observed between when you conducted the braking test and when you observed these 2 triggering events that you were talking about at the earlier mile?
I said no difference. The odometer mileage is the odometer mileage is 36.
And so I guess what I'm asking, sir, is the 36 miles, is that within the range of the 2 triggering events that you were just talking about?
Yes, it was.
Now, as far as within your report and your analysis, did you come up with some sort of a label as far as these 2 different triggering events that you observed?
Yes, I did.
And that incorporated the mileage, is that correct?
Correct.
And that was, again, 12,629, is that correct?
Yes.
And then as far as any further label that you put on it, how did you label it?
I labeled them as in when they occurred. One's 12,629A and the other one's 12,629B.
And with respect to the A and B, which one occurred first?
The A occurred first.
And may I approach, Ron?
Yes.
Dante says we're told by insurance companies, insurance companies can tell if our premiums need to go up from car data. This guy's convincing me otherwise. Dante, I think that's a program you volunteer to. You put a separate device on there that actually records more detail.
Okay.
Yeah, I've got one State Farm.
I do. It's the data chart from the 12,629 miles A chart.
May I approach again, Your Honor?
Yes.
I'm going to seek to introduce the minutes of the next exhibit.
No objection.
Okay. The 593.
And again, if I could just have a moment, Your Honor.
Yes.
May I return this to the witness, Your Honor?
Yes.
Curious to see what the mileage difference is
Yes.
between the two triggers.
Okay, so with the document before you, what's now up on the screen, do you recognize that as what's now been marked as the next exhibit?
I do.
Is if you could describe to the jury sort of what these rows indicate as far as what information is there, and if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you observed in this as far as 12,629 miles A.
Okay.
This guy brings in
So
a
each
dry
row starting from the top
chart.
is the vehicle control history time, which is the time that's recorded in the module itself or in the software that gets recorded as each time, and it's recorded as seconds. This time is the time from the start of the key cycle. So it starts off with 652.8, and each one is incremented in approximately half seconds increments up to, let me show it right here where the trigger, this is what's called where the trigger happened. So right here is where it kind of goes from 4.5 to 4.6, and then goes up to 5. Then everything after that is about half second increments from each other. Recorded 10 seconds of time, which is labeled in this one, total time of 10 seconds. And I'll just put time from trigger, just kind of label it back to, here's the trigger right here, and that's the time between each one. Sorry if I can read this right. So and right here, this is the vehicle speeds. The blue is just labeled because that's the speed. Zeros are labeled as a light blue is 0. So if I could read this. So it starts from, shows that the vehicle is traveling at 9.9 miles per hour. It's slowing down to about 0 right here, and then stops for that time, and then increases back, speeds backs up to. It goes up to 6.2, and then slows back down to 0, and then back up to 1.7 to, I think it's 8.7. If I can read that right. And next below for us is miles per hour to kilometers. This is the accelerator opening ratio, which is really where this trigger comes from, because the trigger is labeled as the accelerator pedal opening angle is medium to higher immediately after shifting to reverse. All right, they label it as R.
If I could stop you there just
Yep.
for a second, sir. As far as the accelerator pedal opening angle,
Correct.
can you explain to the jury sort of what that term means and how that relates to sort of the operation of the vehicle?
So the accelerator pedal is, the part where everybody puts the foot on and gets the vehicle to go. So the pedal, so this is what's showing how far the pedal was actually pressed by the operator of the vehicle. And that gives you a percentage of that. So if it was, zeros not pressed and 100%, it's all the way down. So they label the trigger, I think 30% is medium to higher. In this way Toyota labels it. So then that's where you'll see the trigger is around 31.5%. And it also shows start from the beginning, goes from 0 and increases up to 50.5%, and that's 5 seconds. That's only, a little over a second past the trigger. And so it's 50% and then back off, and then back onto the accelerator again, up to 34%.
Now, as far as this data is concerned for the VCH data from the Toyota tech screen, what, if any, information are you able to glean as far as directionality, as far as forward, reverse, left, right, things like that from this data?
So on this label right here, so it shows the shift position signal. 1 is forward and 2 is reverse. So this right here is showing the vehicle was in drive and going forward, and then the vehicle got shifted into reverse, and then back to drive again.
Now, from your experience and from your training when it comes to interpreting this type of data, do you have any opinion as to sort of what type of maneuver or what type of actions the vehicle was taking during the course of this triggering event?
Yes, this appears the vehicle was slowing down and making a U-turn. Because also the other thing into it, it shows steering signal. And the steering wheel showed that she was driving left and then right and the back left again. And also when she's on the brake switch.
Thanks. Ms. Gilman, you can take that down. And Your Honor, may I approach?
Yes.
Big Daddy's watching, Ron.
Ron, you're right. I think you do have to apply a different piece of equipment to your car to insurance to give you a better rate because they're recording
That document that
everything.
I've handed you now, do you recognize that?
Yes.
And what do you recognize that to be?
It's the one, the 12,000,
Yeah, I'm pretty
so
sure
I
you've got to
provided
have that
for
OS,
label
the
12,629
OBS dongle that
miles
plugs
speed.
into the car for them to actually
So that's
record
the
that. I don't think
second
there's any way
triggering
they can pull
event
the data
within this
remotely
same
from the car.
mileage reading
In
on
fact,
the
I don't think they
odometer
could do it
and key
legally.
cycle.
Correct.
Your Honor, may I approach?
Yes.
No, you have to consent to that.
No objection.
You guys following this testimony? Does it make sense to you yet? Or does it make sense to anyone at all?
Well, I was trying to put it together, but then he summed it up while I was trying to put it together. He said she made a U-turn, but I was looking at also at the RPMs. They don't look like she accelerated fast.
Yes, and for the sake of taking the best use of our time, if they're in evidence for the rest of this
'Cause
afternoon,
it looks
both
like
of you can then
idles
just
around
ask
700,
that.
800
Just
RPM.
go ahead and
Then
put
she
them up
goes
and
up
not
to
ask for permission.
1400. I mean, that's really.
And Ms. Gilman, if I could.
Well, it also records the speed. Looks like her highest speed in reverse was 3 miles an hour.
You recognize what's up on the screen now?
I do.
This is the VCH data chart from that same mileage or the second triggering event as far as 12,629 miles peak, correct?
Correct.
And again, this is in the same odometer range as well as the same key cycle as what was just up on the screen as far as 12,629 miles A, correct?
Yes.
And this occurs after A, is that fair to say?
Correct.
Now, similar to before, when it comes
I
to
just grabbed
this,
a screenshot of
VCH
that.
data up on the screen, if you could.
I don't know if you were paying attention to the conversation we were having earlier, Joe, when you were at lunch. I don't know if you could hear it or not, but we were talking about rather this particular model of car pulls the speed
So for this one,
off of a non-powered transducer from the car,
label
or
as
if it's
before,
pulling it off
just
the
that,
transmission. And
the
if it pulls it off the
trigger history
transmission, then
time
a lot of
is-
these readings could be
let's see that.
erroneous.
The trigger time is 1,142.2 seconds.
I'm curious to see what the
after
difference
key
does with
cycle.
this. They can't. let
And this one shows all the same thing, 10 seconds of data. And it was good. So the vehicle speed on this one shows that she's slowing down. It's 13.7 miles per hour and gets down to 0. Then she's down to 0 for a while. And then the vehicle's speed increases up to 24.2 miles per hour at its max speed. Then it goes down to 23.6 as the last two labels. And the accelerator pedal angle at this point at key trigger is 36.5 and increases up to 74.5%. And it stays around 74.5%, 74, 73.5, and 74.
Now, that's 74.5% as far as the pressure being applied to the accelerator pedal, correct?
Correct.
And with respect to that 74.5, that's about 3/4 down, is that correct?
Yes.
Now, with regard to this data from 12,629 miles B, what, if anything, are you able to tell from this data as far as when that occurred in relation to 12,629A?
So they occurred about approximately 8 minutes. So 1269A occurred 8 minutes prior to the other one, and they both occurred within on the same odometer mileage.
Now, with respect to the duration of the data that you were able to obtain from this one, specifically 12,629 miles B, what kind of duration of data are we looking at in this particular table or chart?
What, say that again?
How long a period of time does this depict?
So this is from the start of key cycle, or this whole just this one?
Just this one.
Okay, so this is 10 seconds of data.
And with respect to that 10 seconds of data, as far as the 24.2 miles per hour, when does that occur within the 10 seconds of data for this particular event?
So the 24.2, as I'll point out, is right here. It's actually around the 9-second mark.
Now, similar to the other charts for A that was up on the screen a moment before, is there an indication as far as the accelerator pedal opening angle?
Yes.
And what, if any, significance does that have, or what, if anything, does that indicate to you from this data on the screen?
It shows that the accelerator angle went up to 74.5%.
Correct, Dante. I had to read that twice.
So
but yes,
as
you
out
are
of 100%, it went up to 74.5%.
Now, with respect to directionality for this, what, if any, data is contained within this chart in respect to that?
Yeah, so on the bottom row, it shows the steering signal. It should show it slowing down zeros like 0.5, 9, 13.5, 13.5. I think it's 13.5, 0, 4.5. And we're talking about steering wheel. How far does the steering wheel move from left to right? So that's the degrees of a steering wheel angle.
Now, as far as when the vehicle is shifted sort of from drive or neutral or park or whatever it was, at some point, is there an indication in this data set on this table as far as when the vehicle was placed into reverse?
Yes.
And how far into this 10-second data set was the vehicle placed into reverse?
At 4 seconds, it's the...
I agree with
right
Range.
here.
This guy's a lot of fun at parties,
So,
especially if it's like a
that
nap
there is
party.
5-second difference between
If
4
you
seconds
sleep.
when it's placed in reverse and 9 seconds approximately when it achieves that 24.2 miles per hour.
Correct.
Now, as far as the 74.5% pressure that's placed on the accelerator pedal, when is that recorded in seconds in relation to the 10-second data set in this table?
74.5 starts at the 8 second.
Now, as far as this trigger is concerned, I understand from your testimony that the maximum speed is 24.2. Is that correct?
Correct.
And what is the vehicle speed recorded at the end of this 10-second data set?
23.6.
Now, as far as the vehicle being in sort of different sets, as far as drive, reverse, things of that nature, what, if anything, did you observe within this data set as far as how it is at the beginning, how it changes at all? What happens with regard to that in the data set?
So this one shows that the vehicle was in drive. It starts off in drive. It's slowing down to 0, and it goes to 0, which is neutral. Then it goes down. Then it goes into reverse. So it's going straight. It stops. Then it's placed in reverse, and then goes back. Goes in reverse.
Now, as far as the reverse is concerned, you indicated there's also some steering angles that are recorded with this data.
Yes.
And what, if anything, was recorded in this 10 seconds of data? Specifically, I'm asking from the time that it goes to...
Kingdom wants to know about spinning tires in the snow, even though there was no snow on the road, I believe, this time.
With reference to the change in the steering angle of the steering wheel.
So I guess you would
It does not
have-
change much. It's only 13. I think the far it goes is left is at 13.5%. So that's only, I mean, if you think if the steering wheel's a circle, the whole circle is 360 degrees. So 13.5% is only, and it's still fairly straight.
I'm looking at my
at
screenshot of
13.5%.
of that chart. I don't know how you would tell.
So from
I
this
mean,
data, this vehicle is backing up in the manner of about 5 seconds or so, in a fairly straight line, and achieves a maximum speed of 24.2 miles per hour, correct?
Correct.
And even at the end of this data set, the vehicle is still traveling approximately 23.6 miles per hour.
Correct.
Now, as far as the small deviations in the steering that you were testifying about, based on your training and experience, what, if anything, would cause that?
Well, the steering wheel was obviously caused by operator traveling only a small amount, about right, and up to here. So it's only just operator steering at those small deviations.
Your Honor, may I approach?
Yes.
Kingdom and Dante are still holding out some hope here that one is that's a lot to interpret. It means that she's a woman driver, and according to Proctor, a retarded woman, a retard woman. And Kingdom's got the snow as a contributing factor that he doesn't believe is being.
I do.
Now, what do you recognize that to be?
It's a more of a closer up snippet of that document that I have attached to my report.
And Your Honor, may I approach?
Yes.
Hard practice. Call with the seat to introduce him.
Biggest problem with this is I think they're making it very confusing for the jury to understand. I think they could have charted this out and done it a little better than an Excel sheet. And this guy's dry demeanor explaining it. That may be a benefit to the defense if the jury's like, I don't understand that bullshit. Doesn't make sense to me.
Trooper Paul, from what's depicted up on the screen as this next exhibit, if you could, using the laser pointer, just direct the jury's attention to what, if anything, of significance you observe in this portion of the data.
Yeah, so I circled in here the drop from 24.2 to 23.6, and also the steering wheel signal went from a left at 4.5 to a right 4.5, so positive to a negative. And also the same thing with the solar opening ratio, kind of stays consistent at 74%.
May I approach again, Your Honor?
Yes.
That would say she's backing up, and at some point she veers the vehicle, the rear end of the vehicle to the left by turning the wheel right. Am I with that? Is that correct?
Okay. Do you recognize that?
I did.
What do you recognize that to be?
It's a vehicle control history distance chart. I calculated and attached to my report.
And may I approach again, Your Honor?
Yes.
I'll have to see.
And I see Dante's point, no brake input at that point on the graph. Dante, that may go back to why this is not manslaughter and murder, is that she didn't hit the brakes. I don't know if that's a benefit to the defense that there's not a brake input.
Paul, do you recognize what's up on the screen? It has now been marked as Exhibit 596.
I do.
And again, if you could, using the laser pointer, let me ask you this first. As far as this table and this information up on the screen, I should have asked you this before. How was this table created, and what, if anything, does this illustrate?
Yeah, so this illustrates from the chart of 12,609B. I started from when the vehicle was placed into reverse, and when it immediately goes from 0 and travels up to 23.6. Just that's like the last part of that last chart we had.
And what, if anything, were you able to do as far as distance travel, and how were you able to determine that?
So I used the spherical speeds and the time, and calculated a distance that the vehicle traveled during this time.
And as far as the total distance traveled from the 0 to the 23.6 at the end, what was the total distance there?
97.35 feet.
And with respect to the vehicle's maximum speed, as far as 24.2 miles per hour that's recorded within this data set, how much distance had the vehicle traveled prior to achieving that 24.2 mile per hour?
62.51 feet.
Thanks. I approach this to retrieve, Your Honor.
Yes.
Now, Trooper Paul, with regard to, based on your training and experience, with respect to this type of data and crash reconstruction in general, this particular set of data from, who's the name again? From 12,629 miles B, what, if any, type of collision is that data set consistent with, and why?
Yeah, there's a point there where it appears to be consistent with a pedestrian strike.
And why is it that your interpretation of that data you feel is consistent with the pedestrian strike?
It's the sudden change of speed at 24.2 to 23.6 in a half second, while the accelerator pedal is still at a consistent 74%. And also the steering wheel angle goes left at 4.5 degrees and also goes right to 4.5 degrees, and then goes back to left after that. So right at that spot is something that's consistent with a pedestrian strike.
Now, with respect to Mr. O'Keefe, the pedestrian in this collision, what, if any, data were you able to see or review in relation to your reconstruction analysis in this case?
Say
As far as Mr. O'Keefe, what, if anything, did you learn about his injuries?
Like what types of injuries he had?
Yes.
Yeah, there were blunt force injuries. I mean, it was abrasions or lacerations, and blunt force injuries.
And the injuries that you observed or that you were informed about, that you learned this from the medical examiner, is that correct?
Correct.
And with respect to the injuries that Mr. O'Keefe was recorded as having sustained, according to the medical examiner, what, if any, relationship did those injuries have to you in relation to a pedestrian collision?
Sorry, say it again.
As far as the injuries that you were informed by the medical examiner that Mr. O'Keefe had sustained,
Yes.
what, if any, relationship did those injuries have in relation to a pedestrian collision?
They are consistent with a pedestrian collision.
And how so?
Due to, I mean, we can break down each injury due to the arm, the lacerations of the arm from the tail light, the dent where the scratches for his hand could be. Those are something that would be consistent with this in this particular case with striking the Lexus.
Now, specifically with reference to this case, what, if any, analysis did you conduct with regard to kinematics?
Yes, I did a kinematics analysis in my report. Kinematics deals with the aspect of motion.
And I'm sorry, if you could expand upon that just a little bit and explain to the jury sort of what a kinematics analysis is.
So a kinematics analysis is, like I said, it deals with the aspects of motion. Pedestrian crashes get labeled in certain types of how they interact. So in this particular case, I kind of labeled it as it's a forward projection crash with a side swipe. And what I mean by forward projection, it means that when a pedestrian gets struck by a vehicle, well, basically their principal impact forces are above the pedestrian center of gravity, as in this case where you get the higher back of the vehicle. When you get struck by something like that, it projects you forward in the direction of the vehicle. And in this situation where he gets more struck through the side of the vehicle along the taillight area, that it projected him to forward and then to the left due to this more of a side swipe manner.
Now, with respect to you mentioned the height of the vehicle, as far as the shape of the back of the vehicle, what, if any, relationship does that have in regard to you sort of labeling this as a forward projection / side swipe collision?
Yeah, due to it being pretty flat, it's not the front of the vehicle where you have the hood and the pedestrian staying above the hood. It's the back of the vehicle. It's pretty flat and it's pretty higher up.
Now, with respect, you also made aware through your review of the medical examiner's report that there was injury to the back of Mr. O'Keefe's head.
Yes.
And based on your training experience in particular to pedestrian collisions, what, if any, significance did that have in relation to your opinion as to how Mr. O'Keefe interacted with the defendant's vehicle?
So when you look at the damage, he would have interacted with that left side of the vehicle. And when he got struck by the vehicle on the left side, it would have caused his vehicle to rotate kind of counterclockwise. And then when that rotation, he could turn it into his back, and his back could have struck the ground. I noted at the scene that there was asphalt curbing, which could have, somewhere he could have struck his head in there, or somewhere along any of the pavement would have caused damage. Most forward projection crashes have damage on both sides of the body.
Why is that?
Due to them get projected forward. So they get hit from behind, they would have damage to the back, and then when they get projected forward, they get damage to the front. So, I mean, in this case, he got projected and got spun counterclockwise due to where he got impacted the vehicle.
Now, with regard to the vehicle speed,
There's a lot of woulda, couldas in that conversation.
From your analysis in respect to that, what, if anything, can you say in relation to, just in general terms, as far as a pedestrian collision is concerned, how much of that vehicle speed would a pedestrian be assuming in the context of a pedestrian collision with forward projection?
Forward projection will have almost 100% speed post-impact. And more, like I said, in this case, it's more the fact that he didn't get 100%, like his center of mass didn't strike the vehicle, so he would not have getting thrown 100% of the vehicle speed post impact. His right side would have sustained the vehicle speed, and that would cause him to spin out. So, as opposed to traditional forward projection, if he was right there in the middle of the vehicle, he would have got projected forward, and he would have sustained his full body would have sustained the vehicle speed.
Is that abnormal as far as the sort of forward projection type of pedestrian collision? And what I'm going to ask is specifically to not having any contact with sort of the bottom of the vehicle or being run over or something like that. Can you expound upon that a little?
Yeah, due to the side swipe manner that projected him off to the left, it wouldn't show that he would have been, the car would have ran over him and traveled over him. Like traditional.
Yeah,
The car would.
I'm going to ask you to slow down just a
Sorry.
little bit.
Sorry.
Okay?
Yes, so due to the situation in this scene where he got projected to the left and by rotated, it would have rotated away from the vehicle and his body would not have traveled under the vehicle as you do in like a lot of traditional forward projection crashes. The vehicle would get tracked forward ahead of the vehicle and that vehicle could possibly travel over that pedestrian.
So that is not what you found in this particular pedestrian collision, correct?
Correct.
Technical term for that is runned over.
I know you've mentioned it a couple of times, but if I could ask you to just expound a little bit when you're talking about
That kind of like the term when they use monies.
and how that relates between sort of a pedestrian.
Very similar, yes.
In a pedestrian type collision.
So pedestrians, almost every object has a center mass. Pedestrians is the same. So a pedestrian center mass is essentially
What happened?
I'm looking at your graph that you took a screenshot of. It literally only covers 10 seconds. Trying to figure out the braking issue like Dante's talking about.
Oh, okay.
It's some forward acceleration and rear acceleration braking.
Sorry, folks, I didn't realize I put the audio off
Now, in
when I did
addition
that.
to that,
You didn't
what
miss
any other
anything.
Testing did you do with respect to that vehicle on that particular date in that location?
we checked the cameras and we did backup visibility analysis with the cameras and the vehicle.
And again, if you could just in general terms first, just describe for the jury when you say visibility analysis, typically speaking, what are you doing in a visibility analysis?
In the visibility analysis, we are trying to see what an operator would see in their vehicle. Looking for, in this particular case, we're trying to see if the operating vehicle would be able to see a pedestrian behind the vehicle. And also in this, where we have backup cameras, we're trying to look at the cameras and see what would the cameras pick up as we go into reverse.
And in fairness to the defendant, at this particular time when this visibility analysis was conducted, it was during the daytime, is that correct?
That's correct.
Your understanding of the crash is that it occurred at night, correct?
Correct.
Now, as far as a visibility analysis, typically, would you be looking to recreate as close as you can to the conditions at the time that the collision occurred?
In most typical cases, yes.
And why were you not able to, were you able to do that in this case?
We were not.
And why?
Due to was most, like I said, it's mostly done when we're trying to see what a pedestrian an operator would see a pedestrian. It's mostly done because it's an accident, but a lot of times when it's like an intentional act, visibility is not an issue in this situation. We were just want to make sure that the cameras worked and the backup sensors all worked in the vehicle.
Now, as far as this particular visibility analysis that was conducted in this case, how, if at all, was that memorialized?
It was recorded when the crime scenes trooper recorded it.
Well, Kingdom's brought up. He says they found an expert that claims Jennifer McCabe didn't make the Google search at 2:27 a.m. You can't believe anything else. They're presenting shady AF. I just don't know what evidence we have to prove that Jennifer McCabe did make that, besides what this expert actually explained away, saying that that's not. I know what you see, but there's more to it than that. That you had to go deeper to determine the truth in it. So I don't know if I buy that necessarily. Dante is still pushing on the fact that because we have acceleration, doesn't mean that we actually have true speed. We could have wheel spin or
So I'm showing you a series of
faulty sensors at the wheels that doesn't indicate that the vehicle is actually
First, I'm
traveling
just
at
gonna
that,
ask you
that maybe
generally if
the
you recognize
wheels were
those.
rotating in a manner to indicate 20, 24, 25 miles an hour. But remember, folks, this is over a 10-second period. Everything we're seeing on this Excel sheet, even though poorly demonstrated, in my opinion, is a 10-second window.
Yes.
Portion of that 10-second was
And what do you
driving
recognize
in
those to be?
forward.
It's the inside of the vehicle. Appears to be taking out the, showing that taking out the infotainment system.
What system?
Infotainment system.
And the last photograph there, what, if anything, does that depict, sir?
That is the module for the infotainment system.
And what, if any, involvement did you have in respect to this investigation in regard to the infotainment system?
I didn't have anything. That was Trooper Nick Marinos did the infotainment system in this vehicle.
And you indicated earlier in your testimony that you had training as it relates to Burla, correct?
Correct.
And what, if any, relationship does Burla have with respect to the infotainment system?
They had tools to forensically diagnose the infotainment systems.
And if you know, are you familiar with whether or not that was able to be accomplished in this particular case?
It was not.
And do you know why not?
Because they had to go to, I think Burla didn't have the equipment, so they went to a.
Sustain.
Your Honor, may I approach?
Yes.
Now, as far as those photographs, they're an accurate portrayal of what you observed in the vehicle during the time that you were conducting your testing.
Yes.
Your Honor, I'll seek to introduce and admit the next 7 exhibits.
Any objection, Mr. Jackson?
I'm sorry, I was writing a note. What are those 5 photographs?
7.
7.
No objection.
I've got to take a phone call.
Okay.
And Your Honor, with the court's permission, if I could just follow.
Yes.
Now, Ms. Gilman, if I could have the photograph labeled BEP2. And Trooper Paul, do you recognize what's up on the screen and is now been marked as exhibit 597?
Yes.
And what part of the vehicle are we looking at in this photograph?
That's the steering wheel.
And Ms. Gilman, if I could have BEP3. And Trooper Paul, do you recognize what's now up on the screen and is marked as exhibit 598?
Yes, I do.
And if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you observed in this part of the photograph.
That is the infotainment system.
And as far as the infotainment system, when you were operating that vehicle, what, if anything, was displayed on that screen within the infotainment system?
If you were in drive, it just said, the radio navigation stuff. But if you're in reverse, that's where the backup cameras and sensors would be.
And Ms. Gilman, if I could have BEP4, sorry. And Trooper Paul, do you recognize what's up on the screen as exhibit 599?
Yes, I do.
And what, if anything, are we looking at in this system?
That's the push button start, the ignition.
So that's how this vehicle is started and stopped, essentially, is a push button start, is that correct?
Correct.
Ms. Gilman, if I could have BEP22. And Trooper Paul, do you recognize what's up on the screen as now marked as exhibit 601?
Yes.
And if you could, using the laser pointer, direct the jury's attention to what, if anything, you observe of significance in this.
Yes, that's the infotainment system. It's on, shows satellite here. Looks like that's the navigation.
Ms. Gilman, you can take that down. Now, if I could take you back just for a second to the VCH data and the kinematics of what you were testifying about just a moment ago. You had mentioned that with respect to the injury to the back of Mr. O'Keefe's head that is consistent or could have been caused by striking his head on part of the pavement or the curbing, is that correct?
Correct.
Now, as far as your training and experience in pedestrian collisions that you've responded to and investigated on prior occasions, as far as weather, as far as the coldness of the ground being frozen, what, if any, impact could that have as far as in relation to the injuries to the back of Mr. O'Keefe's head?
Objection.
Sustained.
Now, as far as the visibility analysis that you were conducting on February 1st, you mentioned that that was memorialized with photographs as well as video. Is that correct?
Correct.
And the video that was taken, sir, was that in the interior of the vehicle, exterior of the vehicle, or both?
I believe it might have been just the interior.
Approach, Your Honor.
Yes.
Sir, I'm showing you two discs.
Okay.
Do you recognize those?
Yes.
And those are the recordings of the visibility or the braking and acceleration tests from February 1st, both interior of the vehicle, exterior of the vehicle. Is that correct?
Yes.
May I approach again, Your Honor?
Yes.
I'm going to introduce you to the next exhibits.
No objection.
Before we get to those videos, Trooper, may I approach again, Your Honor?
Yes.
So I'm showing you another series of, I believe, 8 photographs. Just ask you to look at those and look up when you're finished. And do you recognize what's depicted in those photographs, Trooper?
Yes, I do.
And what do you recognize those to be?
Those are photos from the backup cameras and sensor tests.
May I approach again, Your Honor?
Yes.
I'm going to seek to introduce the minutes and next exhibits.
Okay.
No objection.
So I'm wondering, you know how like on those vehicles, when you back up and you get too close, it'll start beeping. I'm sure it records that as well.
I'm not sure. I know you could be a pretty good distance behind my car, and it will start beeping way outside the arc that I can see. So that's a good point. I'm curious about that myself.
Thank you.
And Ms. Gilman, if I could have from this packet photograph 2612. Trooper, if you could, please describe to the jury what we're looking at in this photograph that's now been marked as Exhibit 606.
Yes, this is the view from the operator as they would turn around and look to the back of the vehicle.
And Ms. Gilman, if I could have photograph 2616. And Trooper Paul, do you recognize what's up on the screen and has now been marked as Exhibit 610?
Yes.
And can you please describe to the jury what, if anything, we're looking at here?
Yes, that's the view inside the vehicle, showing the infotainment system and the backup cameras on it.
Now, as far as the backup cameras on this particular vehicle, what kind of view was able to be portrayed, or what did you observe on the screen when you placed the vehicle in reverse?
Yes, so this has this straight backup camera and also has a 360 overhead view of the vehicle.
And as far as the cameras within this vehicle are concerned, are we talking about one single camera, or how many cameras are encapsulating this 360-degree camera angle view?
It has the front and the sides and the rear cameras.
Now, if you could, using the laser pointer, just draw the jury's attention, direct the jury's attention to where you're talking about as far as the screen is concerned, depicting that camera angle view.
Okay. So the one on the left, that's the backup camera. And the one in the middle here would be the 360 overhead camera.
Now, in addition to what's depicted on the screen right now, as far as the vehicle on the 360 overhead, as the vehicle travels, what, if anything, in addition, is depicted on that particular portion of the screen as far as the 360 overhead?
It shows a sensor, and also when that sensor shows up in the area where the object that it gets closer to.
And the sensor that you're talking about, how is that depicted on the screen?
It's a little red like blip or a little bar that would show up on the camera itself.
And is that something that appears as you approach an object from either in front or behind or something else?
Correct. As you approach the object, the bar will, blink and will go get faster as you get closer to the object.
Now, with respect to the system overall, in addition to the visual cues depicted up on the screen, what, if any, auditory cues are also part of this system?
It will beep at you, and it will, as you get closer to the object, it will beep faster as you get closer to it.
And as far as getting closer to an object, the beeping that you're talking about, it increases in speed or rapidity, is that correct?
Correct.
And how does it, what, if anything, does it do as far as the volume of the beeping that you
I guess it would increase as it would get faster.
So it gets faster and it gets louder as you get closer
Yep.
to an object, correct?
Yep.
Now, with respect to sort of the middle of the screen here, up on the dashboard, what, if anything, do you observe there? Could you direct the jury's attention to what, if any, devices are up there right now?
Yes. So that right here, this blue device, that's the V-Box Sport attached to the windshield.
So that's something that you attach to the vehicle. It's not necessarily something that was in the vehicle when you began to operate it around.
Yes.
Ms. Gilman, if I could have photograph 2618. And Trooper Paul, if you could describe to the jury, or using the laser pointer, if you could draw the jury's attention to what, if anything, is significant to observe in this portion or closer up image of the screen in the center console.
Yeah. So this, this is one on the left here is the backup camera, and the one in the middle is the 360 overhead camera. The bars and lines are showing the path of the vehicle.
Okay. Ms. Gilman, you can take this down. I may have a moment, John.
Yes.
Now, Trooper Paul, as far as during this visibility analysis that you conducted, you testified earlier that you were primarily concerned with sort of whether or not the cameras and the auditory and visual cues worked properly with this vehicle and this system, correct?
Yes.
And during the course of your running these sort of forward and back reverse acceleration braking tests, as well as visibility analysis, what, if anything, did you observe with relation to the functionality of the cameras and the visual and auditory cues?
Everything seemed to be working properly.
Now, when you were operating the vehicle on February 1st and you shifted the vehicle into reverse, what would then sort of occur with the screen in the center of the data?
It would change from the navigation to the backup cameras.
And how long a period of time did that take as far as you shifted from drive to reverse on a number of different occasions while you were conducting your test, correct?
Yes.
And so how long a period of time are we talking about between the time that you shift the vehicle from drive or another gear to reverse for those screens to then display both the rear backup camera and the 360 overhead view?
It's fairly instantaneous, very quick.
Now, at some point during the course of the visibility analysis specifically, what, if anything, did you place behind the vehicle during your visibility analysis?
It was like a punching bag dummy.
And where did you place that in relation to the vehicle?
Along the right rear.
And as far as that punching bag dummy was concerned, about how far up off the ground was the top of that?
I'm not exactly sure the exact height of it. Maybe my height or taller.
And with respect, your height, sir, how tall are you?
5'6".
So it was at least 5'6", if not taller. Is that correct?
Correct.
And with respect to that, placing it behind the vehicle, after it was placed behind the vehicle, at some point, were you inside of the vehicle?
Yes.
And when you were inside of the vehicle and that was outside of the vehicle, what, if any, visual observations were you able to make with respect to its placement? And it's in the right rear passenger side of the vehicle, is that correct?
Correct.
So what, if any, observations were you able to make with respect to that item or exemplar that was placed out there?
It would have been invisible in the cameras.
Now, with respect to the visibility analysis that was conducted with respect to that, let me ask you this first. When I say exemplar, so exemplar pedestrian, can you explain sort of what that term means and how it relates to a visibility analysis?
So an exemplar pedestrian is, just like you said, we used a punch bag dummy. It was something that we used in place of a pedestrian to act like a pedestrian.
Now, when that exemplar pedestrian was placed in the rear passenger side area of the vehicle, what, if any, obstructions did you observe as far as just from a visual perspective, sort of turning your head or looking or cameras or anything else as far as where that exemplar was placed?
There were no obstructions.
Now, if that exemplar was placed directly next to the vehicle versus feet away from the vehicle, what, if any, difference did you note as far as this visibility was concerned?
Yeah, so if it was placed right next to the vehicle, it'd be blocked by the back pillar of the vehicle. If you place it like 5 feet away, you would be able to see the dummy and the cameras and also in the side mirrors.
So at a distance of at least 5 feet, it was fully visible from where you sat in the vehicle?
Yes.
Your Honor, with the court's permission, if we could, I would ask, and I'm sorry, I'm not sure what exhibit numbers they are, but the 2 videos that were just introduced.
Okay.
And Ms. Gilman, if I could have the exterior video first.
And just for the record, they are 604 and 605. Thanks.
Thank you, Madam. Gilman, if you could pause there for a moment. Paul, with respect to, just for orientation purposes, if you could explain to the jury sort of where we are in relation to the Canton Police Department and where it was that you conducted these tests.
Yeah, so this is a view from the back of the Canton Police Department. So as you look at the Canton Police Department, we'd be on the left side of the Canton Police Department.
And as far as the vehicle in question, if you could, using the laser pointer, just direct the jury's attention to where that is and sort of where it's going to be in relation to the camera angle.
The vehicle is right here.
Ms. Gilman, if you could press. if I could ask you to pause there for just a moment. Trooper Paul, during these testing that you were conducting here with the acceleration, reverse braking, all of those things, the highest speed that you recorded during the course of that testing was 30 miles an hour. Is that correct?
Yes.
And the highest speed that was contained within that VCH data for the second or the B of those two data sets, what was the highest miles per hour there?
At 24.
Now, with respect to the braking in this vehicle, what, if anything, was this vehicle equipped with?
Had ABS brakes, anti-lock brake system.
And with relation to anti-lock brake system or ABS, what, if any, relationship does that have with regard to braking and what is then visible on the pavement?
It doesn't leave visible tire marks.
And why is that so?
Due to when the brakes, as the brake is about to lock up, it transfers over to another tire. So it kind of rotates between tires. So the tires never fully lock up and slide across the pavement.
Now, in relation to ABS not leaving marks on the pavement, what, if any, relationship does that have as far as the sound difference between ABS brakes and non-ABS brakes?
Yeah, it sounds different because you would hear a car sliding across the pavement as opposed to just hard braking and engine slowing down.
As far as sort of screeching of braking and tire coming to a brake, what would you expect to hear with respect to ABS braking?
There would be no screeching of the tires.
And Ms. Gilman, if you could press play from here. Thank you. Your Honor, with the court's permission, may I publish the other video of the interior of the vehicle?
Yes.
Ms. Gilman, if you could just pause it briefly. Again, Trooper Paul, with reference to what's up on the screen, if you could, just using the laser pointer, direct the jury's attention to the screen in the center of the dashboard, and just as far as what different parts of the screen are visible here.
So right here is the reverse camera, 360 camera.
And as far as this particular portion of the interior of the vehicle, are we looking at what was done with regard to acceleration or braking test, or are we looking at the visibility now?
This is the visibility analysis.
Ms. Gilman, if you could please press. If you could pause it there, Ms. Gilman. I could ask you to just bring it back just a couple of seconds.
All right, co-host, has this testimony swayed your opinion any?
Paul, as far as this is the closer up image of the screen.
Nope, I'm still locked in. I think at this point
Yes.
they're just trying to drag it out.
Using the laser pointers may be a little difficult to see. If you could, using the laser pointer, direct the jury's attention.
Same with you,
Observe on this
Johnny
screen
Cochran?
While the vehicle's in reverse now, correct?
Correct.
If you could direct the jury's attention to what, if anything, you observe on this screen as the vehicle's in reverse with the exemplar pedestrian behind.
Yes. So this screen has now changed to a park assist screen, and it now shows a sensor for the back of the vehicle. And also same here, the sensor starts popping up in a yellow line for behind the vehicle.
How about you, Joe? Is this anything swayed your opinion? Are you still the same? Are you
Next
starting
count
to
view
lean one
shows
way?
that's where our puncher bag dummy was, and also shows where the sensor's backed up to on the bottom here.
I think
And Ms. Gilman, for the record, this is about 34 seconds in. If you could press play from here.
I think this type of testimony a jury can take as empirical evidence and be very difficult to overcome unless the defense can get up and poke holes in their methodology. I'll say it's hard to ignore. I can't ignore this.
Now, Paul, at some point over the course of your investigation, over the course of this case, did you become aware of ring videos from Mr. O'Keefe's residence at One Meadows Avenue?
Yes.
And specifically, have you had occasion to see a video depicting the defendant backing out of the garage as snow was coming down?
Yes.
I'm going to allow it.
Yeah, I don't care about his opinion there.
With the court's permission, if I could publish.
You're going to tell me that
witness on
the snow didn't fall. I don't care.
6
Now, Dante does bring up a good point. We talked about ABS brakes, but we really haven't seen any braking data. Are we to assume that she drove 24 miles an hour and she didn't hit the brakes? She let the vehicle come to a complete stop on its own? Or are they asserting that the impact with Brian O'Keefe's body stopped the vehicle, which I don't know that I buy that either. What do y'all think about that?
We should still see some data that shows the car coming to a stop. And it would be abruptly, and then there would be impact data from the sensors on the car, according to what these guys are saying.
I thought he was saying that you may not see impact data because of where the impact was at. If impact around the tail light area, there's not sensors there, and if it doesn't deform the frame or deform the body, then the side impact sensors wouldn't be triggered as well. And
I don't.
It seems like his. I'll say this. It seems like his chart that he put up. It stops before the vehicle gets to 0 miles an hour, indicating whether it was stopped by brakes or stopped by just getting off the gas and letting it stop by itself. But I'm going to go back and say this, that I think you're hard pressed, that I think you can analyze every one of our personal vehicles and kingdoms as well. I don't think you'll find an occasion where we've traveled 24 miles an hour backwards. 24 miles an hour does not seem very fast going forward, but backwards, that's a clip. That's quite a bit. And it's unusual for someone to travel at 24 miles an hour in reverse. So I think that's a hard thing for me to get past. And it's hard to say that it didn't happen. This is kind of empirical evidence. That vehicle has no, it logs information as it logs information. It has no dog in the fight. It's not deleting files. It's not putting files in. It's just recording what's happening. So it's kind of a true fact that I think I can lay my hat on. So I will say it is difficult to get past the fact that vehicle at the time frame, if all of his mileage is right. Of course, we're relying on Alan Jackson to poke some holes in that with an ice pick when he stands up. That somehow or another that this occurrence of the 24 miles an hour didn't happen in front of the Albert House. That it could be attributed to somewhere else, another location. Then that would poke holes in it where I could dismiss it in its entirety. But if you can't do that, it's going to be hard to dismiss that, I think. And you guys got to look at this. Some jurors may weigh in on that. The Proctor was so repulsive and repugnant that anything you say after that is bullshit. I'm not believing anything else that anybody else has to say, and they're going to stand on it. They'll vote to acquit or even hang the jury on it. And I think that's like if Kingdom was sitting on the jury, I think that's where he would be. And I guess both of you would be there as well. Then others are going to sit on the jury and they look through all this other shit's a smokescreen and bullshit going on. What can you really hang your hat on? And they may look for data like this to say, well, if you can't explain that, then this in and of itself, everything else is bullshit. But I have to believe in this, and this makes sense that she was involved somehow or another in the death of John O'Keefe. So I don't know which way the juries will go on it. I think I'm more of the empirical portion of that. That if there's something as the investigator in me, something that is definitely not tainted, it's true. I can hang my hat on it, and if I can't get around that, then that's pretty much where I've got to stop. Here's Kingdom Radio. Who are you going to believe more, the Massachusetts State Police experts who are actually clearly conflicted, or FBI crash experts? Well, I hadn't heard the FBI crash experts yet, and I don't think you have either, Kingdom. So I don't know which one. I do want to hear what they've got to say, and if they've got, and this may be a very valid point that Kingdom brings up. If the FBI crash experts come in and they give a contrary story to what the Massachusetts State Police are saying, then I absolutely actually agree with Kingdom on that. I would lean towards the FBI expert. I feel like if I could hang my hat on a third uninterested party doing an analysis on this, that it's essentially, in these experts, what's rare about this, they're not paid for by the state. They're not paid for by the defense attorney. They have no other reason to come into this trial other than to speak the truth. They don't care which way it goes. So yes, if the FBI experts say this is different, then I will absolutely go with that. But I haven't seen that testimony. And Dante says, excuse me. He said himself pedestrian impact is a little effect on the car speed, but says ABS would allow silent braking, so no skid marks. So house can't be expected here, skid marks. And where's the brake data? And I agree with everything you just said. ABS won't leave a skid mark on the street so that you would see that, because they say there were no skid marks. It would be less likely that somebody inside is going to hear this occasion happening, but it doesn't erase the fact that they have not displayed any brake data, which is kind of odd. I think they've talked about everything else: angle of the steering wheel, the percentage of depression on the pad, RPMs on the engine, miles per hour in reverse, the camera, what kind of brakes it was. The brakes would be silent, but they haven't shown us where those brakes were applied when the data, and I'm pretty sure that data was recorded. So I'll give you that. That's a little concerning for me. Now, will the jury pick up on that nuance? I don't know. Hopefully the defense will pick that up and run with it. But once again, the defense could pass this witness and say they have no questions for it, and they're going to rely on their FBI experts and leave it to the jury. You pick which expert you trust. And at that point, Kingdom may have a very valid point at that point, where the jury may just go with the FBI, thinking of it in similar nature that I do, that at least I hadn't heard too much bad shit about the FBI. Maybe I can believe what these people say. But definitely makes the case's state stronger, in my opinion.
We'll see. I think what a lot of people don't understand is that they're talking a lot about that throttle pedal. Also, throttle is a potentiometer, so it's not like it's connected to a cable or anything. So it doesn't really matter what position it is. It's all how the car's set up.
Well, wouldn't the further it's depressed indicate the more fuel it's going to be giving to the engine?
You would think so. Another thing to look at is throttle lag. I haven't seen them go into how fast it was pressed just percentage it was pressed. You know, a lot of cars have throttle lag in them again, and then it rolls back to something we talked about earlier. If it's reading wheel speed off the transmission or off an actual non-powered tire, is this true speed or is this just transmission speed?
You know, I'm not sure which one it is, but I mean, we definitely got a percentage of pedal depressed. We definitely have an RPM. Everything seems to correspond with that. And we have this the speed that it's recording as well. So I think if you're sitting on that jury, unless somebody points that out to you, that may slip by you if you don't have that technical knowledge of mechanical knowledge of how these machines work. So once again, I don't know how much that's going to help the defense. I think this is a problem for the defense. To be quite honest with you, I think I see it in Karen Reed. She seems to be, she's not as joyful today as she has been in other testimonies, which goes back to what Laura said in the past, that she needs to watch how she reacts to this stuff. And I don't necessarily disagree with Laura on that one. But yes, I would say that the cell phone data on Jennifer McCabe's phone this morning and this trooper crash reconstruction expert, and probably some of the best witnesses the state's had that I've seen.
All right, Jarvis. I appreciate your patience.
You are unmuted.
A few things. So I'm going to send you home for the day because the lawyers and I are staying, and Trooper, I'm going to ask you to stay. Sometimes when we take these breaks, when I talk to the lawyers and then don't schedule you, it's because we have to do things in the case to facilitate getting this case to you now as efficiently as possible. Next week, we will be in session here Monday. Tuesday is going to be a full day of the lawyers and I with witnesses to make sure that the case is ready for you to wrap up. So Tuesday you will be off, we'll be working. Wednesday is a federal holiday, so court is not in session on Wednesday. We'll have a full day Thursday and half a day Friday. It's a little
What's the
different
federal holiday?
But I am assured that we are still on schedule to getting the case to you folks to begin your deliberations sometime that last week. Okay, so we appreciate everybody's patience. I appreciate the lawyers now really trying to work to get this case to you as efficiently as possible. So those cautions. Do not discuss this case with
It's the
anyone.
newest one, Joe. The newest one.
Research or investigation into this case. If you happen to see, hear, read anything about
So
this
there's like
case,
a gay day
disregard it and let us know.
federal
We'll
holiday?
see you on Monday. Monday will be a full day. Have a great weekend.
Juneteenth, gay day, whatever.
Oh, Juneteenth. Okay. Yeah, that makes sense.
You are muted.
Yeah, we've only been celebrating it for like, a year, so nobody really knows about it yet.
Actually, in Texas, they've celebrated that my whole life, kind of unofficially, but
I never even heard of it until last year.
yeah, it's in fact, I think it was specific for Texas. I think that's the day that Texas slaves in Texas were notified that they were free.
That's the story. Yeah, it's the last official. It's the last day that people were actually enslaved.
I'm hoping we're staying in session
Trooper,
for
we're
this. I
going
want
to
to hear
have
this.
a voir dire of you, sir. Mr. Lally's going to ask you some questions. Mr. Jackson's going to ask you some questions. You'll
Oh.
be shown a video. Okay.
This is going to be good.
All right, Mr. Lally.
Now, Trooper Paul, as I was asking you before, with respect to, have you had occasion to see a ring video from Mr. O'Keefe's house on One Meadows Avenue, depicting the defendant or the defendant's vehicle backing out of a garage while snow was falling?
Yes.
Now, in addition to that, as you've already testified to, you made observations of the defendant's vehicle in the Canton Police Department garage on February 1st. Is that correct?
Yes.
And Your Honor, with the court's permission, may we play the video at this time?
Yes.
Your Honor, to save time, I'll stipulate to the video.
I want to see it for purposes of this voir dire. And in fact, I'd like to see the version that the defendants have with the focusing in on the tire.
Understood.
Both. Go ahead, Ms. Gilman. You show yours, and then I'm going to ask for the defense.
153. Now, Trooper, from your observations from this video, at some point, this vehicle either comes close or makes contact with Mr. O'Keefe's vehicle. Is that correct?
Yes.
Now, in addition to your observations of this video and your observations of the defendant's vehicle, at some point, have you also seen photographs of Mr. O'Keefe's vehicle?
Yes.
And is your understanding that those photographs of Mr. O'Keefe's vehicle were taken by State Police Crime Scene Services on February 3rd? Is that correct?
Yes.
Now, with reference to your observations in this vehicle, what I'm going to ask you is in regard to the significance that you observe, significance of the impact between the two vehicles. In respect to Mr. O'Keefe's vehicle, what, if anything, did you observe on his vehicle at that time?
At the photos or now?
Right now.
Oh, right now. There was snow on the vehicle.
And then with respect to the contact between the defendant's vehicle and victim, Mr. O'Keefe's vehicle, what, if anything, did you observe to occur with relation to the snow based on the significance of the impact between the two?
The snow doesn't move.
And Ms. Gilman, if you could press play at this time.
All right. Can I see the other video? Please. Yes, I think it's on, I know it's in evidence, but I think it's on your computer, your hard drive. All right. Thank you. Okay, could you turn the lights on, please?
Your Honor, if I could, there's just two photographs that I'd like to
Sure.
purposes. Ms. Gilman, if I could have what's now been marked as Exhibit 549.
And before you do that, what is the exhibit we just saw through your IT person? What
Your Honor,
number?
it's the same exhibit. It has not been enhanced in any way. It was just magnified for purposes of this, of showing it. In other words, the magnification is not embedded in the video. It's
Okay.
the same video.
Okay.
We just magnified it.
Okay.
Here you go.
All right. Thank you. Go ahead, Mr. Lally.
And Trooper, do you recognize what's up on the screen now?
Yes.
And what are we looking at, and which area of the vehicle are we looking at?
It's the rear, sorry, John O'Keefe's car.
The driver's side, is that correct?
Yes.
And what, if any, relationship does this portion of the vehicle we're looking at here have in relation to the video that we just watched?
It was faced, well, kind of you see it
All right.
from.
What was the answer? I
It
didn't
was,
hear.
sorry, it was faced kind of the same way you see the back left rear corner of the vehicle as you do in this picture here.
And Ms. Gilman, if I could have what's now been marked as Exhibit 559. And sir, is this the same driver's side rear of Mr. O'Keefe's vehicle?
Yes, it is.
Now, as far as your observations of these photographs, what, if any, damage did you observe to Mr. O'Keefe's vehicle in either the last exhibit or this exhibit itself?
There was no damage.
Now, as far as the impact, let me ask, as far as the damage that you observed to the taillight area of the defendant's vehicle,
what, if any, opinion do you have as to the amount of force necessary in order to cause that damage?
Objection.
You need a foundation on this.
So,
I don't know that he can testify to
of
that.
I'm sorry, how many crashes have you investigated over your time with the cars unit?
I've been primary on 196 crashes.
And I know I'd asked you before about pedestrian crashes. Fair to say most of the remainder, if not all the remainder, involves vehicles colliding with other vehicles.
Correct.
Now, with respect to that experience in relation to vehicle crashes, what, if any, training or knowledge do you have in regard to sort of physical forces of vehicles in a collision sequence and what kind of damage you would anticipate?
So obviously, the higher the speed, the more damage. The lower speed, the less damage.
And what, if any, from the observation that you made in that video and the observations that you made of the defendant's vehicle, what you observed in the video, is that consistent with the damage that you observed to the defendant's vehicle?
Objection.
So I'm going to allow this for voir dire. I just need to hear this information.
Understood, Your Honor. Thank you.
It is not consistent with the tail light in this collision.
And why not?
For one thing, the collision, the tail light is, what I say, 42 to 50 inches off the ground. So that vehicle would have to have damage 42 to 50 inches off the ground.
Yes,
so they would have had to contact each other in the same distance from the ground, and there's no damage to that vehicle. So if the taillight breaks, it should leave some sort of scratching, maybe a dent, something on some sort of damage to that vehicle should have occurred.
And with respect to, I think you just answered it. So as far as Mr. O'Keefe's vehicle, what kind of damage would you expect from an impact significant enough?
This guy's ignoring what is.
It'd be probably higher speed than what we saw.
For purposes of the voir dire, I need to hear all of this. Go ahead.
A higher speed than what we probably would saw in there. If it's not, it was minimal. Maybe it would crack a tail light or something like that, but it wouldn't. I mean, the damage is different. And also, you know, we have a bumper that's also in the way too.
If everyone can imagine, if I were to back two vehicles together and put a pillow between the two tail light or the quarter panel, the metal to a tail light of another, keep applying
the bumper
pressure,
is, you know, it's basically
pressure
meant as
in the
another
pillow,
cushion
even with a
to
pillow in
absorb
between,
the impact
I would
to another
break
vehicle from
the
one
tail
vehicle
light
to another
man's gonna
vehicle.
give before the metal gives.
And it kind of sticks out to kind of also preserve whatever, you know, the tail lights and
Speed
everything
and
else
damage and,
on top of it.
collision impact. I don't think that's the case here, and I don't think that's what we observed on the video. I think we observed compression damage.
Responding and investigating collisions, specifically collisions between motor vehicles. The speed that you observed the defendant's vehicle.
I think the Massachusetts State Police has a propecia epidemic. This is not a haircut. That's just a bald head.
So if you look at the defense vehicle, there is a scratch mark that is along the left side of, starts from her bumper around the rear. That could be consistently with his hitting his bumper. That would be around the same height level. He has a like little ridge there on his bumper. So that bumper could have been hit that little ridge. And also the bumper in itself, and here is a different material. Hers is a little lighter, like a glossy colored paint. This is more a duller flat finish. So it might have some, why it would show up on her bumper more than it would show up on his bumper.
And finally, sir, in your opinion, the damage to the defendant's taillight is that something that could have occurred or could have been caused by the crash or the contact of the vehicles that you observed in that video?
Objection.
No.
So again, this is voir dire, Mr. Jackson, going in here.
No.
And again, sir, why not?
For a thing, the bumpers, you have to go push through the bumpers in order to hit the tail light against the other vehicle. And there's no damage to that, significant damage to a bumper in order to push back into the car.
And again, there was no snow on the vehicle. By that, I mean Mr. O'Keefe's vehicle that even came off the vehicle that you observed during the course of that contact between the two vehicles.
That's correct.
If the snow don't fall, she did it
Hey,
all.
Mr. Jackson?
Did you ever put the two cars together?
I did not.
No, you didn't, did you? You never tested whether or not the SUV would match up with the Traverse, did you?
What do you mean?
You just said, oh, look, one of them has matte finish, one of them has glossy finish, so it couldn't have happened, right?
No, I'm confused by the question. I'm talking about the tail light. We're talking about the tail light.
Yeah.
Are we talking about tail light? Are we talking about the bumper?
Yeah, we were talking about the tail light.
So one person at a time, you both are talking over each other.
You started talking about the bumpers.
Yes.
You said, well, one has matte finish and one has glossy finish, right?
Yes.
And you said, well, you'd expect one of them to like slide off of each other, and they could have done this and they could have done that, right?
Not slide off each other.
You were suggesting that the two cars wouldn't match up such that the taillight could make contact with any part of the traverse. That's what you were suggesting.
I'm saying it didn't match up because there's no damage to the traverse.
You didn't test whether or not the lens, the right rear lens on the SUV could match up to any part of the traverse, right? And make contact, physical contact with it, right?
When I see a picture of the traverse,
Yes or no?
when I see the picture of the
This is a
traverse,
voir dire. I need the information, Mr.
you asked me a
Jackson.
question.
Yeah,
I said when
yes or no question, Trooper.
I don't think so, but
Mr. Jackson, just for, there's no jury here.
I
This
realize
is,
that.
this is for purposes of what I have to rule on. The more information I
Calm
have,
down.
the better off I am in being able to rule on it.
Let me take a breath.
So this is you
What they're
trying to
doing,
get the
folks,
evidence out.
the
So
judge
if
is
you
going to
wanna give
decide
me
whether
the
this guy can make testimony
Did you
about
not ever do a test where you
the accident
matched
that's
the
observed on the
Lexus
video.
up against the Traverse?
we did not.
Did you or did you not ever do a test where you put the two cars together and measured them?
No.
Did you ever measure the taillight of the SUV, the black SUV, against any area on that Traverse?
No.
Did you ever do any force multiplier tests to determine the forces necessary to crack the SUV's convex taillight?
No.
Did you ever do any testing to determine whether or not a plastic taillight, under how much pressure a plastic taillight would need to be subjected
There you
before
go.
it would crack?
No.
Did you ever do any testing to determine whether or not if a plastic taillight came in contact with a metallic portion of another SUV, whether it would leave any mark?
Haven't done any tests, and I've seen crashes where headlights have struck other vehicles. That's kind of where the experience comes from.
Fair enough.
That experience is
But
not
those-
fair
I'm
here.
guessing that those crashes are probably different speeds and higher speeds. Not this, right?
I've had multiple crashes at different speeds.
So have you ever
So,
had
yes.
a crash where you've investigated, the Massachusetts State Police has been brought in to investigate a crash where the car was going in reverse at about a half a mile an hour?
Half a mile an hour?
Whatever that was.
Are you saying the SUV Lexus is going half a mile per hour?
Well,
I don't even think it was going that fast.
Give me an estimate of how fast you think that SUV was going at the point of contact with the Traverse.
Maybe like 1-2 miles per hour?
Okay, fair enough. Have you ever been called in to a crash, to investigate a crash, where the cars have collided at 1 mile an hour?
I've had pedestrian crashes that have been at a very low speed.
Okay, that wasn't my question. That wasn't quite my question.
Okay.
My question is, have you been called in to a crash involving two
The
vehicles
answer is no.
Yeah.
that have made contact at about a mile an hour?
I have seen testing for vehicles at low speeds. So next time I have been called to a crash, I go to fatality crashes, but I have seen testing for vehicles at low speed impacts,
Okay. How low speed?
like just the bump.
So like this?
Yes.
Did you see any damage?
Yes. All right. Well, minimal damage.
Right. In what circumstance? Minimal damage, like, I don't know, like a cracked taillight.
No, like just a little bit of rub off on the paint.
Right? Or you might see nothing, right?
Yes.
You've certainly seen circumstances in which two cars come in contact and there's absolutely no physical damage to either car, nothing observable, right?
Have I gone to
Sure.
crashes that have seen no physical damage on a car?
Or just in common sense, just everyday life, where one car backs into another car at the Jiffy Lube, makes contact and drives away, and there's no damage.
Not normally. It's usually something with car and car impacts.
Like, what's the something?
A crack or a paint, something chip, scratches.
Right.
Yeah.
So if you put a piece of metal in that scenario, if you put a piece of metal, steel, right,
Uh-huh.
against a piece of plastic, Which one do you think is going to give way first?
You'll still see some damage to both
Right, not
vehicles
question.
at a speed.
Which one would give way first?
Between metal, depends what speeds. And what we're talking about, you're just saying plastic and metal. You're giving a pretty general, broad plastic and metal
Trooper Paul,
analysis here.
you admit, you got to agree with me, that there are circumstances in which low speed, very, very low speed contact between two cars can certainly leave damage on one and not damage on the other, damage on both, or no damage on either one. Observe.
Yes, I just said in that situation where the scratch on the side of her car had a scratch mark and his doesn't appear to have anything.
And you said under questioning by Mr. Lally that certain circumstances like this could lead to a lens material, right, plastic material cracking, right?
Say again, like on least.
Just a few minutes ago, Mr. Lally.
I'm trying to answer your question. Sorry, yes.
Mr. Lally asked you a question a few minutes ago, and you indicated that something might show up on a bumper.
This is actually brilliant. This is why you pay money for an attorney. He's taking this opportunity to voir dire where the jury's not there to see what this guy's temperament is.
It might crack on a low speed impact?
Correct.
Yeah, it might crack.
Okay, now, Mr. Lally also said you saw this video where the cars come close to or make contact, right? That's how he worded the question. Remember that?
Come close. Yep.
Just as Dante says, oh, look, he turned into a prick when he gets disagreed.
I said it might. I don't know if that scratch from the side is. It's something that's consistent with the height of the bumper. Like I said, I didn't measure them from side by side, but you can clearly see there's a scratch on the side, and that's something that looks like that would come back. So as I look at the bumper, and I see the bumper, and it has that little divot, and I look at her side of her car with that scratch mark, that kind of lines up a little bit of why that could be where that was from.
I thought you said there was no damage on that car, on the Traverse.
There is no damage, and that's why I went to why there's this two different paint materials there. That why one could have showed up on her car because it's that flat, the glossy paint on there, and it could have scratched on it. While you have something that's a little more rougher texture with like a flat, flat color on there.
The checker at the grocery
wouldn't
store
leave
give
on
you a
there.
better assessment of this crash than this crash expert. He's doing horrible.
Contact. You don't see any observable damage on one, and you do on the other. That's what
I just, and I, yeah, I suggested that when you asked me that a second ago.
Yes. With regard to the video, let's get back to the question that I asked, which was, in that video, did the SUV come close to, or did it come in contact with the Traverse?
Again, I don't know because I'm saying based off the damage that is something consistent with that. So most likely it did come in contact with the bumper to bumper, but I don't know definitively because there is no damage to his car, but it's something that could explain why there's a scratch mark alongside the right rear side of his car, or her car.
Did you see the tire move, sir? Did you see the wheel on the Traverse move in that video?
No, I couldn't see the wheel move.
I beg your pardon?
I didn't see it move. If I did, I didn't observe it moving. If it moved, it moved. I didn't observe it moving. I wasn't looking at the wheel.
When was the first time you saw that video?
I don't really know. It's been a little while.
Well, I don't know what a little while means.
Like a year ago, I think.
I think the judge is going to rule that this guy cannot testify as an expert to analyze this accident on the video,
Your report, which is wherever it is.
which I think is the right decision.
I'm looking at your entire car's report. Did you put anything in this car's report about watching that video?
No, because I watched the video like after the report was done, and I watched it first time on court TV. So
who on court TV during this trial?
Like
Prior hearing.
No, when it was on TV at some point.
When did you and Mr. Lally have a discussion about you testifying about this video?
That was a couple weeks ago?
I'm sorry, I couldn't understand.
A couple of weeks ago?
What's a couple of weeks ago? Is it 10 days ago?
Days ago? 2 weeks ago? 2 weeks ago? A couple.
Here's an inside scoop.
Where did you two meet?
At the DA's office.
This come up and the state didn't think about this wheel moving and
It
being
was a pre-conference hearing, or pre-trial hearing.
Right.
So they're saying this guy's a crash reconstruction expert, so he's an expert on all crashes. We'll let him be our expert on.
We're talking over each other. I'm trying not to.
There could be no damage.
I'm trying not either.
Let's both try harder.
Okay.
Poorly done.
Who set up the meeting?
From my pre-trial.
Yes.
Okay.
Paul.
Adam Lally.
Who was at the meeting?
Everybody sitting right here. Lieutenant Tolley.
My mom. She goes to all my
Lieutenant Tolley,
meetings with me.
you, Adam Lally, Laura McLaughlin. I'm guessing Miss Gilman was not there.
She was not there. Correct.
Did Mr. Lally show you this video at that meeting?
Yes.
Did he tell you that he intended to ask you some questions about this video at that meeting?
Yes.
Did he ask you whether or not you could render an opinion as to whether or not the impact you saw or lack thereof, whatever the case may be, was consistent or inconsistent with damage to the taillight?
Yes.
Did you tell him that you would give him such opinion if called upon at trial?
Yes.
Did anybody take any notes?
I don't know.
Were you taking notes?
Yes.
Where are those notes, Trooper Paul?
I think I just, well, no, it's not on this specifically, but just, make sure I had, my everything checks and balances. And for what I want to talk about, what we're going to talk about.
Make sure you had
My
what?
checks and balances, sorry.
Checks and balances.
Just make sure I'm more on the same page of what we understand.
Getting beat up.
What's going on in the trial.
You want to make sure that you're on the same page with Mr. Lally.
And Dante, I would say AJ is absolutely going to cross him, and I think that break data will be forefront.
I have no idea.
I agree with you on that.
You were watching him. I mean, was he writing something down?
I also agree with you. It does look like the Chevy tail.
wasn't paying attention to his note taking.
Traverse
Was she taking notes?
lines up with the
I don't know.
tail light.
You didn't see her either?
I don't know if people were taking notes, writing stuff down, or what they're writing stuff down in relation to our little conference.
Did you give him an opinion? We've asked whether or not you were asked to give an opinion, and you said, yes, 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 I was.
Yep.
Did you give an opinion at that meeting about whether or not you believe, in your opinion, the contact between the SUV and the Traverse, the Lexus and the Traverse,
Range sums it
could
up well.
result in the damage
He's
to
done.
the taillight, in damage to the taillight?
Yes.
What did you tell him in the meeting?
What we talked about already in the stand here.
Okay. So what you related to him was exactly what you've relayed in this court.
Yes.
All right. And he asked you, he told you that he was going to ask, I'm going to ask you to look at the video, correct?
Yes.
You're going to be asked a series of questions about that video, correct?
He told me the video and he said, okay, this is the video. This is what they think the taillight was broken. And these are the pictures of his car that they take. So they asked my opinion on, do you think that's where a taillight would be broken?
And he said, and he told you, you need to make sure that you tell the jurors that couldn't have happened in this impact, right?
He didn't tell me that. Make sure jurors. I mean, that's my opinion on. It doesn't appear to happen in that video.
Did he tell you that it would be helpful to the prosecution if you said that it would be, that it was inconsistent with the taillight break?
Objection. Yeah, he lost me, Kingdom, when he didn't match
I'm
up
gonna
two
allow
vehicles
Did
and
he tell you it would
compensate
be
for the
helpful
angle of
to
approach
the case if you said that?
and determine the
No.
force it would take to
But
break
you knew
the
it
tail
would
light.
be, right?
This guy's
I'm just stating what I saw on my professional opinion on what it is.
professional
If it
crap.
looked like it was consistent, I would say it's consistent. If it wasn't consistent, it's not consistent. I'm not
sure
gonna.
I'm sure that's what you would say.
Okay, so comments are not appropriate for the jury. They're also not very good for me, Mr.
Understood.
Jackson.
Understood, Your Honor. Did you formalize your new opinion? Because this is a new opinion, right? You've never been asked this opinion before.
Yes.
Did you formalize this new opinion in any kind of report or memorialize it in any way?
No.
Did Mr. Lally ask you to create a report of some sort that you could then turn over to the defense so that we would know that you have a new opinion that you're going to testify about?
No.
Did you save those notes that you took about making sure that you were on the same page as Mr. Lally?
You don't have them with
I
me?
mean, yeah. I say
You have them
fine.
with you?
Where are they?
They're my report.
They're in your report?
Yeah, as I was writing a report, I just kind of highlighted stuff that I want to make sure I've memorized and remember my report.
Okay, I'm talking about notes specifically about this video, seeing this video and rendering a new opinion about this video.
No, I didn't have notes specifically about this video. I didn't write anything down saying I must do this on this video.
Did you write anything down about the new opinion that you had come up with related to this video?
No, I did not.
Yeah, good answer.
Yep.
You're about to have to haul that to court. This guy was coached, and you can tell during cross, Kingdom says.
Lally in
I
that
don't
meeting
disagree.
was that the car did not move and the snow did not move, correct?
Correct.
That's all I
If the snow don't
right.
fall,
Did you want to follow
he
up at all,
did
Mr.
it
Lally?
all.
No, thank you, Your Honor.
All right. So, Trooper, you are all set for today. We will see you Monday morning.
Thank you.
Okay.
He's going to be great on cross-examination. Alan Jackson's got his number. He's figured out where his button is. All that show he was doing wasn't for the jury. He was trying to see what this guy's reaction was, and he definitely got the reaction he wanted. I like it. He's like, yeah, I'm going to make you go home and ask Mama to hold you tighter in the fetal position. We're done on Monday, brother.
All right. So you're moving to exclude this. I'll hear you, Mr. Jackson.
Your Honor, it's very clear that this is a blatant discovery violation. Commonwealth has at least the obligation to provide us with any new opinions that any expert is going to testify to on direct examination. They've known about this witness for not months, for a year, for a couple of years. They've known exactly what this witness has memorialized in his official report. They knew that the only thing that we had was the official report. They met with him 2 weeks ago. This has become a pattern of conduct by the Commonwealth over and over and over. We're finding these witnesses getting on the stand, finding out that there's been a sort of preemptive strike in some sort of a prep interview where they're coming up with new opinions, new conclusions, new facts. It happened with Jennifer McCabe, this new fact about coming up, going to Michael Lank's house. It happened with Officer Sarah, coming up with a new determination about what was said or not said at the scene that we had never heard before. That was also a prep session of some sort, or I believe it was. And then this witness, literally, it's not even like just, was it light out or was it dark out? This is a completely new opinion based on evidence that we presented, both in or talked about in opening statement and have presented variously throughout this trial. And this officer gets on the stand and now has a new central opinion about whether or not we're right and that taillight lens could be cracked. That's something that should have at least been reduced to writing. And even if it was reduced to writing, it should have been excluded because it's a discovery violation. It's late. We don't have time to prepare for it, and we're caught off guard. I use the word at sidebar ambush, and I know that rankles the court, and the court doesn't like it, but that's exactly what it feels like.
Well, that's been used both ways here, right? So it's a word. Let's just take it out of here. Make your point. Okay.
I'll see if I can come up with a synonym for it.
No bad words.
I understand your argument. So focus on
No bad points or harsh language in my
whether
court.
I like ambush or don't like ambush. It's a word I've heard a lot of both sides.
I understand, Your Honor. My point is the evidence that now is being sought.
There you
should
go,
never
Big Ron.
be presented.
Range minded says, "State me harder, Daddy."
We didn't have opportunity to get this in advance. This has it's at least very.
That state's all up in there.
For weeks. He took notes about it. He now says, "Well, I didn't take notes about that specifically." I don't believe that.
No, it just doesn't have the same ring to it.
He did take notes about it. He was shown the video. He provided a new opinion. Mr. Lally knew that he was providing a new opinion, and then the first time he discloses this opinion is in front of the 16 jurors, 15 jurors. We would ask for its exclusion, Your Honor, and I'll submit.
All right, Mr. Lally.
How about on grounds the guy's not an expert?
Yes, Your Honor. As far as the pattern, especially coming from counsel, I simply find it laughable. As far as Officer Sarif, I think what counsel is referring to was testimony that was in his grand jury testimony. He was crossed about whether or not it was in his report, but it was in his grand jury testimony. As far as Ms. McCabe is concerned, that was regarding reciprocal discovery that was given to the Commonwealth weeks into trial by the defendant. It was then shown to a witness, which is perfectly permissible. Counsel asked a question of Ms. McCabe on cross, and she was aware of the material based on the late disclosure of reciprocal discovery. So there's no violation there. As it relates to, and why I say laughable, Your Honor, is that I am still...
I don't like hearing you say laughable. Just
Understood.
Stick to what the arguments are.
I'll
and
put
with
mean
the-
words in my
focus on-
courtroom.
Quit the finger pointing, name calling, things like that, please. I
Yes.
know it's been a long week. It's been a particularly long day, but just focus on what you want to argue to me.
And I apologize to the court for that, Your Honor. With respect to this testimony, it's well within his realm as a crash reconstructionist. This is a witness who's responded to and investigated hundreds of crashes involving damage to vehicles. Simply making an observation of contact between two vehicles or purported contact between two vehicles on a video. The force is self-evident, and whether or not that force is sufficient to cause the damage that he personally observed on the defendant's vehicle is well within his expertise. And should be permissible as far as for this witness to be able to testify to.
What about the non-disclosure to the defense? So showing this video and asking for an opinion, what about that?
So, Your Honor, what I would say is I did not show this video and ask this opinion. This is a video that actually the trooper mentioned to me that he had seen over the course of while the case was pending, probably over a year ago, that he had seen that video. What I showed him was the photographs of Mr. O'Keefe's vehicle and asked whether or not he observed any damage consistent with the damage to the taillight observing or popping up on Mr. O'Keefe's vehicle.
Why wasn't that turned over?
In hindsight, it should have been, Your Honor.
All right. So it's late. I'm not ruling here. I want to review everything. I would like, I'm not obviously taking any of the evidence home with me. I would like, if it's possible, for what your IT person did on the expanding, like he did this second time, maybe I missed it, but I didn't see the tire move this time. So I'd like that. I'd like that video, and I would like, what's the exhibit number here?
It's Exhibit 6. Do you want just that video, Your Honor?
And the pictures of the cars, whatever was shown during this voir dire, I would like those emailed to me so that I can look at them this weekend while I'm deciding, or put them on a flash drive right now.
That's what I'm making.
I'm sorry, I can't hear you.
We'll do a screen record and get it to the court by email. We can do that. I just need an hour once we get back to home base.
Okay. All right, Ms. Gilman, will you burn what you have for me before we leave somehow?
Your Honor, if I could, I just want to close one loop.
Okay.
What I was referring to with Ms. McCabe, I want to make sure that this is clear because this has come up a couple of times. The only thing I was referring to, or what I was referring to, it's not the only thing, but what I was referring to with Ms. McCabe is after Ms. McCabe testified, days and days and days after she testified and she was excused as a witness, then we got the report from Lieutenant Tully about the new information that she disclosed on the witness stand. In other words, she was cross-examined about it, etc. And then after she testified and was cross-examined and gone, then we got a report that predated her testimony that was in the possession of the Commonwealth, or at least in the possession of Lieutenant Tully. That's what I was talking about. I just want to make sure that that's clear. We don't need to go into it any further.
Did you want to add anything to that, Mr. Lally?
No.
All right. So I'll see you Monday morning.
All right.
All right. Make
You
sure
are
y'all stand up.
unmuted.
The judge is leaving the courtroom. Show that respect. Interesting day, I think. I want to go through some of these comments. We've got Dante, who brings up a good point. If the FBI are going to investigate the Massachusetts state troopers, there's going to be a lot of leaky balloon knots. I don't necessarily disagree with that either. Good way of put it. Kingdom, of course, says smoke and mirrors, smoke and mirrors. Everybody's lying. Our good friend James says, hope the department issues brown pants for those leaky knots. Here, this is a good one. Dante brings this up. We talk about damage assessments. This guy's not an insurance adjuster. He's a trooper. He is trained in analyzing and reconstructing automobile accidents, crash scenes, from like how fast a vehicle is going, what angle, looking for offenses, who's at fault. He's not there to determine the dollar amount of damage or the type of damage that could be seen in a vehicle, other than observational damage that honestly a tow truck driver, anybody else that responds, firemen that respond to scenes and see crashes, could make almost the same type of determination, which honestly we all could. I don't think he's an expert. I don't know that he's an expert that can make a determination of how much compression force, because that's what we're talking about. We're not talking about impact force. It's like, well, when two vehicles hit each other at rates of speeds, yes, when you have impact.
On the next episode of Accomplice to Murder.
This was a multi-generation.
When you have vehicles moving at velocity, you've got inertia. You've got a few things that are happening there. You've got the weight of the vehicles that are going to encounter each other. Inertia is going to take in things at rest have a tendency to stay at rest. Things in motion have a tendency to stay in motion. These two things are in motion. They don't want to come to a rest, so that energy is going to be absorbed between the two vehicles. So that's what this guy may have some expert testimony on, but I say he has no expert testimony on determining the value or to the extent of damage that you would have between two materials coming in contact with each other, which is called compression force. Compression force is that if I can take an aluminum can and I can hit it with a hammer and I can crush it, or I can put it in my hand without striking it whatsoever, and just with the compression of my hand, crunch the can. Are the two forces equal? No. But I say what we're seeing here with the tail light, if the tail light was damaged in the encounter between her vehicle and John O'Keefe's parked vehicle outside of her house that we see on the ring camera, that if there was any damage there at all, it had to occur with compression force, because those vehicles moved and made contact so very slowly that there was no traveling speed, there was no impact, there was contact. And that's where I say that is. I don't think this guy should be able to testify as to whether or not what he observed on the video is consistent with the damage that he sees on the tail light, and that's what the state is wanting this guy to say. But what do you guys say out there on the text stream? And Big Ron, what do you say?
Well, again, I haven't really swayed my decision on this too much. I think we've gotten a lot of good information out of it. I think a lot of it's rehearsed at this point. There's just, I don't know. It doesn't seem to be. None of it seems to be natural to me. It all seems to be coerced and rehearsed. I still don't think she did it. I don't think the car was damaged. We've already seen the video of the car driving in multiple directions with no white light coming off the tail light. He made a comment earlier in this feed about LED versus incandescent. I don't see that being a difference either way, because it wasn't a light. It wasn't a color change light. It would just be a white light. So, and in that kind of environment, that dark at that time of night, you'd be able to see in a camera a white light protruding from a tail light. It would have been extremely bright. So, and then the fact that we see that as she drove by, the taillight's not broke. We get to the police station, taillight's broke. We've got the issues with the timestamp being flipped and, not knowing about that. Now we're into the impact sensors on the bumpers, and the bumpers themselves have impact sensors. And we're talking about deformation of the frame. They're trying to overload the jury, in my mind, with information, where they're just going to say, oh, well, these people sound smart, and that's the direction they're going to go. And I'm not picking it up.
Well, let's go back to something that Dante has keyed up on early in the testimony of this trooper. And I don't disagree with him. It seems like the data that he portrayed on the Excel sheet stopped before it got to an application of the brakes. During this 10-second episode, there's the brake application, is 0, and they don't explain how the vehicle. Okay, it traveled at 24 miles an hour. Okay, I'll buy that. I'm with you on that. When did it come to a stop? Was it a hard brake? Was it I'm sure if you can tell me the percentage of brake pedal that's depressed, you can tell me the percentage of brake pedal that's depressed, whether it's a hard stop. And I don't see any of that. I think Dante's right. I think AJ is going to make this guy cry when he gets up on the witness stand, going into the legal tactics. I think on this voir dire, or they call it voir dire there, I think. But voir dire, which means to speak the truth, and it's not done in front of the jury. It's for a judge to make a decision as to whether something can be admissible or not. So it's just a kind of a questioning of especially like expert witnesses. Are you an expert? Tell me how you're an expert. Um, but going back to that, I think he took this opportunity to see how much it was going to take to get this guy's feathers ruffled, and it didn't take much at all. He got defensive very quickly, um, and honestly discombobulated. His answers didn't start to make sense once AJ had ruffled his feathers a little bit. So that's going to be super interesting to see. But going back to what back to the breaks, I think the state made a pretty good case today, both with the cell phone technology or the analyst, data analyst, and the and this expert up until he gets to no break information. I do want to know about that. That is, the more Dante says it, that it gets stuck in your head. Now I just have to know that before it makes sense to me. And I think Dante's the same way. I want to know where the break information is. That would help clean that up for me if he could explain that. But when he gets to this reverse impact that Karen Reed does, that's on video, he loses all credibility for me. Him attempting to make excuses to why that tail light's not cracked, when it's clearly obvious that there was contact between those two vehicles. That wheel absolutely moves. Snow doesn't fall. Don't care, but it absolutely did fall. Did move. There was contact between those vehicles, unless a ghost was behind there that pushed that vehicle forward as her vehicle got close to it. But she approached it at such a slow speed that I don't think this guy has any expert ability to be able to articulate what kind of damage you could expect from a compression fraction. It would, like I say, using the aluminum can in the hand versus aluminum can with the hammer, I can smash them with both, but one is done slow with compression, and I can just as effectively break or smash the can just like I could if I had the strength, I could go to the back of a vehicle and I could push in on the tail light to a point where the tail light's going to fail. I can apply enough pressure that way. And to me, that's what we're seeing there in the video, is that is a compression contact with compression. And I think it's very feasible that if the tail light reaches that little pointy spot like Dante speaks of, because he's correct, the angle of the vehicle looks like it's exactly what it does. The little pointy metal part sticking out on the corner of the quarter panel of the Traverse looks like it makes contact with the lens of the tail light. And if she just lets the vehicle roll a little bit forward, it's 3,000 or 4,000 pounds. You're going to get 3,000 or 4,000 pounds of force directly onto that tail light. It's the only point that has contact with the Traverse. So I think that what we see there very well could account for damage to the tail light. I don't think this guy's got a chance on the stand against AJ on cross-examination.
Oh, I'm so looking for him to take him down the Chattahoochee. I'm waiting for that one.
No, absolutely. I think that that's going to be a good one on Monday. Curious to see how the judge weighs in on this. AJ didn't really stand on the fact that I say this guy's. Well, he did mention it, that he's an accident investigator and reconstructionist, but no one calls as Dante said, nobody calls the police. Hey, I just tapped my neighbor's car. I need troopers out here to investigate when there's no apparent damage. Or even just a broken tail light. In the state of Texas, I don't know about the state of Massachusetts. In the state of Texas, if you say, hey, I've had an automobile accident, they're going to ask you, do you believe it's more than $1,200 worth of damage? And if it's not more than $1,200 of damage, they're going to tell you to fill out a crash report. You can get it online. They're not going to respond out there for less than $1,200 of damage. So you tell me in Massachusetts, this guy's going out with barely making contact vehicle incidents. That's absolutely not true. And AJ says, crushed every single trooper who looks solid under Lolly so far. Yeah, I can't argue that, because this guy did fall apart at the end. He started out pretty good. His data I like. I think that is something that it's rare to be disputed. But then again, Kingdom brings up an excellent point that they're supposedly in the wings. There's an FBI investigation, a paid analyst that investigated this accident, and they're going to come in and say that the injuries on the victim and the damage to the vehicle are not consistent with the state's story. So that would negate everything this guy said. Because I think that if you're sitting on the jury and you got the troopers versus the FBI, I think you're probably going to line towards the FBI because at least, they hadn't been up on the stand talking about this girl's balloon knot and how they hate her and they hate the attorney, which Proctor's is he's peed in the punch on that for the state side, I think. Rain says, I think the trooper's going to settle for a burger and a grape snow cone. A burger and a grape snow cone actually sounds pretty good. I'd go for that. But
That's such a great song.
That's a song?
Yeah, little ditty about Jack and Diane. American kid, done the best he can. Come on, really?
That's a little ditty? I thought that was John Cougar Mellencamp.
Is it?
Little ditty about Jack and Diane. That one?
See, I
I'm
knew
not
I could get you to sing.
No, I'm not going to sing it again. Well played. Well played. Well played. Dante says the FBI crash team says John's injuries are not consistent with a car impact. Not sure where that info comes from, though. And I'm not sure that's exactly what it says. I know that's what Turtle Boy said, but I'm just going to hold my comments on that. I want to see what they're able to bring in.
Didn't we talk about that earlier in the week too? About some of those entries, the way they looked, that they weren't consistent with a vehicle impact, but more of a bouncing down the stairs and being peed on by a dog.
We have talked about that, and I've said I'm not sure, but I do know that, and this trooper explained it actually not bad, that when you have a vehicle versus pedestrian impact, you've got essentially two blows. You've got the strike of the vehicle, which is one blow, and then they're gonna fly to the ground, or they're gonna leave that impact with such velocity that they will encounter another blow. That's going to be wherever they land, what they hit. They can hit, bounce, and roll to things. I will say my problem with that is that if he was hit with so much force that it threw him 12 feet, I really want to see some skid marks. There's going to be some lateral striation type of injuries either on his body or his clothing to indicate that he didn't just come to rest like a beanbag. When you throw it, it slid none at all. That body's going to move. Now I've had some pushback in some of the spaces with like, well, there was snow that could have lubricated it a little bit. I still think I would have seen some indication of movement that way. But let's also don't forget, this man wasn't dead until he got to the hospital some 4 or 5 hours after when the state says this happened. It is very possible that he was struck, thrown to the curb there. His back of his head takes that curb and puts the knuckle in the back of his head. And then he, on his own ability, crawls into the yard where he loses the ability to go any further. And that's where he lies and dies. So, I don't know that I'll be honest with you. I don't know that I can buy the fact that she struck him at 24 miles an hour and knocked a 205-pound man 12 feet, almost 90 degrees from the travel of the vehicle into a yard. It's more feasible to me that he was struck and most likely was able to work himself up to about 12 feet in that yard before he lost the ability to move any further. But that's about the best I can go on the state's case. They do leave a lot to be desired. In my opinion.
Yeah, I could see what you're saying there, Joe. With the weather conditions, I would expect there to be a lot more sliding of the vehicle and things of that sort.
Well, that's another thing that's in contention is what were the street levels? You had Higgins and there was two other people, I can't remember their names, that testified at that hour. Snow was starting to stick on like grass, but pavement and the streets were still wet. And I think we've all been in a snowy area that we've seen that condition before, where the streets are good to go, a little wet, the streets are good to go, but you don't have the snow hasn't built up there yet. And we've had testimony that says that. So I'm not sure that we're looking at 18 inches of snow. And let's go back to how much snow was falling. The snow had started to fall. They're right. It had started to snow somewhere around 12 o'clock when these guys are leaving the bar, deciding to go to this after party. It's starting to snow, but in the time from 12 to 6 when they did the measurement, or actually after 6 when they did the measurement, I think it was closer to 8 o'clock. They did the measurement of snow. It was only 2 inches that had accumulated, so it's not falling at such a crazy rate where you're going to get 3 or 4 inches in an hour. So I don't know how much snow's really coming into play on this. I've seen that with Kingdom. I've seen that with Dante. The comments about the snowy conditions could have let the tires spin, accounting for a 24 mile, appearing to be 24 mile an hour backwards, but not actually achieving that speed. Kingdom does say that there was snow on the streets with the library video. I have to go back and look at that. I just quite honestly don't remember. So I'm just not sure how much the snow has to play in this.
Yeah, that's a good point. I think I'd like to see that too. How much? I think that's the video we're talking about where the car drove by. We could see the tail lights to see they weren't completely busted out. There was no white light coming from the back end. I almost
Well,
want to
now
say
on that one, they're saying that at the point you could see that side is when the camera skips and that part's not actually seen. That's one
that
of the
is
complaints with
so
that library.
convenient.
It is.
It's
It is.
so convenient.
Higgins
Yeah.
did say he plowed the drive for a joke. Must have been snow there when he arrived, but I don't know if he was doing it as a joke. Is he kind of acted like he was plowing something that didn't need to be plowed? So I'm not sure about that. In the same testimony, though, Higgins did say that he's the one that said that snow was starting to stick on the grass in the yards at that point because it just began to snow, but it had not snowed enough and began to stick on the streets. The streets were still a wet, drivable condition, but no ice. So he had both in his testimony, Dante. I'm not sure which one to really go with. I think that guy's an ass clown in general. I don't know that I would trust him with much.
Is that your professional opinion?
That is my professional opinion. You can take that to the bank. I think Higgins has some. He has some credibility issues. Just I think as a person, I don't think just in this case. I think this guy, if you really were to know him, he'd be a person that I think you wouldn't trust overall. And I'll go back to him getting rid of his phone. This guy could have gotten rid of his phone because some other stupid shit that he's doing, and not what happened there that night. And honestly, so could Albert. Yes, it looks suspicious, and we don't know what was on their phones. But the absence of evidence is not evidence in a courtroom. So I really don't weigh it in. Other than I think both these guys are shaky, and I think they've had some other things going on. And it could be even much to Albert's got an affair going on. He didn't want it to get out. All that's in his phone. He didn't want all that to get out, so he gets rid of his phone to prevent that from happening. And Higgins could be, I don't know, Higgins could be doing his wife, Albert's wife, and he didn't want that to get out. So who knows? We know that Higgins is not above texting somebody else's long-term relationship or long-term partner or serious partner, and letting him know there might be some daylight over at my house.
Maybe the texting was between the two of them. That's who the affair was with.
Yeah, you know what? It could have been. But I'm saying, I mean, if you want to lay on the fact that they got rid of their phones because they had some dirty business to do with this murder, you can also go. They could have got rid of their phones for some other dirty business that they're doing. What is it? If they're doing other dodgy stuff, it leans more towards them doing a shady cover up. I don't disagree with you, Dante. I don't disagree with that necessarily, but in a criminal case, you got to prove it. You got to the state's got to prove their case. And when folks think I'm simping for the police or apologizing for the police, I make no there's no gray area where I stand. The state needs to prove its case, needs to prove its case beyond a reasonable doubt, and it needs to be a fair shake. I'm less concerned about a guilty man going free as I am about an innocent person being sent to prison. I'm more concerned about that. Guilty people, if you're out there doing stupid shit, you'll do some more stupid shit.
Well, I think it was can't remember which one of our founders said it, but it's better that 100 guilty people or 100 criminals go free than one innocent person spends a night in jail.
Now, that's a very similar quote. There are several of them out there. Actually, predates the founding of this nation. That should be a foundation in law. Is that when there's a tie, when it's not strong enough, then the accused get to go free. That we can't just like, well, let's just make sure and put him in jail because we're pretty sure he might have done it. That can't be. That's not justice.
No, and I think it's 100% right with what you're saying. You know, if they're out there doing shady stuff, going to get caught, they're going to do it again and get caught soon. I mean, we've seen in every police video that we've watched on all the shows we do on Friday night, which don't forget, folks, Friday night, and all the ones on TV, it's the same people getting caught because they're out there doing dumb stuff.
That's true. And if you're talking about a homicide, if the state doesn't push it, I'm trying to remember the woman who they're not sure how she killed her child, but she wrapped the child in duct tape. Come out of Florida. Who was this? Casey. Name's on the tip of my tongue.
Casey Anthony.
Casey Anthony. If the state had slowed their roll, they would have convicted that woman, but they didn't. They rushed it and they wanted the jury to draw an inference that we don't want a jury to draw. The jury should not have to draw any inferences. They should go off evidence that's presented to them. But they wanted the jury to go, well, since she wrapped the kid in duct tape, she must have killed it. But they couldn't determine the cause of death. I think if they'd slowed down, they could have let and waited for some other evidence to pop up, but they didn't. They rushed to trial, and that's what you get. And honestly, I'm not a fan of Casey Anthony. I think it's deplorable what happened to her child, whether the child died naturally in a drowning and she was scared, but the care that she took to her child after death is deplorable. But I say that was a good decision because the state did not prove the case. You can't allow that to happen. We can't get into a mode in this country where, well, the police said they did it, and this is what Kingdom likes to say because I guess a lot of folks think that, but it's actually the opposite. The police said they did it; they must have done it. That kind of leadway is really not given when juries start to make deliberations, and it shouldn't be. Is my point? It just absolutely shouldn't be. Dante brings up another good point. It shows their characters being the type of shady. Don't disagree, Dante, but once again, I just don't think a jury should have to draw the inference in there. And they could have we could go to the fact too is like it was perfectly normal that they get rid of phones every so often, and this is what they do. And it was just the time that they did it. They could make that argument as well. I don't know that them getting rid of their phones shows that they had anything to do with this murder. I personally think that they had some other shit going on their phones and they got rid of them. Some of that could have been the murder. I don't know that it's not. I just don't know that it is. And he also says the fact that it's such a shoddy investigation into an officer's death screams a lot as well. Already weird. Yeah, well, I can't argue that one either. Other than I just don't know if it's incompetence or if it's dirtiness. It's kind of like if I'm trying to think of an example of incompetence. I'm pulling on an object like a door and you're standing behind me and I let my hand slip and I hit you with my elbow. Is that incompetence because I'm being a dumb butt on how I'm pulling open the door? Or do I use the door as an opportunity to hit you in the mouth with my elbow? One would be an intentional criminal act. One would be, unintentional or negligent even, but not criminal. And that's when I say if you have incompetence, that's one thing. And both need to be handled. Incompetence needs to be handled, but it's got to be handled in a different way. If it's intentional, if they're intentionally framing this woman and they planted evidence for a shoe or the tail light or anything else there, every one of these dudes and women and anybody else that had anything to do with this case that got on the witness stand and lied, they need to spend the majority of the rest of their life in the penitentiary because we can't have that. That jeopardizes us as citizens. It doesn't jeopardize the state or democracy or any of that other stuff. It jeopardizes me like a Joe Lanu and a Big Ron and a Dante and a Kingdom out there. Because any one of us could get wrapped into a case, and by God, the state is what the state says, and we get the punishment that the state says. That's not what our justice system is all about, in my opinion. And he says all the times incompetence would be addressed, you would think an officer's death would be it. I just don't. I don't disagree with you again, my friend. I just don't know which one it is. And our friend brings up never attribute malice to what can be explained as incompetence. I agree with that as well. I think that's kind of like Occam's razor. That's the most reasonable, simplest answer to something. But folks, unless you got any more, Big Ron, I think we're going to close this up. I'm going to get ready for our night court police officer video review, use of force review video tonight. Dante, you should join us on X for this. I think you'll like it. But we'll also be broadcasting on YouTube as well. But you should join us tonight. It's 9 to 11 Eastern time. We'll have law enforcement use of force videos. We have a panel of law enforcement officers, attorneys, and civilians. Would also welcome you in if you want to join the civilian panel on that. But we take questions just like we're taking them here for the audience members to be able to pitch in their comments or have any questions. We have at least assorted folks of somewhat educated in the subject matter to be able to answer those. But it's a great show. We do it every Friday night. Hope you guys will join us for it tonight. That's the 11 o'clock on X. We'll stream it on X. I'm sorry, 9 o'clock Eastern on X. And we also stream it on our YouTube channels, just like we're streaming here today. And we look forward to Monday. We'll figure out what Aunt Bev is going to decide on this crackpot being able to make damage assessments on compression damage, which I think he should be denied the ability to do so. And we'll see what next week's trials bring. Thanks, folks. It's been a pleasure, and enjoy it. And appreciate you, Big Ron, for stepping in and helping me out today. And Kingdom, I know you're listening. Just going to know that you're an emotional little girl. I hope you get over that someday. We'll talk to you guys later.